All right, give me one more sec. I got to send one email. We'll get started. All right, Madam Court Reporter, are you ready? Great. Let's go on the record. In 2023 CV 378521, if I could have the appearances for, let's start with Plaintiff. That would be Entertainment Marketing Innovations.
Yes, Your Honor. Cameron Jackson on behalf of Jeremy Ladd and Entertainment Marketing Innovations.
That's Mr. Ladd.
This is Mr. Ladd, Your Honor.
Hey, Mr. Ladd. All right. And while you all were outside, I learned that Mr. Paskey and Mr. Briskin are here for Mr. Auda. And we don't have Mr. Bicknell, who's represented by Mr. Hypes. He's not late yet. We're going to get started. But if we get well past 10 and he doesn't show, I'm going to count that as a no-show. He got notice. He received notice that we were moving forward with. It's sort of cross TROs. I understand that plaintiff's TRO may not be entirely ripe yet. I'm not expecting defendants to have a full-throated legal argument on that because I don't think their brief is due yet or their response. But things are so interconnected. We'll really be talking about both sides of this same corporate coin. Write one more thing down. Okay, so let me explain what I understand we're doing today so that you don't have to cover the few things I did understand, and then you can cover the stuff that either I don't know yet or I misapprehended. I'm going to use the last names of the two individuals. I appreciate it's a corporate union that was created here to create, we called it HOMP in our brief as we were going through it, but the House of Music Productions was House of Music Entertainment and Entertainment Marketing Innovations coming together. It's easier for me to say LAD and Auda. Appreciate there are corporate entities and there are individuals, but LAD and Auda came together in 2019 to create House of Music Productions, 50-50, right down the middle. Things changed in July of 21 when Mr. Bicknell came into the picture. House of Music Productions bought his company, and Mr. Bicknell obtained or received 10% stake in House of Music Productions, which would dilute LAD and Auda to 45% each. We're probably going to have to talk about today what else Mr. Bicknell got, if anything. One view is he got a 10% stake, no voting rights. He's an equitable interest owner, but he didn't have a say in how things worked in terms of the corporate governance of House of Music Productions. And for a year, that seemed to work smoothly. And then on July 27th of last year, Mr. Auda sent to Mr. Ladd and Mr. Bicknell a text that is a little murky, but it sure sounds like Mr. Auda wants out or is getting out. I'm not returning to House of Music. Does that mean House of Music Productions? Does that mean House of Music Entertainment? I assume Productions because Mr. Auda is House of Music Entertainment. He's not abandoning his own company. Why would he say that to Mr. Ladd or Mr. Bicknell? And he wants his final check, and he's talking about how he'll be bought out, but he will continue to oversee the books. So it's not clear to me that I'm gone and everything is Mr. Ladd's responsibility. It's I'm ready to leave. We need to sort out how that's going to work, but I'm still in the mix. I'll oversee the books until we sort that out. About a month later, there was a meeting called by Mr. Auda, who supposedly wants out, and he and Mr. Bicknell decided that Mr. Ladd is out as manager and Mr. Bicknell is in. A little confusing if Mr. Bicknell didn't have any voting rights, how that would happen. And then there's allegedly some joinder agreement that Mr. Bicknell executed on that same day, August 23rd of last year. It's more complicated as we work through this because of Mr. Bicknell's semi-answer, semi-default that he may well have legally admitted a bunch of things that aren't particularly favorable to Mr. Auda's view of how corporate management worked from August 23rd onward. So we get to today. It's about a year later, not quite. And as I understand it, Mr. Ladd still controls the website and email and important aspects of House of Music Production. Mr. Auda, and maybe Mr. Bicknell, but clearly Mr. Auda controls the bank accounts. That's important, and lots of equipment. So it really is a situation where Ladd and Auda need to work together if the business, House of Music Production, is going to work. And it doesn't sound like they are playing well together. And so it's not working real well. Mr. Ladd says there's business out there that we'd like to do, but either my ability, Ladd's ability, or our ability, House of Music Production's ability to do that business is hampered in part because of, it's not my word, and it's not specifically the word of Mr. Ladd, but the shenanigans of Auda and Bicknell in making it difficult to enter into contracts. Allegedly, there's $500,000 of account receivable that aren't being collected. And sort of both sides aren't collaborating in the way they did for many years to make House of Music Productions successful. And it all seems to flow from the time when Mr. Auda said, I'm out, pretty much, except I'm going to continue to oversee the books. And then things got rough. What we're really here for is a motion for a TRO and a receiver that Team Auda has filed. And so that's what we need to work through. I don't know that a receiver makes a ton of sense, but I'll listen to both sides on that. And what I'm going to do, because Mr. Paskey, you're really the movement, so I'm going to let you start. And you can start by one saying, Judge, here's some things you misunderstood about what's going on. And then you can take it from there. I'd ask you to focus as you are making your argument for the TRO on what the irreparable harm would be here, because it sounds like what we've got is monetary losses and not the House of Music Entertainment its goodwill will be forever harmed. And how could Mr. Auda continue to do the kind of work he wants to do in the local marketplace? It's not the situation that a tree is going to fall on a house, that kind of thing. It seems more like a classic business dispute where there's a remedy in the end, and it's I sue you and you owe me a lot of money if I win. So we'll need to work through that really for both sides. Because it seems like monetary damages are where we'd end up if one side prevailed in the future litigation. So I did a lot of talking, but that was meant hopefully to save some time in terms of what you want to cover. And I promise you, Mr. Jackson, you'll have a chance to talk about this stuff as well and correct any misapprehension I have about what's going on.
Yes, sir. Just one quick question. Is the court hearing today our motion for TRO and interlocutory injunction, or are we saving that for another date?
Well, I'd love to cover as much as we can. They are interlocking because everyone is worried about some of the same things. I don't know, when did you file yours?
Last Thursday, I believe that was the 22nd.
Okay, so sort of along your argument of what's the emergency here, because things have been going along for a while. Yours isn't really an emergency TRO, and so last Thursday isn't 30 days away. So I will be receptive to Mr. Paskey saying, you know, we haven't had a chance to digest it all, but I will also push him a little bit to say, isn't it just the flip side? It's not in just the converse, but it is looking for some of the same relief, but in the other direction that he's seeking for his client. So my hope is that what comes out of today is direction to both sides about here's how we're going to move this forward. We may have to take a step back, set aside some animus and behave like professionals in terms of trying to maximize the profitability of House of Music Productions until the two sides can sort out, well, how do we buy Mr. Auda out? And he asked for that a year ago, and he may not have actively pursued it, but that's been on the table. And it sounds like until that happens, life isn't good for either side. So that's sort of my longer term view. But I don't think I can force the defendants to say, we're ready to respond to your TRO, but I can give them a little bit of a side eye and saying, how can you not be in a position to at least engage on it informally, given that it's not you didn't bring up something new. Hey, we just learned that Bicknell did X or Auda did Y. It's just a different form of relief. Okay. All right. When you're ready.
So, Your Honor, if I may stay seated, or
you may. And if you've got exhibits you want to share, you can share screens, all that kind of stuff.
Okay, Your Honor. So we made an announcement. I think that was 4 hours based on the court's clear understanding of the issues. I doubt we'll take that long. So I'll start with the first thing you mentioned is whether we're prepared to address their response. I think the court has hit the nail on the head. This is a great opportunity for the parties to get direction one way or the other. So we would love for the court to provide, I would love the opportunity to provide minimal legal briefing to address some of the things that were mentioned, such as Mr. Bicknell's default and how it would impact my client or in my position should not impact my client,
Sure.
things of that nature. But the facts, Your Honor, we're certainly prepared to address today.
Okay. So
So
it's pronounced Bicknell. That's how people say it.
I believe so, Your
Okay.
Honor.
Bicknell.
So today, Your Honor, there's a lot of legal issues, and I'll certainly address those in a minute. But really, there's three factual issues in my eyes. The first factual issue is whether or not Mario Auda resigned from his position as manager. The second issue is whether when, and this is one factual clarification I would make, Your Honor, is in conjunction with the purchase of the TRO of Mr. Bicknell's company, the company did not actually issue additional membership units. Instead, Auda and LAD agreed to issue 5% of what they had, and there's a transfer document reflecting that. So then the second question is whether or not that 10% that was transferred to Mr. Bicknell was an economic interest, as you said, Your Honor, or if it was just a regular membership interest. The third issue.
Before you go on to the third issue, is the distinction that if it was a regular membership issue, then Mr. Bicknell would have voting rights? Or
Yes.
That's the distinction between if it were an economic interest as opposed to a membership interest? And as I'm understanding Mr. Jackson's view, it was an economic interest. If House of Music Productions were worth $10 million, hey, he just got $1 million of that equity by basically ceding his company to House of Music Productions, and then he got that 10% stake.
Sure, Your Honor. The operating agreement does actually contemplate both, right?
Okay.
So it contemplates that if Section 12 of the operating agreement, Your Honor, provides that a transfer of a membership, you can only make any kind of transfer, membership or economic, with an approval of the majority members. So if there was a 55% saying yay, 45 saying nay, then you can transfer an interest, but it becomes, unless you have unanimous consent of the members, it becomes an economic interest. The only distinction, Your Honor, being voting rights.
Mm-hmm.
So here what we have is Mr. Ladd, who actually, the evidence will show that he actually drives this transaction, this 10% reduction in the purchase price in exchange for 10% equity. He signs a transfer document. He's fully on board. There's never any clarification, never any caveat in any of the emails back and forth between the parties suggesting that Mr. Bicknell is getting anything less than what Mr. Auda and Mr. Ladd have. And so our position is that from the beginning, the intent was that this was a membership agreement. And then after he gets voted out at the membership meeting, different arguments start coming up. First, it's that Mr. Ladd or Mr. Bicknell hasn't signed off on the operating agreement, so he can't be a member. So sign the joinder agreement. And then next, it's he hasn't made a capital contribution. Well, first of all, he purchased a membership interest, or he was assigned a membership interest that already had a capital contribution attributed to it. Second of all, his company gave a significant discount in the purchase price, so there was consideration. The other argument is somehow there wasn't an agreement among all the members to make this a membership interest. Well, that's just plainly contradicted by the transfer agreement that we will submit to the court as part of this hearing. So really, again, just going back to my summary, that's the second factual issue, and that's probably the largest one.
Okay.
Right? Because if the court finds that Mr. Bicknell has a voting interest, it frankly doesn't matter if Mr. Auda resigned or not, because we have two members who clearly desire after that resignation, if that's what it was. And I'll explain, Your Honor, further with Mr. Auda's testimony, what that was and what was prompting that correspondence. But really, if number two is resolved in the favor of Mr. Auda, that Mr. Bicknell does in fact have a voting interest, then the rest of these issues are really moot.
Well, I guess, but I thought factual issue number one is, did Mr. Auda resign as a manager? And if he did, then doesn't he have zero voting rights?
He resigned as manager. He's still a member. He still would have voting rights, and he could then vote his voting interest, and Mr. Bicknell could vote his voting interest to appoint him back as manager.
Okay. And so what would the impact of resigning as manager be? That seems like it is just saying some words, but it doesn't change anything. If he can still vote, then what does resigning as manager mean?
Sure, Your Honor. It's important if this court finds that Mr. Bicknell does not have a voting interest. Because if he does not, we have two members with a 45% interest. Neither one of them has a majority. In order to appoint a new manager, you need a majority of the shares. So he would be so then that would leave Mr. Ladd as the only manager, right? So that is the significance of whether he resigned or not is important if and only if this court finds that Mr. Bicknell does not have a voting interest.
Which is what you just said. All right, what's the third factual issue?
So the third factual issue is Mr. Ladd violating his fiduciary duties to the company by competing with the company through EMI? And as the court pointed out, we certainly need to make some additional legal showings in order to be granted an injunction. But I think the threshold issue is his activity, what is what he's doing wrong, right? So I think that would be the third factual issue for the court to determine.
Okay.
So with regard to those facts, the first, did Mr. Auda resign? Our position is, if you look at the correspondence, it doesn't say resign, but it does clearly, to your point, Your Honor, earlier, does clearly express a desire that he wants to be removed from the situation. So the way that the company is set up is that HOMP, I call it HOMP as well, Your Honor. So HOMP is receives services from both Mr. Auda and Mr. Ladd personally as project managers. Those services are billed, but there's no invoice, but they'll say it was 20 hours, and then the company will pay EMI or House of Music Entertainment for the relevant project. The testimony that Mr. Auda will provide, Your Honor, I believe will show that that message was born out of frustration in his duties as doing these project managers assignments. He felt like he was being micromanaged, he wasn't being supported in the way. And essentially you'll see at the end of the message, he says, send me my last check. I'm not coming back. What he's saying is, I'm not going to work for the company anymore. He's not saying I'm not an owner, I'm not a manager. And as Your Honor, as you pointed out, he says specifically, I'm still going to oversee the books. I'm still going to be involved in the management. What he's saying is, I'm not going to work. I'm not going to work for the company anymore.
Was he obligated under any of the terms of the operating agreement to work for the company? In other words, could he resign as a project manager without that also meaning he's resigning as a manager because he's now not contributing what's sort of the lifeblood of the organization?
Absolutely, Your Honor. You'll see in the operating agreement that this isn't a super customized operating agreement. There's certainly some interesting provisions. There's nothing in the operating agreement requiring either Ladd, EMI, either of the members or their principals to contribute a certain amount of time, energy, efforts. And so absolutely, he would have been permitted to resign, not work as a worker, right? And maintain his ownership and his management control over the company. There would be nothing in the operating agreement that would prevent him from doing that.
Okay.
So then after that, that same frustration that bears out that message, the micromanaging, the types of things that, not saying there's anything legally wrong, just as you said, two owners not getting along, that those same frustrations bear out the calling of the meeting to see if something can be done. Again, at the meeting, there's no, the arguments that are being presented before the court today about why Mr. Bicknell.
All three people were at the meeting. It wasn't a meeting, or at least Mr. Ladd was invited.
Mr. Ladd was invited and he was present.
Okay.
He did not enter the conference room to sit for the meeting, such that he wouldn't be on the minutes, but he was aware of it. He came with his attorney. They were present at the time of the meeting.
Okay.
The arguments that are being presented now as to why Mr. Bicknell didn't have a voting interest were not presented then. No objections were made. And in fact, I think the evidence will show that after that meeting, there was a little bit of an acceptance of what had happened. Somewhere along the way, obviously this lawsuit gets filed, that changed. But what I would suggest to you, Your Honor, is there's no requirement in the operating agreement for Mr. Bicknell to have a membership interest that has not been met. And so it is clear, absent an argument I haven't heard yet before, that there was never any clarification to Mr. Bicknell he wouldn't have a voting interest.
Were there voting moments during that year that he came on board in July 2021, and it's about a year later, it's a year and a month later, that there's this meeting where it sounds like the facts will show Mr. Ladd was there, but just right outside the room. Had there been any other instances when Mr. Bicknell would have voted but said, well, I can't vote, I just have a 10% economic stake? Was this the first time he was being called upon to vote?
This was the first meeting of the members. This was the first formal, but I think the evidence will show that the three of them would get together and make management decisions together.
Okay.
So with regard to the third factual issue, Your Honor, the LLC code specifically provides that
the what code?
the LLC, the Georgia Limited Liability Code specifically provides that self-interested transactions are barred except to the extent that they're shown to be entirely fair to the company, or they're approved by the disinterested members. Since this lawsuit has been filed, and perhaps slightly before it, the briefs will show that EMI has consistently conducted business that otherwise House of Music Production had done in previous years or would be willing to do.
I'm climbing a steep learning curve here. Didn't House of Music Productions rely on House of Music Entertainment and EMI to do lots of the work? So it almost was inherently self-dealing, but in an organic way that the two original partners expected, that a new client would come in and Mr. Ladd would say, great, I'll handle this part through EMI. And Mr. Auda would say, and I'll handle this part through House of Music Entertainment.
No, Your Honor. So what would happen is a client would come in, they'd sign a contract with House of Music Productions, HOMP. HOMP would provide all the labor and all of the equipment. And Mr. Ladd or Mr. Auda would project manage, and then they would keep track of their hours, and literally House of Music Production would pay them for their hours.
Right.
So there is no, the customer is never paying House of Music Entertainment in any situation. Once House of Music Production is formed, there's never a customer paying House of Music Entertainment. And then
Okay. So you're saying that if it's my event that needs AV services, I'm signing a contract with HOMP, and all the invoices to me are from HOMP, and that's who I'm paying. But doesn't EMI end up doing some of that work, and House of Music Entertainment does some? I guess what you're saying is maybe so, but it would be Ladd and Auda saying, I put in 52 hours doing whatever, and I may have been, if I'm Ladd, I may have been using EMI for my 52 hours, but the money flows from McBurney, the customer, the client, to HOMP, and then it goes to Ladd, and he could be paying EMI, he could be paying whomever with the money he gets for his 52 hours he worked on the project.
So I think, just to go back to the beginning of your statement, I think that the premise that it is Auda project or a Ladd project until this lawsuit was filed didn't exist. It was a HOMP project. In fact, Bicknell, part of the reason for that purchase is because of the customer base, right? Mr. Ladd was managing a lot of those accounts. It was just about who fits. It wasn't Ladd brought this account in and so it's his, right? We're working. And then secondly, what I would say is that to the extent that House of Music Entertainment and EMI are providing services, it is literally only the services, the hours of Ladd and the hours of Auda. That's it.
Well, let's say my event requires some giant projector. Is that projector something that Mr. Auda brought into the happy corporate relationship because House of Music Entertainment has a bunch of projectors?
So the evidence will show, and there'll be, email correspondence to this effect at the time, that when they formed House of Music Production, they were both active running companies. They took their assets and contributed them to House of Music Production. So to the extent that House of Music Entertainment had that projector, it is now House of Music Productions equipment. And if House of Music Productions doesn't have that, they would cross rent it from another vendor, and it would still go through House of Music Productions.
But that vendor wouldn't be EMI or House of Music Entertainment if they had to rent something that HOMP did not have.
Correct.
It would be a third party, not a corporate entity currently or formerly associated with LAD or Auda.
Correct. There won't be situations where House of Music Entertainment is renting equipment to House of Music Production, or the inverse. EMI is saying, to the extent that EMI had equipment that wasn't HOPS, there would be no charge for it if they did that. I haven't seen any invoices to that effect.
Okay. Were House of Music Entertainment and EMI competitors? In other words, they occupied the same space, or it was a synergistic consolidation because EMI had lights and House of Music Entertainment, we don't have lights, we just have speakers. Perfect. Now we've got lights and speakers.
I'm very confident that it's a mix of both, Your Honor. I will elicit that testimony when the time comes, because I can't say with 100% certainty, but my understanding is they're competitors, but they wouldn't have come together if there wasn't some synergy there, right? So what's happening now, since the filing of the lawsuit, Your Honor, is projects that have historically been House of Music Productions are now, and in fact, there's estimates in the House of Music Production system where Mr. Ladd went through and prepared it as an estimate, as if House of Music Production was going to do it and I'll use the Masters houses. So there's parties along, at the Masters event in Augusta. They have needs for stage lighting, and House of Music Productions done these houses for the last couple of years. Well, this year, House of Music Productions prepares some estimates for 5 houses. They're about $65,000. And then after the events occur, all of a sudden, those are not in the system anymore. And instead, there's an invoice where EMI is going to pay House of Music Productions $15,000, maybe $18,000, I think. $18,000 for that same stuff. House of Music Productions still did all the same stuff, but now it's a subcontractor of EMI's, and presumably we'll find out when the time for testimony comes, EMI retained the profit from that job. And to me, it's wrong no matter what, but especially if you have an active lawsuit saying that you are the sole manager of a company, that you would misappropriate the company's opportunities like that. And the court asked me to address at the beginning, like, why is this not just, money damages aren't irreparable, right? We can always get a judgment at the end. The reality is that we believe that there's a desire to separate, and these customer relationships that are now moving over to EMI may never come back after we separate. And so it's not what's already been done. What's been done has been done. So what we're asking for is a simple injunction saying, stop contracting between EMI and House of Music Productions without getting everybody's approval. And the reason for that is, first of all, that should cause no harm to EMI. And the reason for that is to preserve House of Music Productions customer base. Once these customers fall in, and House of Music Productions had the benefit of this, you see year over year, they're doing the same events every year. So that would be my response, Your Honor, as to why this could cause irreparable harm, is because we may never get those customers back. I guess, Your Honor, hopefully in that open, I know it wasn't very organized, but hopefully I addressed, the main points. Certainly let me get to the last one, actually, the receiver. So the court said, you didn't feel that this was an appropriate receiver situation. And I agree, except in one contingency. So if the court finds that Mr. Bicknell can vote, then we don't have an issue. We're good. We know who's running the company.
do we know where Mr. Bicknell is? I don't mean like today, where is he? But let's say that based on all that you both sides share with me, I conclude that he obtained a membership interest. I don't know that I'm really ruling on that. That's a declaratory judgment that the parties want, and that's not what's before me. But let's say that I indicate I'm trending in that direction. Is he in the United States? Is he a fugitive? I don't mean that in the sense of, boy, he's in trouble, but
Sure.
so Bicknell can vote. If he is AWOL, I guess it would mean that the transfer of what happened on August 23rd would be valid, because he was able to vote on August 23rd of last year. Whether he can vote now may be moot if he has ridden off into the sunset.
Yes, Your Honor, that point, that the August meeting will have been, the action will have been deemed valid, but separately, he's actively involved in the business. For whatever strategic reason, they've decided, not maybe attorney's fees, I mean, that's speculation. They've decided for whatever strategic reason to take this. He's actively involved in the business. He's around.
All right.
So if the court finds that way, if the court indicates, I certainly am not going to, issue an interlocutory ruling saying, that he can't vote, or if the court just signals that, we believe this is a membership interest, then we know who's running the company. We know it's Bicknell and Auda together are the managers, and they're running the company. And then it would be a simple matter of transferring over control of the remaining email accounts and things of that nature. We wouldn't need a receiver in that situation. Likewise, if the court finds that Mr. Auda resigned from his role as manager and Mr. Bicknell doesn't have a voting interest, then we know who's running the company. And all we would ask for is some safeguards in place to prevent the self-dealing. The situation in which a receiver would be appropriate is if the court finds that Bicknell cannot vote, but that Mr. Auda did not resign, and now we have 50-50 managers who do not get along at all. And I would propose a limited receiver, not somebody who, these guys can run the business, that's been shown. What we need is somebody to have control over things so that there's not the manipulations and
impasses and whatnot. Okay.
Yes, Your Honor.
So it's not the traditional receiver who's coming in with an accountant and this and that, and might not intentionally, but just fiscally bleed the company dry, because it takes a while to wrap your arms around the books and understand what's going on. And there's a 10,000 bill, there's another 10,000 bill. And that would seem to, when I was pushing back a little bit, it was not being aware of the notion of almost an administrative receiver as opposed to a financial receiver.
Yeah, it's just literally somebody to have control of the accounts, right? And Your Honor, like in the cost thing is serious. And we discussed this with Mr. Auda is, on one hand, the company's not doing well, and maybe we believe it's because of Mr. Ladd's actions, and certainly Mr. Ladd believes it's because of Mr. Auda's actions. But if the company's not doing well, then you don't have money for a receiver.
Right.
So the reason to move for a receiver despite that fact is, I honestly believe if with a neutral adult in the room, that the company will do better, and it will actually be an investment to have a receiver here. But again, only in that situation where the court finds that Mr. Auda has not resigned from his manager position and Mr. Bicknell does not have a vote. So as long as the court doesn't find both of those two things, I would agree we could avoid a receiver. With that, Your Honor, I think we'd be prepared to present evidence, but that would be it for my opening.
Okay. Mr. Jackson, I'll hear from you in one moment. I just got to write something down. All right, so Mr. Jackson, you patiently listened to a whole lot. This isn't meant for you to get up and say, let me tell you all the ways in which Paskey was wrong. And there may be many in your mind. I just would like your view on sort of what we're gonna cover today, and you may think there are 2 factual issues or 4 factual issues, but it will help me before I start receiving evidence to get the EMI perspective on things.
Perfect. Yes, Your Honor. So I'll start by kind of addressing opposing counsel's opening statements, especially given we're kind of talking about our injunction motion, but kind of saving it for another date kind of aspects. We won't go into full detail there. To address the first part, whether or not Auda resigned, it appears that it's really getting caught up on the I'll continue to manage the books aspect, but that's plain and simple, putting in a 2 weeks notice. Hey, I resigned as a condition of my resignation. I'll still oversee the books until you find somebody to replace me. Nearly every resignation on the face of the earth has a 2 week, notice provision to it. To the extent he's discussing what is the nature of the 10% interest that was transferred, we've gone through discovery with them, the first round of it. They haven't produced any document whatsoever showing one way or the other, whether that's an economic interest ownership or a membership ownership provision. And on top of that, I know they say, and this is probably more of a motion for summary judgment type argument, but they state that, they state that the operating agreement says this would automatically grant him voting memberships. Well, the operating agreement expressly contemplates this situation and states that, X, Y, and Z have to be done for voting rights. You can have a membership without having voting rights, and your membership percentage can be different from your voting rights percentage. And it is expressly put in there, capital contributions your capital contribution divided by the aggregate capital contribution. Mr. Becknell has never made a capital contribution. He admitted that basically when he defaulted on everything in our complaint except for the attorney's fees aspects of it, which I'll point out despite continuing his actions, isn't even here today. So, and further, they keep pointing to OCGA 1411-307, which they keep leaving out is reasonable under the circumstances. The circumstances will show, because of Mr. Auda's and Mr. Bicknell's actions, these were all done to protect house and music productions. There was no self-dealing. And in fact, in one of them, EMI took a $12,000 loss, or picking a number, I think it's $12,000 loss. That doesn't seem like a self-interested transaction. Selfless, if anything.
Let me go back to the 2 weeks notice argument you're making. Is there anything I'm going to hear that shows that Mr. Auda stopped serving as the overseer of the books at 2 weeks and 1 day? In other words, hey guys, I gave you my 2 weeks notice. You didn't seem to take it seriously, but I've resigned. I mean, he doesn't use the word resign.
No, Your Honor. So the 2 weeks was just kind of, it could be 4 weeks, different positions have different things. The fact of the matter is less than a month later, he starts holding these votes, which we contest the validity of through and through. And at that point, the resignation didn't become the issue, the lawsuit became the issue.
Will the evidence show, do you think that Mr. Ladd meaningfully engaged with Mr. Auda after that text from July 27th to say, well, all right, how are we going to buy you out? We got to do something because clearly you want to resign? Or did Mr. Ladd sort of shrug it off and say, it's business as usual? I mean, we're still partners in this and appreciate you want out, but that it's kind of hard to blow up a 50-50. I guess by then it was 45-45-10 business. It is really Ladd and Auda. And if I don't know what out means, if you get out.
Yes, Your Honor, it will, and we'll save it for Mr. Ladd's testimony. But yes, a term sheet was put together. It did not get to be delivered because about the time it got finalized and all the funding came in to be able to buy them, that August meeting occurred, and then all bets were off because the company was starting to chaos.
Okay. All right. Anything else you want to share before we start getting some witnesses?
Yes, Your Honor. Finally, just kind of touching on, these allegations of self-dealing and bad faith. The statute does not control. even if you look at the back of the operating agreement, and we'll get to that in testimony, I believe it's section 1515. Anything not expressly addressed in the operating agreement is controlled by at the sole discretion of the managers. At all times anything was happening, Mr. Ladd was the sole manager. And so it's completely permissible as discretion. Now, taking that for side, let's assume arguendo that the statute does control. Every single one of them was in good faith, given the circumstances of the situation, and was done in the best interest of House Music Productions.
All right.
And then finally, to the extent that, if we find that that message was a resignation from Mr. Auda and he's now acting as manager, well, this is, depends on voting, whether, how important of an issue this is. He's never been reinstated, even if it is with Mr. Bicknell's voting. No vote has ever happened to reinstate him.
So you don't think that whatever vote happened on August 23rd was to reinstate, it was to remove your client and put Mr. Bicknell in that spot?
Yeah, so it was, and there's evidence that they submitted to the court as one of their exhibits. It is the notice of the meeting, one of the topics to be discussed at the meeting. I can tell you exactly which one of it was. Give me 1 second. Exhibit 9 that defendants submitted expressly states what the purpose of that meeting was. It was to remove Mr. Ladd, to add Mr. Bicknell, and to just generally discuss happenings within the company, which I think say generally discussing happenings within the company, I don't think requires a quorum. It's not really a vote as much as a conversation. But the first two certainly require a quorum, which was not met at that meeting.
Okay.
And Mr. Ladd was at that meeting. He did object to Mr. Bicknell voting. That was the first time Mr. Bicknell the issue of him voting as a member ever came up. So it's not like Mr. Bicknell was voting before and then this happened. And he was objecting at the meeting. He objected to the joinder agreement. He objected through and through. So this is not a change of position on Mr. Ladd's part.
Give me 1 second. What would the folder be that has exhibits in it?
It should be in the-
But would it be entertainment? I don't have any E's. It goes from DURSO to F7 NWO. Are you in the staff attorney directory? Weird. Let me try again.
Your Honor, I may be able to share my screen with the notice, if that's helpful.
But you'll be able to share in a sec. I'm just trying to figure out why. All right, let me try again. Now it is. I just reopened it. Okay, we're good. All right, what exhibit did you say? Exhibit 9. Yeah. The notice of meeting. Okay. Okay. All right, anything else before we get to witnesses?
Yes, Your Honor, just two little quick things that kind of interrelated. On top of everything, on their own, I guess statements through discovery responses and our clients' testimonial show, Mr. Ladd hasn't been paid by House of Music Productions since February of 26. And to the extent that, any of these he could possibly owe duty, it's absolved by the fact that he hasn't been paid.
Hasn't been paid since when?
February 26th of 2023.
Of this year?
Yes, and we're not sure, that's whether to drain the snake or drain the, coffers so he can't afford legal fees, but we brought this up with their side several times and they just kind of brush over it. We'll have a payment ledger presented through, provided us with their discovery responses to show that Mr. Ladd hasn't been paid. Mr. Auda is the only person the company can authorize it and is refusing to authorize it.
So would the refusal to pay coincide with what I heard about where EMI was invoicing House of Music Productions? And is there sort of a correspondence there that once that process started happening, that's when Mr. Ladd wasn't being paid?
No, Your Honor, it happened before that. And to kind of clarify the point they were saying, they made it seem like there is one workflow of client, but in reality, both House of Music Entertainment and EMI have their legacy clients that are not House of Music Production clients. They're simply their own clients. Now, House of Music House of Music Entertainment and EMI both utilize their investment in House of Music Productions for a twofold reason. One, to get better margins on their deals, and then two, to help provide cash flow and revenue into House of Music Productions. So there are certain clients that have never been a House of Music Production client that that EMI will do theirs, House of Music will do theirs, and they'll just subcontract through House of Music Productions, and that is completely within the normal course of business.
That sounds like a very different answer than I got from Mr. Paskey. Give me an example. I don't mean it was Fred Smith, but so I have a fancy house in Augusta and I want there to be some nice production there. And that was a EMI client from way back. We've been doing this since the 1990s. I've always worked with Mr. Ladd. It would now go through House of Music Productions, or I don't understand this subsidizing. And
it's kind of like in a construction context, a general contractor, subcontractor situation. So EMI, it's a traditional client. They would get the contract, they would manage the contract, and they would leverage House of Music Production for mainly gear rentals, sometimes labor services. They would sometimes use the truck systems to transport gear back and forth as just their subcontractor.
Okay, so I, as the client, would have entered into a contract with EMI in this scenario.
Correct.
And so any invoice I get comes from EMI. I may never hear of House of Music Productions because I've always known Mr. Ladd. He talks too much. I don't care about his different ventures. I just know it's Ladd, EMI, that's it. I don't need to hear about Hump. But what you're saying is, as Mr. Ladd and his EMI team are putting together what they need to take care of what I've contracted them to do, the EMI team might use House of Music Production equipment. Oh, you know what? They need a reverse stabilizer, and we don't have any of those, but Hump does. So how does that work? Does Mr. Ladd just say, well, I'm Hump, so I'm going to grab that out of the warehouse? Or like you said, subcontractor, EMI calls up Hump, which I guess would be Mr. Ladd calling himself or calling Mr. Auda saying, I need the reverse stabilizers for this EMI gig that we're doing. And here's the $1,000 you get anytime someone uses a Hump reverse stabilizer. Walk me through the transaction.
Yes. So the client, whatever the legacy client of EMI is, would come to them, hire them, say, I don't care how you do the job, I just want the job to get done.
Yep.
EMI then, let's say the situation, they're using House of Music Productions for gear rentals because let's say EMI only has light rigs, but they don't have stage. They would rent it just rent the stage from House of Music Productions to EMI. They would pay. There is a insider discount that both parties have been freely enjoying. They would get that stage, EMI would put on the performance, EMI would get paid by the client, EMI would pay the subcontractor.
Okay, which would happen to be Hump.
Yes.
And you're saying that Mr. Auda and House of Music Entertainment enjoyed that same ability. There's some legacy clients, they're servicing that client and they need a stage. And they don't have one, meaning House of Music Entertainment doesn't have one. I know a way to get one that's going to make my bid continue to be attractive to my legacy client, because I can get the stage at this discount in the same way that EMI could get the stage at a discount. House of Music Entertainment gets paid by McBurney and then they pay their sub.
Yes, Your Honor.
Okay,
And
two-way street.
yeah, and it even goes farther than that. There's situations, and we'll have the exhibits to show, and we're not saying there's any wrongdoing. This is normal course of dealing. Mr. Auda is giving himself 100% discounts on things. And in fact, there's other ones where complete third parties are getting discounts too, because the nature of the business and the nature of the industry is, if you want to survive, you have to get business to business discounts.
Okay. All right. Thank you. Mr. Paskey, why don't you call your first witness?
Okay, Your Honor, I'd like to call Mario Auda.
All right, Mr. Auda, if you'll come on up to the witness stand.
We do affirm that testimony will be the truth, the whole truth, and nothing but the truth, so help God. I do. Lawyer in LLC, state and spell your name for the record. My name is Mario Auda.
Got to spell that last name.
AUDA.
Mr. Auda, when did you first meet Jeremy Ladd?
I first met Jeremy Ladd in the late 1990s.
Okay, and how did you do it?
We met through, I think it was our Star 94 DJ gigs that we had.
Okay, were you guys involved in the same industry?
Yes.
Okay, what industry are you involved in?
We're involved, well, we were involved in the DJ industry and we turned that into a production company later on.
Okay, tell me or explain to the court, what does a production company provide?
Our production company provides live production, which is staging, lighting, sound, video.
Okay. At some point, did you and Mr. Ladd go into business together?
Yes,
And you formed House of Music Productions?
yes,
When was that?
in 2019.
When you formed House of Music Productions, before you formed House of Music Productions, did you have an active productions company?
Yes,
What was it called?
House of Music Entertainment.
Okay, how about Mr. Ladd? Did he have an active production company?
No, he had a DJ company.
Okay. So would you have considered yourselves competitors?
Not really, because House of Music did all the production and we allowed Jeremy to do his DJ services on the side through EMI.
Okay. So this is before you formed House of Music Productions. Give me the thought process behind joining forces.
We joined forces because we were good partners. We both knew the production world really well. And we were both DJs. That's how we met. And being that we put the company together, it was a good joint. He had some equipment. I had some equipment.
Did you have different kinds of equipment?
Some similar, but yes.
All right. When you formed House of Music Production, what capital contributions did you or your company make?
Well, I brought in all the equipment that House of Music Entertainment owned.
Okay, what about your accounts?
Every single one of the accounts from House of Music Entertainment went to House of Music Productions.
Okay, what about EMI? What did they contribute?
We contributed a very little bit of gear, production gear. There was a few lights. I think that's about all he had.
Mr. Auda, I heard Mr. Jackson talk about legacy clients as he was giving me an example of how it might be that EMI or House of Music Entertainment would do business with House of Music Productions. I just heard you say your capital contribution, your contribution to House of Music production was number one, all of House of Music Entertainment's equipment. You didn't hold back any speakers or stages.
The only thing that we had agreed upon to hold back was our personal DJ gear. I own two Technique 1200s, which are turntables, and he owned a couple of pieces of DJ gear. And I think he owned two speakers that was his to begin with. So we let him keep that to do his DJ work with.
Sure.
That's it.
Okay. So when I say all, everything but your personal turntables,
That is correct.
more importantly, you said all your accounts. So were there any House of Music Entertainment accounts that did not get folded into House of Music Productions?
Absolutely not. Matter of fact, there have been no transactions through House of Music Entertainment with any clients whatsoever. The only time House of Music Entertainment has been paid was for the work that I did for House of Music Productions.
Okay. And that just was the way you got paid, was through House of Music Entertainment? In other words, if House of Music Production said, we owe Mr. Auda $50,000 for this last project, the check or the direct deposit or the transfer actually went to House of Music Entertainment and not to Mario Auda?
That is correct.
Okay. So there aren't events that House of Music Entertainment used to do that you still do as House of Music Entertainment. If there are things that House of Music Entertainment used to do, they're now through HOMP.
House of Music Entertainment has not done a single job since 2019, since we formed House of Music Productions.
Okay.
Okay, Mr. Auda, thanks for that clarification. Is there any situation in which you personally, not House of Music Entertainment, would rent or take equipment from House of Music Productions?
There have been times where personally we have events at our house. When I say events, more like a party. And I've used a speaker for my party for personal reasons. No money was involved, no transactions were involved. Matter of fact, they were approved by Mr. Ladd himself.
Okay, so you would have a party at your house, you would rent out, and maybe at no charge, you would rent out equipment at House of Music
I
Productions.
borrowed a speaker.
Okay. Any other circumstances in which you or House of Music Entertainment would take equipment from House of Music Productions?
No, it came to my attention that there's an invoice in the docket for 2 Lecos.
What's a Lico?
Leco is a light that we use to project images on walls with, or we also use the light to light up a podium.
I think you're referring to the invoice that was attached to the plaintiff's motion for TRO. Do you know what that rental or what that Lico light was for?
I do not know exactly what that Leco light was for. I've tried to remember what it was for. And at the time, I was at the Masters in 2022, working the event for George Bush. I can only assume that last minute, we possibly needed 2 Lecos to light up Mr. George Bush, President George Bush. I don't know what they were for, but I can assure you that I never used it for personal monetary use or contributed towards House of Music Entertainment.
So you, House of Music Entertainment or Mario Auda have never, since House of Music Productions was formed, have never profited from the use of House of Music Production equipment.
That is correct.
Until this lawsuit was filed, was there any circumstance under which Mr. Ladd would be permitted to operate a competitive event or to use House of Music Productions equipment?
All productions were done through House of Music Productions. The only thing Jeremy was allowed to do, to my knowledge, at the time, was to do his DJ services where he does trivia twice a week. And sometimes he did karaoke.
Okay, did he use House of Music Production equipment to do that?
No, sir.
Okay,
He may have used a mixing board to do it, but that's about it.
okay.
And that would be House of Music production equipment?
That is correct.
Okay,
Well, just the mixing board, everything else he owned.
right, but that mixing board wouldn't have been, like you mentioned, you kept 2 turntables, and Mr. Ladd kept a few things per agreement. But that mixing board you're describing, that would have involved Mr. Ladd dipping into House of Music Productions store of equipment, saying, I'm gonna use that for trivia night at this bar.
No, he would not use it for trivia night. The only time he would use it was for karaoke. And most of the time, those karaoke's were booked through House of Music Productions.
Oh, okay.
Okay. So in the event that he did these events, the karaoke or the trivia, that was with your permission, correct?
I don't believe he needed my permission for that, but yes, I approved of it.
Okay. And would House of Music Production have done those events if EMI wasn't doing them?
No,
Okay. So they're not really the type of event that House of Music Productions would do.
that is correct.
Is it, just to keep it simple so I understand, the kinds of things Mr. Ladd would do on the side were sort of audio only events, and House of Music Production is AV. And so being the DJ, or doing karaoke, one, he's done that historically. 2, 99% of the equipment was his own. He might borrow a mixing board for karaoke, but it's just not a space in which House of Music Productions would be active because it's small scale and it is largely monodimensional, meaning audio only.
I would almost describe it more as services only versus audio only, because trivia is a service. And so were some DJs. He DJ'd certain things on his own. And that was also because we did not pay ourselves for the first year, 2019, for the work we did in the office. We only paid ourselves for the shows that we worked for.
Okay.
So how long were you operating House of Music Productions where it was just you and Mr. Ladd as owners?
Since 2019
Until when?
and until now, also until Lee Bicknell came into the picture.
Yeah, when was that?
So that was June of 2021, I believe.
Okay, when did you first approach Mr. Bicknell about acquiring TRO?
It may have gone back as far as 2019. We were discussing purchasing True Productions. We were in the middle of a purchase in 2020. And in February, we were preparing documents to purchase True Productions, and then COVID hit.
Okay. So, Your Honor, may I share my screen?
You may. I'm going to rotate this just a little bit.
And if you would, what does that say on the screen there?
Stay muted, unmute.
Stay muted. And got it. Okay, now you're gonna be able to see.
So, Mr. Auda, I want to show you what I've marked as Defendant's Exhibit 2. Do you recognize this document? I'm going to try to zoom in a second.
Your Honor, we're going to object to this as parole evidence. There's a final contract. This is a term sheet, but there's a final contract.
This is not only signed by the parties that are present here, Your Honor, the lead up, the negotiations to the final contract are relevant to whether, to the value. One of the arguments they've made is that there's been no capital contribution or no consideration. And what this exhibit will show is here's the initial offer, here's the final, here's how it changed to show that the purchase price was reduced in exchange for this 10% equity interest.
Your Honor, the final contract has a merger clause in it, says it's the entire agreement and it accounts penny for penny, everything that happened in the transaction.
What's not in the final contract that's here?
So here, Your Honor, the purchase price is higher and there is no grant of ownership interest. And then later, I also intend to introduce email correspondence negotiating that reduction in price in exchange for the ownership. And then the final agreement showing here's the lower purchase price, here's the 10% to show that that 10% wasn't just free. There was consideration paid for it.
Your Honor, there's no dispute that a 10% ownership was transferred. The dispute is what was the nature of that ownership. And none of these documents show that.
You're not contending, Mr. Paskey, that the final agreement that Mr. Bicknell signed isn't the totality of the agreement. This is evolution of how Bicknell, Ladd, and Auda got from the beginning to whatever the final document is. So whatever is in defendants two, if it's admitted, isn't going to be something you point to. No, this is really what they meant. It's just, here's where they started and where they ended up.
Yes, Your Honor.
Okay. Given that that's all it's going to be used for, Mr. Jackson, I don't disagree with your point that the contract is the contract is the contract. It's got a merger clause. It's the four corners of that control. But there seems to be some debate about what the parties were talking about. I don't know that negotiations are irrelevant or excludable, even if some of the negotiations were reduced to writing. I'm just giving you a chance to respond. It's like, nope.
I thought you were saying that was ruling of the evidence. We'll just say, kind of going off what you said, I don't think it's going to change your mind on it, because basically reiterating what you just said. But we do have the four corners of the document. It expressly breaks down. It just doesn't say a sales price in the final document. It breaks down where every penny's going to.
Okay.
And so, parole evidence.
Well, I trust we'll get to the final document quickly, but that this is a waypost that the parties encountered on their way there. All right. Before we go any further, Mr. Jackson, are there other exhibits that you expect to have issues with, or is it safe that there's foundational basis for the exhibits and they can be admitted? Or, and I'm not precluding you, you should object to anything you think you ought to on behalf of your client.
Given just looking at what he emailed the court clerk, yeah, we have another one that we're going to have a full evidence, and then one, maybe two, that'll be a hearsay.
Okay. All right. Then let's do this piecemeal.
Okay, thank you, Your Honor. And for the record, I'm sure you'll get there. We have no objections to any of their exhibits.
Okay.
Okay, Mr. Auda, I know the writing is a little bit small, but can you tell the court what this document is?
It's a document offered to purchase True Productions.
Okay, and this was signed by you and Mr. Ladd?
Yes,
Okay, and you're proposing to purchase Lee Bicknell's company?
correct.
Okay, what was the proposed purchase price?
500,000.
Before you go on, notice that this document talks about an agreement between House of Music Production doing business as House of Music Entertainment. Is that, did basically your business's name, that was sort of the front name of House of Music Production? If I was trying to get an event, services provided at my event through House of Music Production, it actually is House of Music Entertainment that I would see as the customer?
No, it would be House of Music Productions. So
Okay.
I own House of Music Entertainment, and the way it worked was House of Music Entertainment and EMI got together to produce House of Music Productions.
That's exactly how I understood it. This document is confusing to me because it refers to House of Music Production doing business as House of Music Entertainment. But it may have been there weren't lots of lawyers involved in putting this
That is correct.
document together. Okay. And then that first paragraph, the deal is actually with the Tiki Bicknell. Who is that?
That is Lee Bicknell's wife.
Okay. And was she ever a part of House of Music Production, or she was a part of True?
She was a part of True. And once we purchased True Productions, we made her head of our accounting division.
Okay. But she did not get a 10% stake in House of Music Productions. It was Lee who did?
I believe that's how it worked out.
Okay.
Okay, so the initial proposal was $500,000 cash at closing. Did that happen?
No.
Okay, why?
Well, COVID came about, so we were not about to purchase a company when we didn't know what lied in our future.
Okay, and at some point though, did you re-engage True about acquiring their assets?
Yes.
Okay, when was that?
Well, we purchased them in June or July of 2021. So we discussed it before then.
Sure.
You have an issue with 4.
Other than relevance, no.
So, here I'll share my screen again. Stay more for something like that. Mario, I want to show you what I've marked as exhibit 4. I'm gonna go to the top, and then I'll scroll back down. So this is defendant's exhibit 4. Technology now. Do you recognize this exhibit?
Oh, actually, this one is also parole evidence. Objection, sorry, I was looking at a different one. Yes, Your Honor, we're also going to object to this on parole evidence, the same basis.
Okay, overruled.
Okay, so this email was dated July 7, 2021. Do you recognize this email, Mr. Auda?
Yes,
And what is it?
it's an email from Jeremy. I think it was written to the broker discussing that he did not see the 10% reduction in ownership in the shares that he drew up.
Okay, so is that reflective of the discussion that you had, that you guys would lower the purchase price in exchange for you guys issuing a 10% ownership?
That is correct.
Okay, was it your understanding that House of Music Productions was going to issue new units, or conversely that you and Mr. Ladd would give some of your units to Mr. Bicknell?
We discussed that Mr. Ladd and myself would take 5% of our shares and offer them to Lee.
In this email from Mr. Ladd reflects that when it says we would also need to include transfer of shares document 5% coming from each Mario and myself.
That is correct.
Ultimately, I'm going to show you what's been marked as exhibit 5. You did close on the purchase of True Audiovisual, right?
Yes,
Okay. And if we look here at paragraph 2, what was the final purchase price?
360,000.
Okay, and it's allocated, right? But then when we go to paragraph 3, we see that in addition to the cash, there's also going to be an ownership interest granted, correct?
Yes,
Okay, it says House of Music LLC. Is it your understanding that the intention was for that to be House of Music Productions LLC?
yes.
And it says Lee and Tiki Bicknell will receive it. Did Tiki ever receive an ownership interest?
Well, I'm not sure how it went down, but Lee and Tiki were purchasing it, so I'm not sure if Lee purchased it himself or once I don't know how their shares worked.
But what was it, 10% to each of them or 10% total? They could divide it up however they want.
10% total.
Okay, was there any discussion before you signed this asset purchase agreement? I mean, any discussion one way or the other as to whether or not that 10% ownership interest would be a voting interest?
It was never discussed.
Okay, was there any, the 5% that you were granting, so you're a 50% owner, you're gonna be granting 5% or transferring 5% of your ownership. That 5% that you're transferring, was that a voting interest?
Yes,
Okay, so you transferred your voting interest or your membership interest that had voting rights to Lee.
that is correct.
Okay, and there was never any discussion with Lee or Mr. Ladd that that would not be voting interest.
That is correct.
Okay, so when the ultimate transfer happens, did you and Mr. Ladd transfer your ownership, your 5% at the same time?
Yes,
In fact, you did it on the same document, right?
yes.
Okay, let me show you what I marked as exhibit 6. Do you recognize this document, Mr. Auda?
Yes,
What is it?
that is the transfer of shares or ownership to Mr. Lee Bicknell.
Okay, and at the top here, we'll see that it says 10% ownership to Lee Bicknell. And then below it says transfer 5% of their 50% equity. When you signed this, did you understand what the difference between full ownership, membership interest and an economic interest was?
No,
Okay. After, and obviously Mr. Ladd were you guys in the same room when you signed this?
yes,
Okay, so he didn't voice any objection to a transfer of your 5% to Mr. Bicknell?
No.
Did he ask for Mr. Bicknell to sign any other documents in order to become a member of the company?
not that I know of, no.
Okay. After you signed this transfer of ownership interest, tell me, how did the management and the operation of House Music Productions change?
Well, we brought on a new partner,
Okay, and that was Mr. Bicknell?
Mr. Bicknell.
Okay, and was he involved in the management of the company?
Yes,
How so?
we made decisions all together. So anytime that we consulted each other and we also made decisions for the company together.
Okay, from the time Lee becomes a member or gets his ownership interest until this lawsuit is filed, were there ever any meetings between the three of you guys?
We had meetings on a regular basis here and there.
Okay. What kinds of things would you discuss at these meetings?
We would always discuss estimates that were going out, how much we should charge. We discussed purchases for the company. And 100% of the time, just about, we always all agreed on whether or not to make a purchase.
Okay. Do you understand that Mr. Ladd now contends that Lee Bicknell's ownership interest is a non-voting interest?
Yes, I understand that.
When did you first learn of that contention?
It wasn't until after we had our members meeting.
Tell me how you came to know that he had some objection.
Well, I didn't know that, and actually until I was served with paperwork that he was claiming that.
Let me ask a better question. Tell me about that, the date of the meeting.
Why'd you have the meeting? You've never had one in 4 years of having House of Music production, and then out of the blue, August 23rd, a members meeting. There's even an agenda. What precipitated that?
Well, I was very frustrated with how I was being treated in the company. And I just couldn't take it anymore. I felt like I was getting run over. That's when I wrote him that text message.
Him meaning Mr. Ladd.
Mr. Ladd.
Did you feel like you were being run over by Mr. Bicknell as well?
No.
Okay, keep going.
What's the question?
I had interrupted you, but you explained why you sent the text message. But then there's this members meeting. Why all of a sudden, after 4 years, a members meeting?
So when I left,
Sorry, before you answer, I'm just cautioning you, don't need to tell anybody about anything you discussed with your attorneys, but you can say that you did, but go ahead.
Right, that's a great point. I'm not asking you to divulge privileged information, but I do need to know what was going on in your head from a business perspective, a personal perspective, that all of a sudden there's this members meeting.
well, I mean, I felt like the situation had become hostile. It was not a good situation, so I needed to get away from Mr. Ladd. And in doing so, I received a phone call from Lee saying, Mario, I really want you to stay with, come and work with the company again.
This would have been after you sent your text.
Yes.
Okay. So Mr. Bicknell was saying, I want you to reconsider. Don't walk away from this.
Don't walk away, come back. He says, if you don't come back, I'm leaving. And I said, well, Lee, I am currently speaking to an attorney at the moment to see what my options are. And that's when I was advised to set up a members meeting and to basically vote Jeremy out as a manager of the company because of how things were running in the company.
And what was your understanding of what the effect would be of voting Mr. Ladd out as a manager? Would he still have an ownership stake? Would he not be able to bring in new customers? What did you think would happen if you were successful?
So in being successful with it, the only thing I was really looking for, because I wanted nothing to change other than the fact of Jeremy lying to me or Jeremy talking to the employees bad about me. And then the last thing was for Jeremy just to tell me no.
No, meaning you don't like him telling you no, or the point was, look, let's just get it real clear. Is this a yes or a no? Are we done?
So in saying no, the last straw on the monkey's back was in order for me to collect money in the company, I had to go through Jeremy. Jeremy had it set up to where if I wanted, he had to send out the invoice because I didn't know how to send the invoice from our system. I asked him to please send an invoice to the customer. He told me no. Customer had a check in hand and he told me no. I said, please just send the invoice.
That no was the straw that,
So I came
Referring
back
to-
to the office. I didn't collect the check. And I said, I don't understand. Why didn't you send this invoice? He says, well, there's a $19 receipt I found in Tiki's box. That's not job costed. You didn't do your job properly. $19 receipt was for an item I bought for the job that we didn't use on the job. That's why I didn't job cost it. But it is an item that we use on most jobs. So instead of returning it, we kept it in inventory. So the reason we didn't pick up a $20,000 check that day was because he happened to find a receipt for $19 that was not job costed. This is what I mean by telling me no. I had just as much power as he did, but yet he controlled all the situations.
thank you.
I was gonna come back to this, Mark, but since we kind of touched on it, I wanna go ahead and talk about the text that opposing counsel's been referring to as your resignation. Okay, so do you recognize this exhibit 13, Mr. Auda?
Yes,
What is this?
it's the text I sent Jeremy and Lee.
Can you kind of just explain to the court what prompted this message, right? Okay, so when you say I will not be returning to house, what do you mean by that?
I meant that I was not coming in to work any jobs at the moment, because that's what that was our job, is to work jobs as far as project managing certain jobs.
Were you guys paid anything just for being managers? Did you get just like a salary or any payment just for being a manager?
Up until this point,
Yes,
no,
okay.
I was paid nothing. Jeremy was paid, I think, 500 every 2 weeks to run the books.
Okay, so
When you say you were paid nothing, there wasn't a standard salary, but you were making money out of the venture. And how did that, because if there was a contract with George Bush, and that was for $100,000, you'd, after expenses, get, I guess, 45% of the profits.
So prior to the members meeting that we had, before that, Jerry and myself did not get paid for any of the office hours that we contributed to. The only way we got paid was paid by the jobs that we worked. So if I project managed the job, I got paid for project managing that job. If I was a sound engineer on the job, I got paid as a sound engineer. And same with him. If he was a lighting guy, a video guy, that's what he got paid for. It's what I got paid for. After the members meeting, that's when we decided that we were going to pay ourselves what we call a salary, but it was more per hour.
Okay, but if a particular project was profitable, the excess of revenue over expenses stayed within House of Music Productions. There wasn't an annual, hey, you know what? We made $400,000 in profit in 2022. You get 45%, he gets 45%, and Bicknell gets 10%. Those types of payouts never happened?
No.
Okay, it's what you described, which is I ran the project, and so it was 52 hours, and we've got an understanding that I expense that time at $80 an hour or whatever it is, and you got paid.
Close. When we did jobs, we got paid more as a contractor for the job, so I got paid. A project manager makes a certain amount, a lighting engineer makes a certain amount, so we got paid that set amount for how we have it. So it all depends. If you do a job that's over 10 hours, it's time and a half. You do a job that's over a certain amount of hours, it's 2 days. But it was a gig pay,
Sure, but that's an hourly rate or it's a piece rate?
gig rate.
So a lighting manager would be expected to get $1,000 for a gig unless it went over 10 hours, and then,
You got time and a half or day and a half.
okay. So it's $1,000 a day, but it would be day and a half because it was more than 10 hours.
Yes, and we always approved of our own.
Sure, okay.
So again, yeah, to my point, you were getting paid by the hour for the work you're doing on projects, not just by virtue of your position as a manager. It was about the hours that you put in.
That is correct.
Okay. So when you say here at the bottom of this message that I expect my final check to be prepared and ready for me Friday, you mean the final check for the work that you performed, right?
Yes.
Okay. It's not a check that you would have been receiving as a manager. You didn't pay yourself as a manager.
Well, no, but that also, part of that check is also part of the last straw on the camel's back.
Okay, yeah, and I don't, by that you mean, go ahead and explain to the court.
So that final check is back pay that we had not paid ourselves for. I was owed probably around $25,000. I think Jeremy was owed about $15,000 in back pay. What I mean by back pay is that when we have trouble paying bills or we're trying to grow, instead of paying ourselves, we had a back pay amount. I was owed 25,000, he was owed about 15, and we're rounding these numbers off. I had asked Jeremy for the last year that we should start chopping away at our back pay. And every time I asked, we don't have enough money, we don't have enough money, we don't have enough money. I asked them every single month from January of 2022 all the way until June. I stopped asking him in June. And then when this came about, the last meeting that we had that caused me to write this text, I asked Jeremy, how much money do we still owe you? Because we have plenty of money in the bank account. We're going to pay ourselves off now. How much do we owe you? He looked at me and said, I paid myself off. That's why I said I'm picking up my final check. The very next day I came and picked up a check for $15,000. And that's what was left after chopping away from the 25 that was owed to me.
Was it your desire, and you state the desire to be bought out in this message, was it your desire to continue to be involved in the management of the company until you got bought out?
Yes, that's what I was saying, overseeing the books for, because I wanted to make sure that I was in charge of still running the company.
So then you call a members meeting, and where is the members meeting held?
We held the members meeting at your office.
Okay, was Mr. Ladd present?
Yes.
Was he alone?
No, he had his attorney with him.
Okay. On the day of the meeting, did Mr. Ladd voice any objections to leave voting?
Not that I know of. I think he had not signed the agreement,
The operating agreement?
the operating agreement.
Okay. And so did you present him, or did your attorney present him with a joinder agreement to be bound by the operating agreement?
Yes.
Show you what I've marked as exhibit 10. And you recognize this exhibit 10.
Yes.
This was actually signed the day of the meeting
Yes.
by Mr. Baker. Did he sign it before or after the meeting?
Before the meeting.
So then, when you actually call a meeting to order and start taking votes at the meeting, was Mr. Ladd in the room?
He was not. He was in the other conference room.
But he was aware that you were going to start the vote, right?
Yes.
And decided not to come in and vote.
Chose not to participate.
Okay. After the meeting, did you have any discussions with Mr. Ladd?
Yes.
Okay, tell me about those.
He came into the conference room and I believe he profusely apologized for 5 to 10 minutes, admitting that he was lying, admitting that he was telling the employees false information about me.
Objection hearsay, Your Honor. If he wants to hit him on direct examination, he can, but
The declarant is present in the courtroom.
then he can examine the declarant.
Right. The fact that there's a declarant's here doesn't make it not hearsay. If it's a statement against interest, it may come in. But we often have declarants in the courtroom. That doesn't make it not hearsay.
So it would be the statement against interest also, Your Honor, but I believe that the definition of hearsay is by an out-of-court declarant, but
No, it's an out-of-court statement, not an out-of-court declarant. But I'm going to allow it in part because as plaintiff's position has been relayed to me, this would be a statement against interest.
so continue, Mr. Auda.
What's the question?
You were explaining what was said during the meeting after your.
So he apologized. He said that he was going to work on it and do better. And I told him that the whole purpose of that meeting was not to cut him out of the company, not to do anything. Matter of fact, I told him that nobody needed to know that we even had that meeting. None of the employees needed to know. The only thing I needed was for him not to be able to tell me no anymore. That's why we held the meeting. I included him in every single decision making in the process of every meeting that we had from there on out. He chose to go and tell all the employees what happened. So that was a moot point. I was trying to make it to where he never let anybody know.
Okay. Most importantly, did he ever object in that discussion that you had that that vote wasn't valid or that Lee wasn't entitled to vote?
No.
Okay. And again, he had an attorney with him.
Yes.
After the meeting, like moving forward, what role, I think you started to touch on this, what role has Mr. Ladd had in operating, managing the company?
He had the same role as he had before. I let him participate in the decision making, even though he was no longer manager.
And did he continue to work as project manager for House of Music production events?
Yes, he did.
Before the lawsuit was filed, so you testified earlier about how House of Music Entertainment hasn't done any events.
That is correct.
You said that EMI does a trivia night and a karaoke night.
Does the trivia night, he does karaoke on occasion.
Okay.
Mostly which was booked through House of Music in the last year or two.
Okay. Before this lawsuit was filed, were you aware of any other production events that EMI was
Never.
contracting for?
EMI was not doing productions. They only did some DJ services and his trivia services. All production was run through House of Music Productions, unless he did something we don't know about.
So I want to ask you a little bit about these masters events, I think that we've referenced so far. Does House of Music Production provide events at the Masters?
Yes.
Okay, tell me, like, what kind of event would House of Music Productions do?
So for the Masters, that particular one's kind of long story. So I don't know if you want the long story, or the short story.
Let's go with a short story.
All right. So the Masters came to us through one of Lee's longtime clients, 180 over 60 or 180 over 90. I think the client was called at the time. They had a sister company called On Location. We initially started to do the job for 180 over 90. And then somewhere along, as we were working out the estimates for this job, the client changed from 180 over 90 to On Location.
So in short, these are not Masters associated events. These are parties that vendors hold at houses.
Yes.
House of Music Production provides production, stages, lighting for these parties.
Yes.
And House of Music Production has been doing this for a couple of years.
I believe 2022 was the first year we did the work for the masters. We had done it before that, the same client. And in 2021, we were to do a big concert for the actual masters with this client. That got canceled due to COVID. It was supposed to be a big show, and that the end client was someone with the masters, but our client was 180 over 90. That event never happened because it got canceled with COVID. The year after, we started doing these other events, same client, then the client changed.
So last year, 2022, who was the boots on the ground for House of Music production at the Masters?
There were two.
Okay.
It was myself and Jeremy.
Both did it in 2022. How about 2023?
2023, I was originally tasked with managing that job. And after we had a manager meeting, we had discussed it would be a better fit for me to go to Dallas to do the Final Four and to keep Jeremy here for the Masters.
Okay. So did, when House of Music production does a job like this, do you provide an estimate to the customer beforehand?
Yes,
Okay, and who is in charge of providing that estimate?
the one in charge of the show itself.
So I want to show you what I've marked as exhibit 14. It's the same exhibit attached to a motion arm, which is why it's so long.
Okay.
So this is compiled, can you tell the court what this invoice is? Or what this exhibit is?
This one is Georgia Aviation Hall of Fame.
Okay, so these are House of Music production invoices.
Yes.
Okay, so at the Masters this year for 2023, do you know how many house events the House of Music production was set to do?
We were set to do one large event, which is usually called the Endeavor House, where it's a week-long event. And then we were scheduled also to do a event in a different house every night with the same band. So there was 5 or 6 different events for the Masters. And I don't know how many more that were never booked through House of Music and booked directly through EMI, because 3 weeks after the event, this changed from our client on location to EMI, and it went from 65,000 down to 18,000.
Okay, so let's walk through this a little. I know I'm telling you to be short, but let's walk through this a little slower. So I'm showing you page 81 of our exhibit 14. Do you recognize this?
Yes,
Okay, so this is a House of Music. You'll see the TRO. You guys bought TRO, so that's on the top of your letterhead, so to speak. But this is a House of Music estimate, right?
yes,
And this is for Endeavor House, the one you were just mentioning.
yes.
Okay, and if I scroll through, it shows that this event is supposed to occur on March 28th, and that the takedown will be on April 10th, 2023, right?
Yes.
Okay, and then there's some itemized charges, or maybe not so itemized, but at least in buckets, there's charges. And then we get to the bottom and we see that the total estimate is $42,000. Okay, so to your knowledge, did this event occur?
Yes.
Okay, was all of this House of Music production equipment and labor used on the event?
I can't say all of it because we do cross-rent some gear that we don't have from other companies, but I would say 99% of that gear belongs to House of Music Productions.
Okay, now I want to show you what I've marked as exhibit 15. In this exhibit 15 is a little prettier. It's in color. It looks like it was more less a printout and more of an official document here. What is this? Do you recognize this?
This is the invoice that had been changed to EMI from the original client.
Okay, so we go back to 14. We can see that the client is set to be Masters Address House, whoever it is. It says Endeavor's event, but the services are going to be performed directly by House of Music Production. And then does this exhibit 14, does this still exist in House of Music Production system?
No,
Okay, it's been deleted.
well, it's gone or changed or
Okay, so now what we see is that EMI is listed as the customer.
That is correct.
Okay, and if we go to the Endeavor House, we see Endeavor House charged $5,047. Audio cables, video, DJ backline, those are all the services, labor included, ultimately only gets to 14,000.
Yeah, I don't even know how he got this number. I mean, there's a lot of prep work that went on beforehand, a lot of his managerial time spent that we paid him for.
So before the client was switched to EMI, we expected House of Music Productions to be paid 42,000.
We were expecting 42,000 or more because Jeremy came back from the event telling all the employees that it was much more than the event that we did out in Dallas, which was 150,000. So he was bragging.
Hearsay, Your Honor. He's saying he's telling what Jeremy told the employees.
Right. So let's not get into what people were saying.
We believe that it was over $100,000 total for the entire Masters event.
Okay, but what we have here is House of Music Productions not getting paid by the direct client for any of them. And what we have is an invoice saying EMI will pay $18,000 to House of
In
Music
total.
Production.
That is correct.
And do you know where the rest of that profit went?
I'm assuming it went to EMI.
Okay,
You say profit, you don't know that it's profit as opposed to just it's income, it's revenue.
Mario, has House of Music Productions been paid this $18,000?
No.
In fact, in the plaintiff's brief that was just filed, they indicate that they have money from other events as well, EMI does.
That is correct.
And the amount of money that EMI has, that it has invoices for House of Music Productions, well exceeds the amount of pay that is owed to Mr. Ladd, does it not?
We are predicting that the amount of money that has been taken is somewhere between 200 and 250,000.
So, but that's your projections. This invoice that we're looking at here, who created this invoice?
Mr. Ladd.
So Mr. Ladd is admitting that at a minimum, he owes House of Music Productions $18,000 for this event.
Yes.
Who set these prices? Who decided that House of Music Production would be paid $14,000 for the work it did at Endeavor House?
Mr. Ladd himself.
Were you consulted?
No.
Was Mr. Bicknell consulted?
No.
Do you see anywhere on this invoice that sets out exactly what House of Music Production provided? Like, can you tell like what equipment was used for each job based on this invoice?
Not based on his invoice, no.
Since we filed our motion, have there been more instances of EMI contracting to rent equipment from House of Music Productions?
There have been several events that were contracted through House of Music Productions and changed to EMI after the event. It doesn't change in our system until after the event takes place.
So that I'm following, it would be like we saw here. There's what looks like an arrangement between Endeavor House and House of Music Productions. Fast forward to the actual event, and now there's suddenly an arrangement between EMI and House of Music Productions. EMI having done the work that was going to be all in-house. And are the numbers deflated like we saw here, or how do you have a perspective on that?
It is much deflated. I think the last invoice I saw that was supposed to go to Endeavor House was 65,000, but it's no longer in our system.
I got that with Endeavor House, but Mr. Paskey asked you if there've been more situations like with Endeavor. You said yes.
Yes.
And my question is, do we see the same phenomena of the original bid or estimate from House of Music is X, and then when the final invoice comes through where EMI is now the client, it's something a lot less than X?
I don't know the exact number of events we did, but I think there's 4 to 5 that we know of for sure. And we don't know how many others.
So the question the judge is asking, Mr. Auda, is, was the number that EMI was gonna pay Hump after the fact, was it significantly lower than the amount?
Significantly.
expected the customer to pay if they had contracted with Home directly. Okay, I'm gonna show you what I've marked as exhibit 16. You can see this is a event from May 3rd with EMI. You can see all this equipment that's being rented. Who prepared this this invoice?
Mr. Ladd,
Okay, we see like most of these things have no charge.
that is correct.
And in fact, there's a lot of equipment here, but then we get down to the bottom and the total invoice is $400.
That is correct.
Did Mr. Ladd contact you or Mr. Bicknell to get approval to rent this equipment?
No, he did not.
Okay, have there been occasions where you found an EMI invoice in the system for a job at lower than your normal prices?
EMI was never a client of House of Music Productions, so we didn't have estimates from EMI to House of Music Productions.
In the last month, have
Yes,
you checked your system and seen there's a project on board where EMI is gonna rent equipment?
this particular one was written through House of Music for ABS lighting. It changed to EMI after, or actually before the show, a week before the show, he changed it to EMI and then only put the items on here that he was getting from House of Music Productions.
Have you stopped any equipment from going out the door to EMI?
Yes, I have.
Why?
Because one, it's not his equipment. Two, he's trying to get it for $0. Three, EMI is not our client. ABS is our client. And four, the predicted profit on it was so low, it doesn't make sense to even send it out. I think the predicted profit on that event was $75. And then Mr. Ladd would make all the profit from there.
That's all the questions I have for you.
So why don't we take a quick break? We've been going at it for a little bit. I want our court reporter to get a break and then we'll do cross-examination. Does that work for you, Mr. Jackson?
Yes, Your Honor. Your Honor, I haven't been entering exhibits, but I think you said 3 and 4 and 8 were the ones that you had objections to.
The ones that we raised objections to, which you've already ruled on.
The one more than probably not gonna use, 17. So with the exception of exhibit 17, we would tender all of our exhibits.
To the extent he's asking to tender evidence he hasn't shown to the court yet, kind of have, I'm not saying there's an issue with those exhibits. I'd kind of like to see him just before blanketly raising no objection to it.
Okay, so why don't you do that? So 17, don't worry about looking at an email from Josh Bell. That's what it's entitled. So we don't have to worry about that. But the others, Mr. Jackson, just flip through them and let me know if you've got concerns about those. And you don't need to you can do that during the break. Why don't we reconvene around 11:40? So 7-8 minutes on that clock on the wall. Madam Court Reporter, can you raise your hand if that's enough time for you? It is. Great. Okay, we'll do that. Thanks.
I'm gonna go to the restroom real quick. Helen, was there anything that like I can sneak in on redirect that you think needs to be asked about? I'm looking at some of my notes. Trying to focus on the things the judge seemed to care about rather than going through everything. I'm very intrigued to see what he says when I ask him production events before 2023.
Yeah, that was one of the big ones. Well, one of the big ones that I know is that both of them, this is what Cameron brought up in his, that both of them did business the whole time.
Yeah.
And some swing and some minute.
Right.
So you hit on that. Judge was very intrigued and even asked questions.
Yeah.
So that he hit that. So that has not been paid since February. So I think
He was there in February and I've never paid anybody.
so I think you hit on that.
I get it
However,
across.
however, I think the question is, who was the one that authorized those payments? So I would sign off on Jeremy's time sheet. Jeremy would sign off on Mario's. So since
But Mario has the bank account, so that's illusory. Mario could transfer the money if he wanted to transfer the money.
No,
So can
no,
Jeremy,
since,
Bill.com.
no, from February to July, Jeremy was the one that was in charge.
Like right now?
Before
Yeah.
Jeremy left, he came to me and said, I think we need to hold our payments. Because I continued that because we weren't collecting the money that he worked for. And I
So
didn't have
he's-
the money to pay him.
I think we're better than that. I think he's admitted in a pleading that he's holding more than $17,000.
Yeah.
So how is he entitled to any of it?
He's not.
It's EMI. It's not him. It's EMI.
Yeah, I think you hit on that. I don't think you need to.
But just to make this clear, I've never paid Jeremy. I've only approved of his payroll.
But you're the manager now. You and Lee are the managers and you have control of the bank account. So moving forward, you do need to pay him when you're able.
When we're able, I haven't
One
paid
thing you
myself
brought
either.
up was this whole term sheet.
Mhm.
That was never,
Yeah, I don't
think that.
we're gonna get that into evidence, but what we need to do is make a note of things he said in the opening that they didn't back up with evidence, and that might be one of them.
Okay.
All right, I'm gonna run to the
What
restroom.
time did he say to come back?
11:45.
Let me just restroom as well.
So were you asking about exhibits you haven't presented yet?
Well, I don't need to, I'm not, if you
I guess
don't
you
have an
can-
objection to it, I don't have to like put it up there and be like, Mario, is this a record you keep in the ordinary course of your business?
Yes, like the invoices, no objection to the, let me just kind of.
Yeah, so if there's specific exhibits, then I can just put them back up there and we can enter it in that way, but like, you don't have to, you won't have to do that.
Operating agreement, no objection, offer to purchase, I've already raised it, the judge has ruled on it, emails, already raised it, the judge has ruled on it. No objection, no objection, no objection. There might be an objection to this one, it's hearsay, it's in default, okay, fine. Lad, email, probably no objection, no objection, no objection, no objection, no objection. No objection, no objection. Yeah, we have a lot of duplicate documents. What is this?
I think
I-
the judge just wants you to look at them and let him know what you object to.
Yeah, this one I showed them.
Oh, okay, yeah. No objection there. This one, it seems like it's not a complete document. I mean, if you have like just on your computer.
I don't need it. I
Okay.
probably do, but I don't think I'm not gonna use that in my, so I'm probably good with that.
Okay, then yeah, I don't think we have any objections to anything else.
Okay, thank you.
Take notes, but I think I'm.
Good, we got you covered.
Yeah, I think you got everything pretty much. Figured out that.
All right, Madam Court Reporter, you ready? Great. We're back on the record in entertainment marketing innovations versus House of Music Entertainment with some other players in the mix. Mr. Auda, if you'll make your way back to the witness stand.
Boot it up in Zoom.
Whenever you're ready.
Sorry, you ready to get started again?
Yes.
So I'm gonna kind of walk through, be another opportunity to come back and ask questions and interact, but right now I'm really just gonna be addressing some of the points your attorney raised in his direct examination of yourself. I'm gonna start with this exhibit 2, which was the offer to purchase that was signed, sorry, trying to get our scroll on this thing, get the right screen up. That was signed, when was this signed?
Looks like it was signed in March of 2020.
And so, as you said, this was pre-COVID, correct?
Yes.
And when COVID occurred, what effect did that have on your industry?
It pretty much put us to a stop.
Put it to the stop. So, you know, from especially those early months of COVID, let's say from this date in 2021, or mid 2021, you know, what level of client, what was the reduction in client engagement? Did you lose like 50% of your business due to the pandemic, 60, just ballpark?
I would say we lost about 90 to 95% of our production, but we gained much more in installs. We did, I think, 750,000 in installs that year.
And did True Audio Visual have anything to do with installs?
Well, they did before we purchased them.
They had done installs before?
Yes.
Okay, but so, you know, total value, do you think COVID might have had an effect on the value of the company? Given that you are in the event space?
Well, when production came back, no, because we did the same work. We got the work back. It was just during COVID at that time, the evaluation of House of Music Productions at the time went down as well. We lost all our production until production came back. Really wasn't valued anymore.
And you had stated earlier, and I think you all shared this, that you had no idea where COVID was gonna take the world.
At the time when COVID hit.
Correct. And so, did this deal, you said it got put on pause when COVID hit?
Yes.
And so when you started negotiating again, it was kind of, you know, starting from square one?
I wouldn't say it was starting from square one. We took what we had before and moved forward.
When did you start to see kind of business coming back? Like, you know, COVID kind of ending, business kind of starting to flow back again?
2021, I would say probably about March of 2021.
2021. So would you say that, you know, House of Music Productions, if you just took like what's it valued at any given point, lost value during COVID?
I think almost every company lost value during COVID.
So every company would include True Audio Visual Services.
Yeah, during COVID.
Now I'm gonna take you over to move in exhibit 4. Probably got away with that. Move in exhibit 4. Do you see anywhere on here that it says what type of ownership percentage is transferred?
Says the transfer of shares.
But the nature, whether those be economic interest or membership shares.
Membership shares.
You are aware that the operating agreement of House of Music Production provides that economic interest owners and members both have ownership percentages of different natures, correct? Yes. And so looking at this document alone, is there any way you could say with 100% certainty what type of ownership shares are being transferred?
Full share. It was never discussed to give any less.
And so that was your understanding, that was a full share.
It was my understanding. I believe it was Lee Bicknell's understanding, and I believe it was
So,
Joey Ladd's
You
understanding.
stated earlier in your testimony, though, that you were not aware that the operating agreement at the time of this transaction actually provided for, multiple classifications.
Objection, misstates, mischaracterizes his testimony.
You can ask the question in a different way.
At the time of this transaction, were you aware that the operating agreement provided for, different classifications of shares?
No, I was not fully aware.
So if you were not fully aware, how could you know with certainty what type of shares were transferred?
So I thought I was transferring a full share.
When you say full share, meaning what?
Every right that I have with my 45% shares would go with that 5%. 50% share I had would go with the 5% I was giving up.
So if that meant manage or vote or
It meant
proceeds.
It meant everything that I was able to do.
Okay.
And did you ever discuss this with Mr. Ladd? That specifically, let me clarify, specifically the interplay between economic interests or membership
never
voting shares that's
discussed
being
it.
transferred?
Never discussed that.
So I'm going to interrupt you guys. It's important for the court reporter that you, Mr. Auda, not start answering until Mr. Jackson's done. You may know where he's going, but there's no early buzzing in. If he's talking and you're talking, the court reporter can't take down both things. You may have something important to say. So wait till he's done. He won't talk over you. He started to do that too, if he doesn't like your answer. So he'll wait until you're done answering, and then he'll ask his next question. Thank you.
And I apologize, but I'll do better on my testimony. Court's a little weird, normal conversations, we talk over each other. Court, it's a little different. And so did you ever have a conversation with Mr. Ladd about, what you thought was being transferred versus what he thought was being transferred in the context of voting rights versus non-voting rights, whatever form those may arise in?
We did not have that conversation.
So how do you know that Mr. Ladd understood what was being transferred the same way that he did?
I don't know what Mr. Ladd understood, but I do know that we all thought we were giving up a full share, 5% coming from me, 5% coming from him, with all the rights that we had with our shares.
Why do you say you think that Mr. Ladd thought his 5% was full shares as opposed to economic interest only?
Well, we had discussed that Lee's opinion and his knowledge would be helpful in our company. So we used him to make decisions and helped us make decisions throughout this process.
And so you're familiar with the inner workings such as House Music Productions, correct?
The inner workings?
Just like the back end of the business, the administrative stuff, let's say tax preparation.
Familiar with some of it. I am not an accountant.
And I'm not gonna ask you any, don't worry. And so you are at least familiar that House of Music Productions is an LLC, while it is specifically taxed as a partnership. It's not treated for any other reason as a partnership, but it's taxed as a partnership.
I'm not familiar with the taxation of it.
It's in the operating agreement.
I'm still not familiar with it.
Are you familiar with the fact that on Mr. Bicknell's taxes, the K-1 form that was issued to him explicitly states he is a limited partner and not a general partner?
Objection to form assumes facts not in evidence, or objection to the question assumes facts not in evidence. Also, if they have a tax return and they know what it says, they could use the tax return as the best evidence of what the tax return says.
I'll change that question. We'll bring it back up on record and take it out of the discovery groups. So that's last question, do you think it's at least possible that what you thought you were transferring the voting percentage, Mr. Ladd thought he was transferring some economic interest ownership?
I don't believe he thought that, and I did not think that I was transferring just an economic share.
Move on to the asset purchase agreement of True Audiovisual. Let me see on the screen. So you see here on 2, can you please read the name of what number 2 says?
Purchase price, the purchase price for the assets and goodwill is $360,000, allocated as follows. Resellable inventory, 1,000, fixed assets, 20,000, goodwill, 339,000.
So, do you agree that if you add 339,000 plus 20,000 plus 1,000, that equals $360,000?
Yes,
And you agree that it is expressly allocated between inventory, fixed assets, and goodwill? Like there's a one-to-one relationship between the price and what's going to what?
I mean, that's what the paperwork says.
Okay. Is this your initial?
Yes, it is.
Is this your signature?
Yes, it is.
I'm to speed things along, like, do you agree that, paragraph 11 says this is the full contract, other prior negotiated stuff falls out of it? It makes it easier to just read it out, I could ask you to read it out loud in court.
This agreement constitutes the sole and only agreement between the buyer and seller respecting the business or the sale of purchase of it. The agreement correctly sets forth the obligations of the buyer and seller to each other as its date. Any additional agreements or representations respecting the business or its sale to the buyer not expressly set forth in this agreement are null and void, unless otherwise required by law. Both parties agree to waive rights as to any conflicting laws which may nullify this agreement to the full extent allowable by law.
And so just going off this, do you agree that a reasonable interpretation is what's in this document is the full and complete agreement?
Well, that is the document we signed. It is the agreement we signed.
So I'm curious if, you have a one-to-one relationship between what the value of the total purchase price was to the various tangible and intangible assets which was purchased. What was paid for that 10% ownership?
What was paid for the 10% ownership?
Yeah, so it seems that, you pay 360,000, 1,000 goes to inventory, 20,000 goes to fixed assets, 339,000 goes to goodwill. Where's this 10% that's also getting transferred? What did he pay for that?
Well, the
Everything
original agreement was 50,000 more. We took 50,000 off the price, the purchase price, to give him 10% ownership.
You just stated that this document right here controls the entire agreement in its entirety.
That's what the statement says.
Signed it?
I signed it.
Do you see anywhere on this document where you can tell what type of ownership is transferred? I can scroll if you need.
No.
I have a question on this, I'm gonna put it on this one. Do you see anywhere on this document that specifically says the type of ownership equity that was transferred?
Says it'll be transferring a total of 10% ownership to Liebig Mill.
But the nature, whether that be economic interest, member, or member ownership percentage, which would amount to voting rights.
Well, it says 5% of their 50% equity to Liebig Mill, reducing ownership equity to 45%.
But does it, can you tell, you had to give a correct answer. Is this ownership, is this membership or is this economic interest? Can you tell from this document?
I don't know if I can tell. I'm not a lawyer.
And is this your initial right here?
It is.
And your signature down here?
It is.
And so we're gonna kind of just come off exhibits for a second. I want to talk to you. So you talked about how, while that August meeting, members meeting was the first time there was a vote, there had been plenty of meetings discussing company workings that we had participated in, correct?
Yes.
But you had also said that this mainly dealt with contracts and asset purchases, things of that nature. So are you aware that the operating agreement actually leaves that duty to the managers and not to the members?
I am aware that the managers are the ones who make the decision for the company. Yes.
And you were aware that, actually at all times relevant to this litigation, there has never been a member, we're using kind of legal entities through corporations, but there has never been a member that has been a manager.
No, I believe Jeremy and myself were 50-50 managers before we purchased out Truth.
So if we go to the operating agreement. So this is the operating agreement that your account, we have the same operating agreement that we're showing, there's no duplicity of operating agreements.
When you say we have, meaning your
Oh, sorry,
exhibit,
both sides.
Okay.
There's the same operating, you agree with that? Both sides just make the same operating agreement?
Agreed.
Yeah. So you're aware that the operating agreement says who the members are?
Yes.
Okay.
I hope the redaction.
So do you see under the members, Jeremy Ladd and Mario Auda listed?
Yes.
Where?
Right there in the center of the page.
I see it says House of Music Entertainment, LLC, and Entertainment Marketing Innovations are the members,
Well, I'm sorry, I saw my name right beside that.
which is mailing address. So you would, take to be maybe the corporate representative of that company who's the member?
Yes.
Okay. So going back to the initial question. Who do you understand are the current managers, but by law, who are the members of House of Music Productions?
By law, who are the members?
Well, I can't make you a conclusion of law, it's a bad question.
I didn't understand the question, so I
It was
was
a bad question, that's my fault. Do you agree that prior to the purchase of True Audio Visual Services, House of Music Entertainment LLC, and Entertainment Marketing Innovations LLC were the members of House of Music Productions, whereas yourself and Mr. Ladd were merely corporate representatives of each entity?
yes, I guess I agree to that. Yeah.
Okay. And so you had stated earlier, kind of going back, I got a little off track, I apologize. That Mr. Bicknell had sat in on meetings prior to this dealing with, votes, but what of those votes were, member abilities as opposed to manager abilities? And I can scroll to it if you need it. Alright, so do you agree that, we're not gonna go through the whole thing, it's just sitting down report. Do you agree that section 5.3 controls the certain power of the managers and what they can vote on?
Yes.
Yes. And then looking at 5.1, this last paragraph here, do you agree this is a list of what members vote on?
Yes.
Has Mr. Bicknell, prior to that August meeting, ever been involved in a single a vote regarding single one of these at all?
I don't think there was ever a single vote done since Mr. Bicknell came on board.
Perfect. So prior to August 23 meeting, despite maybe managerial meetings he was in, he never participated in a member vote? Because
don't
that
know.
never happened?
I don't believe we ever had a member vote.
One last little thing I want to show you in here, and this kind of ties in with your text message. I want to draw your attention to section 5.8. You said earlier that Mr. Bicknell sent you a message begging you not to leave the company. Is that correct?
No, I didn't say he was begging me not to leave the company. He said he wanted me to return and work again. And we had a discussion. We talked about what our options were. And he told me that he did not want to stay in the company unless I came back to work for the company. I did not resign. I just stopped working for the company.
What's the difference?
The difference is I wasn't coming in to manage a show anymore. I was still there to make decisions for the company. The reason I didn't want to manage the shows is because I did not want to come into the office and have to deal with Mr. Black.
So you just said it wasn't a resignation, right?
That is correct.
So I have the injunction you filed kind of while we're here today. I can pull it up on electronic form if the court needs real quick. But on page 3, you say, on July 27th, 2022, Auda quit working for the company and Auda quit working for the company and requested payment for his past services rendered as an independent contractor. Yes. So even you say you quit working for the company.
No, I said that I was not going to do independent contract work for him.
This is your own pleading.
Is that not what it
accompanied by an
just said?
affidavit.
Don't talk over each other.
I'll let you go ahead. Mr. Auda.
I'd like for you to read that again because it sounded like I said I would not do contract work for House of Music at the time.
On July 27th, 2022, Auda quit working for the company and requested payment for services as an independent contractor for the company.
Quit working. I didn't resign as a manager.
So let me ask, what were your responsibilities as manager?
Making the everyday decisions, making decisions for the company, purchases, sales,
And so,
reviewing contracts that were going out. Sorry.
finish, please. Okay. And so would you say basically everything in the company falls on the shoulders of the manager? It's the manager's job to make sure stuff gets done.
It's a manager's job to oversee the business of House of Music Production. So
So whether you're doing that yourself or through delegation, if something doesn't get done, it's ultimately the manager's fault. It's not some other employee's fault.
ultimately, it's, the boss's fault if something goes down.
So I'm trying to understand, and maybe I'm misunderstanding where you're going with this. It kind of sounds like you're arguing there's a duplicity of, employment statuses you have with the company. Another question, have you ever received a W-2 from House of Music Productions?
I don't believe so.
So at all times you're an independent contractor of them
I believe so.
in every capacity?
So I did give the company a loan, a personal loan for myself to the company, and the company pays that directly back in my name and not House of Music Entertainment. But that is not income. That is to pay back for the loan I gave the company.
But that's more of like a creditor situation. I'm talking more of you perform labor, you get paid. Have you ever been like W-2 employee?
I don't think I have.
Okay, and so you've only ever been an independent contractor. You stated in your brief you're quitting as an independent contractor. You stated that as a manager, everything was your responsibility. And so I'm kind of understanding, if you admit that it was a resignation, how, if you're a manager, right? You know, your job might be to do really high level stuff, sign bank loans, things like that. But if the bathrooms aren't clean, it's still your responsibility to make sure they get clean, whether that's, hey, you have a sponge and you're cleaning it yourself, you're hiring janitorial staff.
That's a strange question.
It is, but I mean, when
You know, is it my responsibility to make sure the floors are mopped? I don't know if that was my responsibility. My responsibility was make sure that we purchased equipment properly. My responsibility was also to make sure that we sold equipment properly. My responsibility was to make sure that we assigned certain people tasks to do in the company. I don't understand what you're trying to ask me.
so it was your responsibility to make sure stuff got assigned and completed. And if it didn't get completed, whose shoulders did that fall on? At the highest level of the company, whose shoulders did that fall on?
Well, it either fall on my shoulders, it fall on Jeremy's shoulders, it fall on Lee's shoulders.
So I guess what I'm not understanding is how you can say, hey, I resigned as an independent contractor, the only position is an independent contractor. But hey, I didn't resign from that independent contractorship. It almost feels like you're saying you're two different independent contractors from the same company at the same time.
I never got paid for my managerial duty before we had our members meeting. So I didn't get paid as a contractor to perform my members or my managerial duty. I got paid to perform my independent contracting with House of Music, which was my skill level set of audio engineer or project manager. That's what I got paid for.
So the big bucket, then, the overarching umbrella is independent contractor, and then the small umbrella under that would be you were a manager, where, you know, everything you did was as an independent contractor, but, you know, under that, you know, managing for free with some of that. Is that what I'm just
No,
trying to
I would
understand
not
this.
put it as an under or over. They were two completely separate jobs.
So you are saying that you had two separate positions with the company at the same time? Both of which were independent contractor?
My managerial duties was not an independent contractor. I was working, I was assigned as a manager of the company, and I was working as a manager of the company. I was also assigned other jobs as an independent contractor to work those jobs.
I'm now going to take us to the resignation text. So you stated on direct examination, which was when your attorney was asking you questions, that Jeremy oversaw the books.
He oversaw most of the books, yes. We both together oversaw the books from what he was working. His job was to work through the QuickBooks and to do the books. I oversee them with him.
So what was, I guess, your hands-on contribution other than just standing over his shoulder while he did it? To the books.
I made all the purchases for the company.
That's not accounting or overseeing books, is it? That's just swiping credit cards.
No, it's researching the gear that you need to purchase for the company. It takes a lot of time to do that.
But that's not books, is it? I mean, so when I hear books, I'm thinking accounting, back end, accounts receivables, you know, tracking expenses. If you clarify maybe what you think books means?
Better yet, what did you mean by the phrase, I will continue to oversee the books with Tiki?
That means I was going to continue doing my managerial services as far as seeing the books, making sure that the money was run properly. That's what the managerial position was doing, making those decisions.
Was that a role that you had done before you sent this text? Or this was
Yes,
going to
I
be
was
something
always-
new?
I was always part of overseeing the books. I can tell you how it all went down. Before we started House of Music Productions, we had QuickBooks that was on our computer. When we changed to House of Music Productions, we went to QuickBooks Online. Jeremy learned the QuickBooks Online and told me, I think it would be best if you stay out of it because it took me 4 hours to correct a mistake I had. And I said, okay, well, if you can continue inputting everything into QuickBooks, I'll oversee them on a time-to-time basis.
What did,
That's,
I'm sorry, keep going.
so I did not know how to operate the online QuickBooks. It's completely different from the other QuickBooks.
What did Tiki have to do with it?
Well, Tiki was our in-house accounting, so we were trying to get Jeremy to move all the accounting over to Tiki. It took over a year for him to even get most of it over there, and he still never released it all. He was still invoicing all his own invoices. So he was doing part of her job and part of the job she was supposed to be doing.
At the time you sent your text, did Tiki have some bookkeeping responsibilities? In other words, some of the online QuickBooks access or information had been shifted over to her?
Yes.
So you just stated that you agreed, parsing this text, Jeremy should control the books. You even stated you don't even know how the software for the books operates. And I get Tiki might have been doing books, but that's a separate individual with their own job status. If you told Jeremy prior to this that, hey, you're gonna control the books, you submitted, I don't even know how the book system works. What were you continuing to oversee?
The numbers, what was coming in, what was going out, what was being deposited.
So you were just watching, you weren't making any affirmative, hey, I'm moving money from this account to this account, I'm writing this check to the IRS. Like,
No, anytime money needed to be changed over from account to account, we would discuss it. We discussed when to take the loans out. We discussed a lot of stuff that had to do with money. But he was tasked and he was being paid for it to run the books. Although now the books are in shambles.
so when he was being paid to run the books, was he getting paid as manager to run the books?
I couldn't tell you.
Because you stated earlier that managers didn't get paid for office work, they only got paid and their only source of income was when they ran events. Now you're saying Jeremy's actually on top of you agreeing to let Jeremy do it, you admitting you don't know how the software works. You're now saying Jeremy was actually being paid to do that exact activity also?
We did not get paid for our office time, but because he was doing the books, it was an extra task. We agreed to pay him 500 every 2 weeks, I think it was.
To be the person overseeing the books.
Yeah, it was an extra task. I had other tasks I was doing.
I'm gonna draw your attention now to the joinder agreement. Is this document signed by yourself or Mr. Ladd anywhere?
I don't see it on that page.
So this is the one that your counsel submitted to the court. It's the same one we have, as far as we know, so one exists. Has it been signed by any member of House of Music Productions?
I don't see it.
Okay, so you have no way to tell by looking at this document that House of Music Productions agreed to this document?
I'm not sure I understand the question.
That's fine, I'll move on. I want to talk very, very briefly about the August meeting that you held. You stated that, you know, Jeremy didn't object to anything, but you also said he was there, just not in the room.
Yes, that is correct.
Was his attorney there with him? A different attorney other than myself was there with him?
Yes.
And you didn't take his refusal to enter the room as a complete objection to the validity of the matter?
I took it as in he didn't want to see himself being voted out.
But you didn't take it at all as, hey, this is improper voting?
No.
You said earlier on a couple instances, one was you believe Jeremy owes the company $100,000, and the other one is you believe Jeremy owes the company $500,000. What is this based upon?
I don't believe I ever said he owes $500,000. What I can tell you was how much the estimate invoices from House of Music went out to the client. And then after the event happened, the invoices changed to EMI, and they were at a quarter or maybe even a fifth of the price of what it was for the actual client.
So when House of Music Productions invoices, such as the ones that were showed today, I can pull them back up if we need, but I don't need to talk about actual documents themselves right now. Is that gross, correct? It's not net, it's gross.
Yes, everything.
And House of Music Production has expenses.
Yes.
And so at the end of the day, depending on the nature of the event, a percentage of some type is going to be taken out of that to cover the expenses. And then what's left over is net your profit, correct?
I believe that's how it works.
And the vast majority of this is coming from gear rentals, correct? The invoices that you're saying that he owes money, it's based on gear rentals, correct?
Mostly based on gear rental.
And gear rentals are basically fixed costs, right? It doesn't cost the company any money to re-rent and re-rent and re-rent. Once they purchase the asset once, you have it, and you rent it out until it breaks.
Yes and no. I mean, we do have to prep the gear and we do have to de-prep the gear. There's a cost value to that. We do have to repair the gear on a regular basis. We also have to upkeep the gear. So there's a cost to more than just renting out the gear.
The general ownership on a, for one client basis, if you rent it out 10 times, might be some upkeep. But if you rent it out one time, probably, hey, just go out there and pending somebody's spilling a drink on something or something like that. There's not really that much overhead associated with the gear rental.
Well, that including the storage of the rental, yeah.
Okay, so do you charge clients for storing the gear in your own warehouse?
No, we don't charge them for it. It's included in the price that we rent it out to them for.
Okay, and so and we'll get to it when we get onto our direct examination. I don't want to bring it up on cross. But these, as pointed out in our briefs, we said there's certain amounts it's owed. You're whereas these are amounts owed for renting gear, there's almost no overhead coming out of it from House Music Production, and it is for the large part straight profit that's getting put into House Music Productions.
I mean, I wouldn't say that, but yes, I mean, if I rent a piece of gear out for $50, that doesn't mean House of Music Productions made $50 in profit.
But if you rent it out for $50, wouldn't most of it be profit?
Most of it
Because you already own it and there is the overhead, as you said, of storing it, but your upfront cost is acquiring it, and you're amortizing that over time with all the rentals.
And so, that overhead has to come from somewhere. Do you believe it's possible that EMI is absorbing that overhead and they're the ones paying it out, which is why on the back end of your payment, seeing a lower amount come through?
I don't understand why EMI would be paying any of it.
We'll get to that.
EMI has
We get
never
on-
done a
we'll get
production.
Don't interrupt them.
that.
EMI has never done a production that I know of for House of Music Productions.
We'll put a pin on that now. We're gonna ask you again when we do our presentation of evidence. I think we're starting to get a little bit outside of what they addressed on direct. I want to ask you one last question about this ABS invoice. This gear right here, this top section of gear, what company owns that gear?
House of Music Productions.
Does House of Music Productions have receipts for it?
Probably not.
Is there any tangible evidence they can produce to show they own this gear?
Other than the fact that we said we were combining our gear when we started House of Music Productions, probably not.
No further questions.
All right. Any redirect?
No, Your Honor.
Mr. Auda, thank you for your testimony. You can return to council table. Mr. Paskey, any other witnesses?
Yeah, yes, Your Honor, I'd like to call Mr. Ladd.
All right, Mr. Ladd, if you'd come up, please.
Your Honor, before I get started, I think we've discussed exhibits, and I'd like to tender all of our exhibits with the exception of 18 and 17 and 18.
There's one more, we're probably going to overrule my objection, but we still need to raise it. With the ROG responses, the interrogatory responses of Mr. Bicknell, he's not present, that's never been filed with the court, and he's in default.
So 17, the email from Josh Bell, you're not submitting, and 18, more than me estimate, you're not submitting.
Correct.
What would the basis be for getting in Mr. Bicknell's interrogatory responses?
So as you mentioned at the beginning of the hearing, Your Honor, there is a pending motion that was filed by the plaintiff for a TRO. And in his brief, he makes the assertion that Bicknell admits he hasn't made any capital contribution. And there's an interrogatory response in there that clearly Mr. Bicknell is stating this was my capital contribution, X amount. And, you know, we would contend it's a pleading, it'd be admissible if he needed to use it for anything at court, and likewise, we should be permitted to use it.
Okay, Mr. Jackson, anything more you want to say on Exhibit 7?
No, Your Honor.
Okay, I'll allow it in. So everything you're tendering is coming in, which would be, I guess, 1 through 16.
Yes, Your Honor.
Okay,
Thank you.
great. Sorry to keep you standing there, Mr. Ladd.
You swear affirm the testimony you give, the truth, the whole truth, nothing but the truth of God. State and spell your name for the record.
Name is Jeremy, Jeremy, last name Ladd, Ladd.
Mr. Ladd, you heard Strada's testimony. Do you agree that two of you, three companies, formed House Music Production for HOM in 2019?
Two companies in 2019.
You formed 2 companies?
No, I'm sorry. There were 2 companies that formed House of Music Productions in 2019. I thought you said 3, my
Sure.
apologies.
So your company, EMI,
Mhm.
which you own 100% of, correct? Is one owner, and House of Music Entertainment, Mr. Auda owns 100% of, is the other owner, correct? Okay. What did you guys, when you formed the company, what were your capital contributions?
I believe it was $2,100 per, and my attorney does have that information.
Okay, so you cash, that's all you contributed.
Correct.
Okay, so you did not combine any of your assets.
Not that I'm aware.
Okay, I want to show you what we've marked as Exhibit 8. And
This is from the same universe of exhibits. It's not a new set.
yes, Your
Okay.
Honor, this has been tendered and admitted into evidence. So this has been admitted as Defendant Exhibit 8, Mr. Ladd. I want to go slow. I don't know if you've seen this before. Do you recognize this train of emails? This is not, it's not, it's just not clear. Give me 1 second. So I'll go slow, so I wish I could give you control of the exhibit, but tell me when you're ready for me to scroll down.
Let me, before you do any more reading, you're the Jeremy at houseofmusicpro.com.
Correct.
Okay, so in theory, you've seen this before. It's not a quiz and you can take all the time you need to read it. As you initially glance at it, is this ringing a bell as to a email chain of which you were a part?
Yes, that is correct.
Okay, take your time to read it now.
Okay, so in Mike, if you want to come back and read this subsequent email, I want to go to an email that was sent before. Okay. If we come down here to this June 16th email here, this is, appears to be an email that you sent to Ms. Laura Moore at your accounting firm. Is that right?
That's what it appears to be, yes.
Okay, and it says, I am confused by this. Both companies have assists that are being combined to House of Music Productions, right? You mean assets, right?
That I would, yes, that's a fair assumption.
Okay, so.
Says you were on a mobile device and we're supposed to excuse any typos, so it's all good.
Yes, sir. Exactly.
So you would agree with me, it was in fact your intention to combine the assets of the companies into house music production?
In regards to depreciable assets, yes.
Tell me what that means to you. What is depreciable?
There was a couple of items that were purchased with House of Music Entertainment that had loans that were taking on them at the time. And those were assets that had not fully been depreciated. They were being taken depreciated over time. So the assets need to be transferred over to House of Music Productions at that time.
Okay, it says both companies, so what assets of EMI were coming over?
I don't see where it specifies.
Okay.
Well, let's look at the next sentence. The agreement that Mario, and it probably was I had, was to combine the majority of all our assets for a 50-50 equity split. Your assets, meaning EMIs, would have been equipment. I heard not through you, but from Mr. Auda, your background, which was more the DJ side than the event production. I'm not bound by that. You can tell me, no, I was all about event production. But either way, you had equipment, whether it was sound equipment, light equipment, stages. Was it your vision that your, meaning EMI's equipment, was being combined with House of Music Entertainment's equipment assets, and that would become the shared body of equipment or assets for House of Music Productions?
I would say that that is correct.
Okay. Are there things you're thinking of like, but not my van that said EMI on it? Certainly not my whatever. I heard about turntables and things like that, but those are personal and maybe personally significant. Financially, that's not the big kind of assets that were being combined. Are there things you're thinking of that may have been put in the same warehouse with all the other stuff, but no, that's EMI stuff. That's not anyone else's.
That is correct.
What would it be that you were thinking was only EMI equipment?
In the document that was shared earlier with the lighting, the DTS lighting, that document, those would be mine, the control surface that went to it. And there were other assets that I purchased under EMI post the agreement to post 2019 as well. But those assets weren't part of any of that. Those assets would continue.
Okay, so a couple things. One, I need you to bend the microphone down to you so
Sorry
the
about
court
that.
reporter can hear you. But two, what I'm hearing you say is you may have purchased, EMI may have purchased some lighting equipment in 2021. And that may have been available for House of Music production work, but it was not a set of assets being contributed to the actual entity. It was EMI, almost as if it had EMI stamped on it. And it was, hey, Mario, it's okay. You can use this in something, but
Correct.
if we ever break up, this is all coming back to me.
Correct.
How did you document for situations like today? What would be these, I'm loaning it to HOMP, but I'm taking it back if things ever go south?
The sales receipts is what I have, Your Honor, for those purposes like that, stating that they were purchased by Entertainment Marketing Innovations.
Okay, but wouldn't whatever you contributed pursuant to this, when we're all coming together, you'd have sales receipts for those things too? Is it when they were purchased? If things were bought before the union of the two, those went into the mix. But if EMI bought something again in 2021, that wouldn't be part of the shared assets.
Correct. And EMI would consistently rent those pieces of gear to House of Music Entertainment prior to this.
Okay. All right.
Okay, so when you say in this exhibit 8, the agreement Mario and I had was to combine the majority of our assets, 50-50 split. What are the majority of EMI's assets that are being contributed? So the judge was asking about what was it?
Right.
What was it?
Without a specific list of inventory, I can't really answer that correctly to you. I mean,
Okay, so you said that the lights that were specifically in that invoice at no charge happened to be ones that were excluded.
okay.
Can you think of examples of ones that were not excluded, that EMI actually contributed to House of Music Productions?
Let's see. I'm not prepared to answer that question. I'm sorry.
You can't think of a single piece of equipment that would have been included in this, the majority of your assets.
Correct.
Okay. Okay, you heard Mr. Auda's testimony about the purchase of TRO. Would you agree with me that there was a negotiated purchase price and then it was reduced in exchange for a 10% ownership in house music production?
In what time frame? We saw two pieces of evidence from a purchase agreement.
At any point, was there a discussion to lower the purchase price in exchange for a grant of 10% ownership?
Yes.
Okay. And you agreed as part of that reduced purchase price that you were going to transfer 5% of the EMI stock, or you said shares, membership units, to Mr. Bicknell. correct?
Objection, this states facts. You said membership units.
Well, one, I don't know that it's a fact, it's in a question. Two, Mr. Ladd can feel free to say, I never used that term. I don't know what that term is. I'll allow the question.
All right. To answer your question, the word member in that was not in my understanding. It was my understanding to transfer 5% equity.
Okay, you used the term shares, did you not?
I did.
Okay, so you were gonna transfer 5% of your shares. Did you ever have a conversation with Lee, with Mr. Bicknell, that this is 5%, but it's not gonna be both, it's just profit?
Mr. Bicknell approached me in his office at our location at one point after the sale and asked me specifically, these shares that you gave me, does that include me taking on company debt? Because that's not what I want. And I said, no. He goes, I just get my 10% back when I'm ready to get out, right? And I said, that is correct. They're equity shares. My accountant, or the accountant that we were using at the time, reviewed the sale agreement, and that's what they concluded as well when they filed the tax documents.
Okay, so that's a conversation that you had with Mr. Bicknell regarding his concern that he would be taking on liability of the company?
Correct. Mr. Bicknell approached me,
Okay, but you didn't discuss voting.
and there was no discussion of voting.
Are members of, at least as far as you know, are you personally liable for the obligations of House of Music Productions?
I am.
Okay, did you sign a guarantee?
I've signed several.
Okay, had you not signed a guarantee, would you be liable for that, for those debts?
I am not sure how the law works in that situation.
So you paid for your 50% shares in the company, right? I'll use your term, shares.
Mhm.
You-
Yes.
And so there was a capital contribution associated with every one of those shares, right?
Correct.
Okay. And then you took 5% of them and you transferred them to Mr. Bicknell, correct?
Correct.
Okay. So that 5%, you had already made a contribution for that 5%, had you not?
Yes.
Okay. After this asset purchase agreement, true, tell me what involvement Mr. Bicknell had day to day in the operation of the company.
Mr. Bicknell served primarily as a mentor.
As a what?
A mentor.
Ah.
I'm sorry. Excuse me, I got a little hoarse.
I thought you had said vendor and I was confused.
No, mentor. Where occasionally we would seek advice from Mr. Bicknell because of his experience in the industry and market to help assist us make decisions.
Okay. Was Mr. Bicknell permitted to do side production jobs after the asset purchase agreement?
Not that I am aware of.
Okay, so he wasn't allowed to go take one of his legacy clients and do the job through True. He would need to do it through House of Music Production.
There was a handful of clients and that were left over True Productions clients when the purchase was taken over that they continued to service with House of Music Productions as the subcontractor for.
So, you mean, what are the names of those clients?
One of them is Cascade, Metro Fund Center, or I think it's called the Metro Fund Center. I'm not familiar without looking at it, but those were several clients that carried balances over from when we purchased True Productions that True Productions continued to service them using House of Music as the vendor to do that. Prior to the sale of us purchasing True Productions, at one point, Mr. Bicknell had tasked me with handling operations of that company until we reached the sale agreement. So House of Music Productions was the subcontractor for True Productions prior to that as well.
So I want to make sure my question is clear.
Mhm.
After the asset purchase agreement closes,
Mhm.
now House of Music Productions has purchased all of the assets of True.
Mhm.
Did True continue to provide services, production services?
In the way that you're asking the question, yes.
Okay, so True continued to receive profit off of customers using House of Music Production as a vendor.
The way that you're wording the question, yes.
Okay, why do you need to clarify?
The clarification to that is, like I mentioned earlier, is that there was a base amount of clients where those services had already been started with True Productions. And that's the difference between the two. From that point forward, I do not know.
But you wasn't starting bringing in new customers or new production events.
I can't tell you if that is correct or not.
You're not aware.
I am not aware of that fact. Thank you.
In your brief, in support of your motion for TRO, you assert that it is common practice for House of Music Entertainment and for EMI to do side jobs and use House of Music Production as a subcontractor.
Correct.
Tell me one event that House of Music Entertainment has put on since you guys joined.
I'd have to look for reference on that, but
Yes, so you have access to the records actually, right?
I do.
Okay, and I assume before this hearing, you searched those records to try to find invoices between House of Music Entertainment and House of Music Production, did you not?
Yes,
Okay, and you didn't find any.
I found job orders, but no invoices.
Okay, and those job orders were for the speaker for the house that Mr. Auda testified was for the house party,
Mhm.
and for the light that he testified he used to light up George Bush at a House of Music Productions event.
Correct. Yeah, those are two of them.
What's a job order?
In our system that they were referencing that had the estimates and production orders and stuff that were printed out, there's a system that we use that intertwines with our accounting system. And that's how the orders are built. So the rental quotes are built in that system. When people scan things out of the back of the warehouse, it adds it to it, so on and so forth. That's kind of an inventory control system would be.
Okay.
Okay, so those are the only two instances you could find between Mr. Auda or his company and House Music Production.
I did not actively look for that. Those were two that came to mind that I saw in our system when I was looking for information.
Okay. Well, for this lawsuit, let's just say before 2023,
Mhm.
other than the karaoke jobs and the trivia jobs that Mr. Auda testified about,
Mhm.
what clients was EMI doing production events for?
Macy's.
Did you subcontract with House of Music?
Yes.
Production with that?
Yes.
So, well, when was that event?
There was a series of events that were one of my clients for 10, 15 years.
Okay, so if we look through the system, we would find that in the past, EMI has invoiced House of Music Productions for this work, or House of Music Productions has invoiced EMI for this. work.
Yes.
And were those paid?
Yes.
Okay. In that same brief that I've just mentioned, that in support of your motion for temporary restraining order, you cite that there are several bills that EMI owes House of Music Production.
Yes, that's correct.
And they are for the Masters event,
That's correct.
for what other events?
I believe in the document, there was the Georgia Aviation Hall of Fame, the Afro Street Market, I think were the three main ones that I can recall.
What is the total amount that EMI owes House of Music Productions, but based on the invoices that you created?
I would say somewhere in the neighborhood of $26,000 to $27,000.
Okay, that's actually more than the amount of salary that you intended.
Correct.
Okay, so net, even if the court believes
Mhm.
that this was properly accounted for,
Mhm.
EMI actually owes House of Music Production money, not the other way around.
Correct. Yes.
Okay, so then why would House of Music Productions issue you a check for your salary?
That check hasn't been issued since February, and I've been doing events for House of Music Productions that I have not been paid for, and also outside of EMI.
House of Music Production has been doing a bunch of work for EMI that EMI's not paying for.
That is correct. I would agree with that statement.
Sort of a stalemate.
Yeah, stalemate, correct.
Have you been paid for has EMI been paid for the master's jobs?
Yes,
How much did EMI receive net for those jobs?
I cannot tell you the answer to that currently.
$50,000?
No, it is not.
How would you explain the difference in the original estimate we saw when it was Masters as the client, Endeavor House, whatever it was called, as the client of House of Music Production, and the final estimate was 65,000, whatever it was.
Right.
And then we fast forward, and now EMI is the client, having done work for Endeavor House, but it's like $18,000. What changed in terms of the event, or what it cost to provide the services that Endeavor House wanted?
So first and foremost, a lot of the equipment that we had to bring out there originally was canceled. One of the other clients that we had at the Masters had canceled also. And then all of the expenses that were associated with the Masters were removed from the billable invoice from House of Music and paid for by EMI.
So the scope of the event shrank in the sense that they needed much less equipment. Maybe I'm making this up. It was going to be 3 stages and now it's only 1 stage. Dang, that's going to be a third of the cost of what it was originally scoped as.
That is correct. That's a correct statement.
Okay.
Do you know how much House of Music Production made out its Final Four event this year?
I do not know. I have not looked at those numbers.
Do you know what the total revenue was from it?
I do not know.
Do you know whether the total revenue from the Final Four event was over $100,000?
I could not tell you without looking at the numbers.
Did you ever brag to other people in the office that the Masters events made more money than the Final Four event?
No.
All right, the initial plan for the 2023 Masters event was to run them through House of Music Productions, was it not?
That seems to be accurate.
Okay, why were they switched to EMI at all?
At that time, all the internal resources the House of Music Productions had were pulled away and stuck to the Final Four event on the NCAA in Dallas and Houston, including all of our main techs, all of our main labor, all of our warehouse labor. At that point, including my denied access to the bank accounts and financials for House of Music Productions, I felt it was in the best interest to keep the name sake and keep my client happy at that point and be able to service their event accordingly to the standards that we live up to.
Your client being whatever the Masters client was.
That is correct.
So the Final Four was absorbing so much of House of Music Productions resource base, you pivoted the Masters event away.
Correct.
Okay, so let's talk about who your client is. Who called you to do the 2023 Masters event? What's the name of that person?
Century. And his name is, what is his name again? Nick.
Had you worked with Nick before?
No.
This is the first time you ever worked with Nick for this 2023 Masters event.
Correct.
All right, so when you made the decision to shift it over to EMI, as you said, because there's the resources of House of Music, does EMI have any employees?
Yes,
Who are EMI's employees?
that is me.
You
Yes.
also work for House of Music Production.
Correct.
Other than the lights we've talked about, EMI doesn't have a whole lot of equipment, right?
Correct.
Okay. So in order to put on this event, you were gonna have to rent equipment and hire people.
Correct.
And you could have done that through House of Music Production, or you could have done it through EMI, but you chose to do it through EMI.
Okay, that I'm not understanding the question correctly. I could rent that equipment from House of Music Productions or another third-party vendor.
Okay,
That's
but House
Yeah.
of Music Productions can rent from other vendors, correct?
yeah, that's correct.
Happens all the time.
Correct.
So it was gonna cost the same amount of money to do it through House of Music Productions or EMI. The only difference was that you got to keep more of the profit if it went to EMI, right? That's the only difference.
No,
What are the other differences?
the other difference.
How do you-
Logistically, the resources that were available at the time.
Okay, so there was resources that would be available to EMI, but not House of Music Production?
Right. There were resources pulled from other vendors for that event outside of House of Music Productions.
Okay, maybe I'm not asking the question clearly.
Okay.
Could House of Music Productions not hired those same resources that EMI did?
I don't see why not.
Right. So everything that EMI did could have been done through House of Music Productions.
Correct.
And the reason that it did not happen through House of Music Productions is because you wanted to keep more of the profit.
That's not a correct statement, but okay.
So why make the switch then? Let's say to do the masters, you needed to rent 50 lights. Because the normal 50 you would use from House of Music Productions were in Dallas for the Final Four.
Yeah.
You have two different hats you could put on your head. One is EMI, one is House of Music Productions. Why did you have to put on the EMI hat to rent the 50 lights you needed for the masters?
Well, not just the 50 lights and the sound system that I had to rent, but also all the hotel accommodations, travel expenses and all that were all paid for by EMI. And due to the fact that, this is an event that happened in April, it was being withheld pay from February. There was no guarantee that I was going to get paid for that particular event as well.
Okay, I'm hearing all those words, but they're not answering the question of why couldn't the hotel rooms and all the things you're talking about, instead of paid for by EMI, paid for by House of Music Production. In other words, never shift over to, I'm going to make this an EMI thing because I want to keep Nick happy. I want to keep Nick happy because I want him to like House of Music Productions. I'm like Mr. Paskey, I'm understanding how things went down. It's the why part, as to why you shifted to making the masters what I'm going to call an EMI event rather than a House of Music Productions event. And I've heard you explain, hey, we House of Music Productions had a lot of resources deployed to the Final Four. But I've also heard you say that EMI is you. There wasn't in EMI's warehouse 50 workers and 50 lights and some stages.
Correct.
Anything you were going to get to make the masters work, you were going to have to turn to a third-party vendor, other than your skill set, which I realize is front and center here.
Right.
But that's why I use this example of you putting on an EMI hat or a House of Music Production hat. I'm not following why you felt it was necessary to make the masters event, keep Nick happy, why you needed to revert to it being EMI anything as opposed to House of Music Production everything.
Okay, right. To answer that question, all of my control for every bit of decision making that I needed to make at that time to make that event happen had been removed from House of Music Productions.
Okay, that's starting to resonate, but what does that mean? Meaning what could you not do through?
Meaning I could not put anything on the credit card. I could not tell you if House of Music could even meet the obligations to pay the vendors that were paid by EMI.
Because you couldn't see the bank account.
Because I could not see the bank accounts. Correct.
Okay. So in order to financially obligate your situation at the masters, you had to use EMI to do it.
That's correct.
Because you had an EMI credit card, you had an EMI bank account, and you had full visibility into both.
Correct.
And you knew what you were putting on your ledger. You didn't want to look at Nick and say, here's the House of Music Productions credit card. Just put this one on us. And he comes back and said, hey man, your card bounced. What kind of vendor are you?
You're right. That's correct. That would be a detrimental to the relationship.
It would. Okay.
Hey, did you ask House of Music Productions to pay for any of these events before you switched it over to EMI?
I did not.
And I think I asked this question, remind me, how much did EMI make off of the master's jobs?
I don't have that information in front of me at this point.
Okay, the judge asked questions to this extent, but I want to flush it out a little bit more. What changed exactly about the scope of the events at the masters that lowered the estimate to the final price so much?
There was a number of assets that were canceled as far as resources to cancel. The scope of work in some of the locations had went from, let's say, a $3,000 job to a $300 job.
So that's what I'm asking for.
Yeah, so.
Was an act canceled so that we didn't need a stage for it?
Okay, so specifically, one of the houses wanted a 20 by 20 stage. They wanted a full sound system for, it cost $10,000. They wanted lighting. They wanted a production manager. They wanted a sound engineer. They wanted all these things. And when it came down to it, they ended up renting a stage and 2 speakers on a stick, which is a minimal amount of gear. And that's what they ended up with. So they downsized tremendously on those events.
Equipment that you did use, was any of it House of Music Productions equipment?
Some of it was.
Did you use any House of Music Productions labor for the job?
I did use some, yes.
Okay. When it came time to draft the EMI, the invoice from House of Music Productions to EMI for the equipment, how did you come up with these numbers?
As far as in what specifically?
Here, I'll show you
Okay.
what I marked as exhibit 15. This is the invoice that House of Music Productions
share.
issued
Yeah.
to EMI for the master's work. Just give me a second, I apologize.
No worries. Okay,
Did I?
that looks correct, yes.
All right, who prepared this invoice?
I did.
Okay, so EMI, your own company, rents some equipment, uses some labor of House of Music Productions,
Mhm.
and you get to unilaterally decide the price.
As a manager, that would reserve that right, yes.
Okay, so there would be nothing wrong in your eyes if you had just paid nothing for this.
That would be considered not good business practice, but yes, you are correct. And
Correct, that would be fine.
yes,
You're the manager of House of
yes,
Music.
that would be to my sole discretion to do that.
Okay. So as long as the manager says it's okay, you can just use House of Music Productions stuff. Take their clients.
As long as a manager says it's okay, or as long as me as the manager, I'm confused.
If the managers go and say it's fine, EMI can steal our client. We don't need to make that.
I object to that statement because stealing is not a.
I'm saying, is that something within the manager's authority?
If the manager decides to take 100% discount to a client, then yes, it is in the manager's authority to do so.
Even when that client is owned by the manager.
Doesn't matter who the client is. We could do it for a nonprofit organization.
Going back to my question about the pricing
Hmm?
here. We don't see any specifics on this. It's just a line item. This is how much I'm paid. How did you come up with these numbers?
These numbers are based upon the equipment that was used from House of Music Productions, minus a 50% discount on the rental price, and to represent the 50% equity I have in the company of House of Music.
So you get the client,
Mhm.
you get to take all the overhead that House of Music Productions would have gotten. And you get a 50% discount?
I'm sorry, I believe I stated earlier that EMI took the overhead, the cost of the overhead for that event.
What is the overhead?
The overhead on that event, just in hotel lodging alone, was over $12,000.
Hotel, lodging, and then your services.
Well, my services as well, yes. And other rentals from other companies.
Hold on one second.
Should you speak up a little bit?
Okay, I'll slow down.
Okay, do you have future projects that are planned with EMI to do production events over the next 4 months?
Yes,
Do you have any House of Music production events that you're gonna be working on over the next 4 months?
yes.
What is the breakdown there? How do you decide which one's an EMI, event, which one's a House of Music production event?
Well, I could say 2 examples here. House of Music Productions events would be ones that I have signed a contract with the House of Music. EMI Productions would be ones of clients that belong to EMI that contact me directly for services.
Okay, what is your House of Music production phone number?
My personal cell phone number or the office number?
No, if somebody wanted to call you about a House of Music production job, what number would they call?
My cell phone number.
Okay, what if somebody wanted to hire EMI?
They would call my cell phone number.
Okay, so it's the same number.
Correct.
How do you decide when somebody calls and asks you to do a project, whether that's an EMI project or a House of Music production?
The origin of the client?
So you get to decide, that's your discretion.
Yes.
So who is the current manager or managers of House of Music production?
That would be me.
Just you.
Correct.
Why not Mr. Bicknell? I thought, is that not what happened? Oh, wait, that's the other side of the, okay,
Correct.
right.
Yes.
Right, okay, so you are the manager because you are contesting the meeting at which, Okay. Your perspective is, Mr. Auda has resigned.
Correct,
You two were managers. He resigned.
correct.
Bicknell, only got equity shares, so any managerial role would have to have been something that you and Mr. Auda approved of. A meeting, of just Mr. Auda, couldn't make Mr. Bicknell a manager because Mr. Auda has 45%, and not 51%. So you are the manager of, House of Music Production,
Correct.
right?
Your
Okay.
Honor, one quick correction there. Mr. Auda has 50% voting.
Oh, yeah.
That's our contention, not 45% voting.
Okay.
So.
Still not 51%.
Still not 50.
Yes.
Right. That's the right. Thank you.
Do you believe that the sole manager of a company has any responsibility to act in the company's best interest?
Yes,
Okay. Earlier, you said that the manager could sign off on somebody stealing from something, right?
no, I did not say stealing.
Okay. Where is that line? What obligation do you feel like you owe to House of Music Productions to act in their best interests?
Well, for example, if, and this has been done before, if we're working with a nonprofit organization and we feel it's in the best interest of the company to donate the equipment to that nonprofit organization at zero cost to that company, then the manager has the right to do that.
And that's great. The manager doesn't benefit in any way from that transaction.
Correct.
But when you decide, when somebody calls your cell phone, and you decide that you're gonna shift over a project from House of Music Productions to EMI, that does benefit you personally, doesn't it?
If it was shifted over, yes.
Okay, and that's happened, right? It happened with the Masters event.
And Masters was an EMI client.
Say that again. Masters was an EMI client,
Yes.
but I thought you said that the Masters was this was the first time it ever happened in 2023.
2022 is what,
Okay, be the 2022, that was House of Music era. When you say EMI client, I'm thinking in 2018, you and the Masters or you and Nick started doing business, and that would be an EMI client
right,
that is a
Nick and
legacy client.
right. Nick and I started doing business in 2023.
Okay, so how does that make it an EMI client as opposed to a House of Music production client?
Nick originally hired me to help him manage the project, and he was not specific whether or not he wanted House of Music Productions or their former AV company to do it, but he wanted me to manage all the AV projects for these events, whether it be through House of Music Productions or third-party vendors.
Okay,
Okay, so now I'm confused because I thought earlier we covered that you said it was initially, the 2023 Masters event was initially a House of Music production event, but then you had to shift it. You didn't have access to the bank accounts and et cetera. So let me ask it as clearly as I can. Was there ever a time when House of Music Productions was going to do the 2023 Masters events?
As far as wholly, 100% no.
Okay, I want to show you what I showed Mr. Auda, this March of Exhibit 14. And I'm on page 81 of this very long document. Ask you to forgive the handwriting on it. Do you recognize this?
That is a paper estimate that was put into our inventory system to reserve gear.
It was put into our inventory system. Who put it in there?
Most likely me.
But, right, you did this.
Okay, yeah. Well, we have a number of different team members that can access this information as well.
So this is the Endeavor House estimate that's provided. It's on House of Music letterhead. This is not an estimate to EMI, is it?
That is correct.
So at least when you prepared this, the intention was for House of Music Productions to do this event directly without EMI.
That was not my intention, no.
What services other than the $42,972 worth of services that are reflected on this estimate was EMI going to provide?
EMI was going to provide the L1 lighting labor, the A1 engineer, the AV tech, the hotel accommodations, the karaoke system, I mean, just on that page.
Something on House of Music Productions estimate.
For the sake of combining it to one piece of paper, so my client doesn't have to look through multiple pieces of paper.
And the piece of paper that was submitted to the client was this.
That I cannot tell you if that was submitted to the client or not. This was actually printed and submitted to you after the fact of the event.
You told any customers that you're separating from House of Music Production?
Defined customer,
Somebody that you provide services with?
an EMI customer.
EMI, any customer, EMI or House of Music Productions?
I have spoken to, yes.
I want to shift to the meeting that we discussed for. So there was a meeting of the members, a notice. Did you receive the notice of the meeting of the members?
I was served paperwork from Mr. Auda on a job site in front of our contractors and employees.
You got notice?
Correct.
Okay. And did you appear at the meeting?
I received a text message 2 days before the meeting stating that if I did not attend the meeting, it would be taken as my automatic resignation from House of Music Productions.
My question was, did you attend the meeting?
I attended with counsel.
And at that meeting, did you object to Mr. Bicknell?
I did.
Okay, what was the basis for your objection?
That he does not have member shares in the company or voting rights, and my attorney objected as well.
Okay. Was the basis of your objection that he had not signed the operating agreement?
No,
Why didn't you go into the meeting and put that on the record?
under the advice of my attorney, I did not attend the meeting.
You heard Mr. Auda say that after the meeting, you went in there and had a discussion with Mr. Bicknell and with Mr. Auda.
Yes,
Correct?
that is correct.
Okay. During that conversation, did you at all object to the participation in the vote?
No, my attorney strictly objected to that, and I did not mention that.
So let me be clear. And your attorney can jump in, but I don't need to hear anything that your attorney's talked about. It's fine if you're
Okay.
done. Tell me that you talked to your attorney, but I just want to make sure you know that I'm not asking you to tell me what your attorney told you.
Real quick, Mr. That includes your prior attorney who was.
That's
attorney-
correct. Yes, Jonathan Sparks.
Right. Any lawyer in whom you confided, you don't need to share that. Well, you're free to share it, but to be clear, Mr. Paskey is not seeking to elicit that.
Okay, understood.
After that meeting occurred, did you continue to be involved in the management of the company?
Yes,
Okay. At some point, did you stop going into the office?
I did.
Okay. Does that mean that you resigned as manager?
No,
How much is you talked about the two invoices that you guys have attached to your most recent motion where Mr. Auda pulled a couple of pieces of equipment out of inventory. One was a speaker he testified was about a house party.
Mhm.
How much would you guys normally run that for?
$75.
What about the Leco lights that Mr. Auda said he used on the master's job for George Bush?
There's two different versions. One would rent for 25, the other would rent for 65.
We're not talking about anything over $100.
And to that aspect, no.
And you testified that you haven't found, at least yet, you've been involved in this litigation for a while, you haven't found any other instances of Mr. Auda using company equipment personally or for House Music Productions.
There's another instance I can think of where he rented a mixer to a bar somewhere and didn't charge it for him. And when I asked him about it, he's like, "Oh, I told them to give one of our guys free beer when they came in return for it or something." So
That would be similar to the.
yes, I mean,
or whatever they use.
yes.
Do you have any evidence for the court that House of Music Entertainment has continued to contract with customers for production events like EMI has?
I would not have access to that information.
But you do have access to all of the QuickBooks and all of the invoices of House of Music Productions.
Correct.
So if House of Music Entertainment was contracting with House of Music Productions, you would have access to to the payments and the invoices back and forth.
That would be correct, yes.
Your attorney mentioned in opening that after Mr. Auda sent his text message saying he wasn't coming back in, he put together a term sheet. Was that ever given to Mr. Auda?
I put together a letter of intent to purchase out Mr. Auda before, obviously, once he had left the company, there was a large workload of projects that were intertwined before I can put together the pieces to put that together and serve him with the letter. I was then served with the notice of special meeting.
Did you ever send that to Mr. Auda? That letter of intent for the term sheet?
Once the notice of special meeting had been given, no.
Okay, do you contend that you objected in any way of the transfer of interest to the 5% interest to Mr. Bicknell?
In what fashion?
You contend that you objected to the transfer. I mean, you signed the transfer document, right? So you agreed to the transfer.
I agreed to equity, yes.
And so Mr. Bicknell has now signed a joinder agreement to the operating agreement. You would agree with that, right?
I saw that, yes.
And I think part of the agreement, the asset purchase agreement, was that both parties were going to bear 50% of the costs, right? So there was an agreement as to how the costs of that transfer were going to be allocated, right?
Correct.
Okay. And is there anything else other than your permission that you contend Mr. Bicknell would need to do or sign in order to become a full member?
Not that I'm aware.
Okay. So if we look at the operating agreement, I'll share that with you. Let me, before I get there, you've never asked him to sign an indemnification agreement or anything like that, have you?
No, not that I'm aware of.
If we look at the operating agreement, section 12. Okay. This is, lawyers are fun, so
Yes.
it's gonna take you a minute to read this, but I think it's important to read all of 12.1 and 12.2, and I've got a question for you.
Okay.
And should I zoom in a little bit more?
If you could, that would be great. Thank you. Okay, that's good.
Okay.
All right, so 12.1, general prohibition.
You don't need to read it out loud.
Oh, thank
Thank you.
Okay, I'm finished.
So number A, 12.2A,
Uh-huh.
you would agree with me that you guys did execute a transfer of interest, a document transfer of interest, you and Mr. Auda,
That is correct.
right? Number B, Mr. Ladd has now signed a joinder to the operating agreement, correct?
I'm sorry?
Mr. Bicknell.
Bicknell,
has
yeah,
now
okay.
Signed a joinder to the operating agreement, correct?
That is correct.
Okay. C, you guys haven't requested that Mr. Bicknell sign any type of indemnity or hold harmless agreement, correct? Managers never requested that.
Not that I am aware of.
Okay. D, you testified that there was no other documents that you contend Mr. Bicknell needed to sign, correct?
That would be correct.
And E says unless waived by the managers, the transferee or the transferor must have paid the expenses. Well, you guys expressly agreed in the asset purchase agreement how the cost of this transfer was going to be incurred. If there even was cost, I don't know. It didn't look like there was an attorney involved, so I don't know that there was cost, but there was an agreement on that. So would you agree that A through E of 12.2 have all been met with regard to the transfer of interest to Mr. Bicknell?
Yes, I would agree.
Okay, that's all the questions I have.
How, question for you, Ms. Paskey, how is 12.2C satisfied? I don't read C as saying the managers have to request it. It's that it must have, and then the form and substance has to be satisfactory. So where is the indemnification box? How is the indemnification box checked?
So I'm relying on in the form and substance satisfactory to the managers. So if the managers didn't require it, then, and if they were taking the position in this lawsuit, that's what Mr. Bicknell needs to sign and he's a member, it could be presented to him and it could be signed. So I haven't heard that argument from them, but my position on that, Your Honor, would be if it was required by the company, it would have been provided. Obviously, any requirement can be waived, but it says in the form and substance satisfactory to the managers. Well, he just said they didn't require one. So none is in the form and in substance satisfactory to the manager.
Yes, but then that's not executing a written agreement, and he must. So, okay, there's a little tension there with C.
That's all the questions I have.
Thank you.
Got it. We're going to break for lunch. A little overdue, but this is a natural break point. Mr. Paskey, how much more? I know you're done with this witness. Do you have other witnesses you're calling, or this would be the end of your presentation?
Be it for
Okay. Then Mr. Jackson, you of course can examine your client in this format. You can call him. I mean, this is less formal than a trial because you mentioned several times, oh, I'm going to save that, Mr. Auda, till I put you back on the stand. You would have been free. You can put Mr. Auda back on the stand, but you've been free to ask him anything and everything you wanted to when you had him there before. What do you have left? You have questions for your client?
Yeah, and I know we've gone over this a bunch, because the ambiguity. If we are not addressing our, I guess, TRO or interlocutory injunction that has 30 days to respond, then ours is probably going to be pretty quick.
Okay.
If you would like us to address the, basis for the interlocutory injunction that we moved for, it might take a little bit longer.
So maybe you're going to be somewhere in between, not much longer and a lot longer, because what I'd like to do after we're done today is to be able to provide some form of interim relief to the two sides. Now, whether that relief favors one side more than the other, TBD. I haven't heard much of your presentation yet, but I won't be ignoring what you've asked for in your motion, if that makes sense.
Okay.
So I don't know how much you need to argue it. That's sort of up to you. But it may well be that an outcome from today is that I ask Mr. Auda's legal team to provide on a short turnaround some briefing on question A, B, or C, because it relates to some of the relief you're seeking. But Mr. Auda's lawyers haven't had a chance to respond to that motion. I don't think we're going to need to have another full-blown hearing just based on your motion, because these things are somewhat interlocking. The other thing that I'm already thinking about is I will likely do something that tries to maintain the status quo, that it's a super healthy status quo, but provides some of the protections both sides are looking for, with an eye to some pretty quick discovery deadlines to work through the declaratory judgment pieces, because that's really what's going to dislodge things, is a ruling from me that says Bicknell is a member and he's got voting rights, or he's not. And it's sort of what Mr. Paskey was alluding to, that we don't even need a receiver if you rule this way or that way, because Mr. Ladd's fully in charge. And what's the receiver going to do? He doesn't need one. Or Mr. Auda is in charge with Mr. Bicknell. Those are declaratory judgment findings that really aren't quite teed up through either of the TROs. They couldn't be, because that's a substantive claim in the litigation. So whether there's a special master who's going to help in the interim rather than a receiver, I don't know. So I'm just sharing with you some early cogitations of mine, so you can calibrate how deep you decide to go with your client, or if you recall Mr. Auda.
So I guess to err on the side of caution, I'd probably say an hour and a half.
Okay. All right. If we then have only a half-hour lunch, if it's going to go that much longer, does that work for Team Auda?
Yes, Your Honor.
Okay. And for you, Mr. Jackson?
That works for us.
All right. Madam Court Reporter, can you get by with just a half hour for lunch? She's nodding her head. All right. Let's try to be back around 1:50 on the clock on the side. Thanks.
Let me get all this packaged. Yeah, we should be fine. I'm just gonna kind of like put away work product notes. Yeah, somewhere we can just kind of talk. I would ask. You think she's okay to leave your stuff there?
Is my laptop? I will be here. So.
Oh, perfect. Thank you.
Hey, Wendy, it's Kristen. I work from my parent. It's actually my very long parent. I think they're gonna go for, about an hour and a half after we get back around 2. So it is not going to happen today. I will stay up for as long as it takes you to, but it is going to be tomorrow morning, as I said in our conversation, probably, looking more like mid-to-late morning before I can get that in. Again, I apologize. I guess I had on Friday that they had this specific, such a specific deadline, then, I think maybe amend my plans a little bit. Yeah, I'm sorry about this. I did not know until today that, it was such an urgent deadline, and as it's videoed, those take a little bit longer. So please give me a call back and we can talk about this. Anyway, yeah, thank you. I will be available for the next, 12 minutes or so. Thanks, bye.
Awesome. That's perfect. I'll do this one.
It wasn't even open.
All right.
You don't think that we should bring that back up, just to make a note that he's claiming he switched to EMI and something, some. Couldn't tell if he had enough. He wasn't provided.
I noticed that earlier. I was looking at the TV and the car. Oh, go right ahead. So many people are just like, "Hello, good morning, how's it going?" I can't text you right now.
Yeah, I don't, when I have like days, I turn my phone on, airplane mode, and I don't even look at it during lunch breaks. Like, I don't want to be distracted. I don't want to.
Yeah, I know. This thing set out, I put it in do not disturb, but I guess there was a storm alert, so when they made that beep, and I'm like, off. Hey, you still there?
Yeah, I'm still
I'm surprised Alan was actually here. I'm surprised Alan was actually here.
Yeah, we were talking about that, me and Samantha. We were talking about that on the way in.
I should get stopped at security with that thing.
Alright,
It looks like a line.
don't even look. You think, hey, actually look at those bags.
Careful, look at Mario's.
They make you take your belt off.
Yeah. I took them off.
Yeah, they started letting you bring your shampoo bottles in. Super nice.
Yeah, yeah, it's just in case you need a midday fresh up.
No breaking anything.
It's like, oh, what's in there?
Those bags make it through that tray so fast, there's no way they're looking through them.
You have to take your laptop out, right?
Yeah.
Tennessee.
Honestly, it was good. 2 weeks that was going, they were nice. Well, just working.
We had, I tried to check in with you on Friday, but they didn't need to call me back.
Yeah.
Occupied.
Yeah, wait for them to.
Yeah.
Sheriff will
Client
take it.
called in. I was on the phone like from 5 to 6 or something on Friday. Bernie or Greco? Bernie
Is he what?
for Greco.
No. Kraus. Rachel Kraus.
Okay, that's good to know. We didn't appeal his.
She was cool with it.
Yeah.
She was fine with us appealing. Need to figure out what we're doing with that. I still want to stay. And Tom wants to mediate it, but it's like 25 grand. It's not worth the mediation if that's all he's willing to offer.
Ed,
Mhm.
I should let him know.
I did. I'm gonna try to talk him into mediating because I think he'll put more on it if he looks at it objectively, and I think making them come in from out of town to do a mediation gives us the best chance at getting it actually done. Because I'm sure she doesn't want to spend any more money.
Doesn't extend that. The order goes.
He said that, of course.
How are things going back there, Deputy Gordon?
Great.
Good, glad to hear it. All right, Mr. Paskey, nothing came up during the break that we need to revisit. You're done with your presentation.
Yes, Your Honor.
Okay. Mr. Jackson, when you're ready.
So I have my approach.
Sure. Come on up, Mr. Ladd. You're still under oath.
I'm gonna try my absolute best to just do this as one big thing instead of, crossing and recalling witnesses for direct. Ready?
I'm ready.
Mr. Ladd, I want to draw your attention back to Movements Exhibit 8. This email that you, not sharing the screen. This was the email they showed you earlier. You've already stated that you did send it, or you believe it did send it.
Yes.
I want to talk to you a little bit about this 50/50 asset, transfer to the company.
Right.
Help me understand, is this just like a moment in time, or is this all assets you've owned from that date moving forward into the future? What is that? What do you think was given to the company, House of Productions?
What EMI gave to the company or what? or-
Yeah, so this email appears to have been sent, June 16, 2021. Is this referring to assets acquired after that date?
No,
Is it referring to assets acquired after January 1st, 2019, which I represent to you, is the date that House of Music Production was legally formed?
no,
No, so just everything prior to that date?
yes,
And House Entertainment, EMI,
Mhm.
has continued to accumulate assets subsequent to this, correct?
correct,
Which is effectively rebuilding its inventory.
correct.
All right. And so even taking into consideration, equipment from both sides that was, given to the company, let's stay away from the word donated, but transferred to the company.
Mhm.
The amount given to the company is equal between you and Mr. Auda, is that correct?
Correct,
In fact, the operating agreement actually expresses a conflict, is that correct?
correct.
So I'm gonna.
When you say the amount that was contributed, meaning the financial amount or of these assets that you were just talking about? Assets meaning, hey, I contribute this equipment, you contribute that. That was exactly equal, or it was the financial contribution that was exactly equal?
Financial contribution.
this actually isn't, this was left out of their operating agreement, so I'm going to pull up our operating agreement, which is a little bit different than the one you presented.
Why would there be two different versions of the operating agreement?
There are pages left off of the ones they presented. It's the same one, just with pages missing, that when I just looked
Okay.
it up, I just realized.
Tax addendum or something he's referring to.
Thanks, would you like to see what I'm bringing up before the objection?
I can see the screen. You're good.
It's a long document. Here we go.
So, Your Honor, while I have no objection to this being entered into evidence at all, this is a separate document than that. And it might be related to the operating agreement. As you saw, as he scrolled through, we saw a certificate, we saw a separate tax election form, and now we're looking at an interest subscription agreement. And so I just want to clarify for the court that we didn't omit pages of the operating agreement.
This is not part of the operating agreement. It's another document that the two members signed.
At the exact same time.
Okay.
As signed the operating agreement, we have no objection. We can consent to, entering as a different exhibit, however the court wants to do it.
You can do it however you want to do it. They're your exhibits. It just is helpful clarification that when you say that the defendants omitted pages of the operating agreement, doesn't sound like that's quite accurate. There is another document that they didn't tender, or maybe they tendered it and didn't publish it. But what I'm looking at on the screen right now is not the operating agreement. It may have been signed at the same time, but it is the interest, you keep scrolling, but it's the interest subscription and something document.
We'll recant anything saying that they were doing it, opposing counsel did any wrongdoing. We didn't mean to imply that.
Okay.
Mr. Auda, do you know what this document is?
Yes,
What is this document?
interest subscription and investment letter.
When was this document entered into and signed?
First day of January of 2019.
Was this signed at the same time the operating agreement was signed?
Yes,
Same meeting, same sit down?
yes,
No objection, I'd like to move to admit as I guess, plaintiff's exhibit 1.
It says exhibit 7 on the screen.
Yes, we'll admit as plaintiff's exhibit 7. That's easier to go that way.
Yeah, I have a folder of PDFs you submitted, and I think this is 7. Let's stick with that. It'll be confusing going forward otherwise.
Plaintiff's exhibit 7. 26 of the call.
Any objection?
No, Your Honor, no objection to any of the exhibits that were provided in the file.
Okay. So if you're not straight, did you get 15 exhibits?
I think I did.
Okay, then 7 is admitted. You can handle the others how you want, but there's no objection. It sounds like on the horizon for you either.
What does this document tell you, Mr. Auda? Sorry, Mr. Vlad.
it tells me that we have equal capital contributions to the company, 50%.
And so when you were signing this, did you understand that you were kind of fixing the price of the assets along with the cash that was given to the company at 2,100?
No,
No.
I'm not understanding that question. Hang on a second.
So I'm trying to get at is,
Okay,
regardless of the assets that were given by which party, it was the understanding memorialized by this written agreement that at the time, the initial contributions were exactly equal.
correct.
Objection, Your Honor. I know I was given a lot of grace on my examination, and to the extent it's moving forward, I'm fine with it, but I'll object to leading on that question.
Okay. I'll let this question go, but this is now your witness on direct. So
Stone Cross.
Mr. Paskey has finished his presentation and you're starting now. So other than Mr. Auda, who you could call call to cross. You don't call your own client to cross.
He called when we took a break before I had to cross-examine.
Oh, you're right. And I think Mr. Paskey just went through the same misstep I did. We did break for lunch, but Mr. Ladd had only been examined by Mr. Paskey. And so you are going to do two different examinations of Mr. Ladd. And how am I supposed to know when you're done with cross and leading questions and want to get to direct?
If the court will allow it, I would like to do the cross, give him any opportunity to redirect, and then begin my presentation of evidence to kind of maybe clear up some of these confusing issues with procedure. I think we can do it time efficiently.
Okay, Mr. Paskey, anything you want to add?
No, Your Honor, I want to move it forward, but as quickly as possible. So I'm considering withdrawing. I'll withdraw the objection if it allows us to move forward.
Let's move
more
forward.
efficiently.
Under the understanding I'm still on cross, I'm gonna re-ask you the same question,
Okay.
Mr. Ladd. Is it your understanding that with regards to this document memorializes an agreement between you and Mr. Auda that regardless of the amount of gear, anything that was given, your initial capital contributions were $2,100 apiece?
That's correct.
And at any point, at any time subsequent to this, has any person ever made another capital contribution to House Music Productions?
Not that I am aware of.
Has there ever been, so as you know, the operating agreement requires certain member votes and authorizations to permit capital contributions, additional capital contributions. Has that ever occurred?
No.
And so we were talking about, they were asking you about lists of inventory between what was currently in that warehouse, that was House Music Productions, and what was EMI's. You said, off the top of your head, you couldn't really just spout it out. But if you sat down and really looked at it, could you figure it out?
Yes.
Figure it out pretty easily?
Yes.
So all you really need is just kind of a list of all the inventory in front of you?
Yes.
Now I'm gonna ask you about 12.2 of the operating agreement and much. Are you able to read that? Is the board able to read that?
Yeah.
I can read it.
So we talked a lot, you were asked a lot about, 12.2, bars with A through E, but we kind of ignored the last paragraph. Can you please read to the court what that last paragraph says?
A permitted transferee of an economic interest who does not become a member shall be an economic interest owner only and shall be entitled only to the transferor's economic interest to the extent assigned. Such transferee shall not be entitled to vote on any question regarding the company, and the ownership percentage associated with the transferred economic interest shall not be considered to be outstanding for voting purposes.
So is the understanding that, while that first part surely does talk about, membership percentage, this section alone addresses the whole gambit of possibility of ownership in the company, correct?
Correct.
Okay. And so I want to ask you a little bit about the masters.
Okay.
We talked about that. Can you talk to me about, the difference between the 2022 masters and the 2023 masters?
Yes, the 2022 masters and the company on location that they're talking to, Liz O'Connell is who hired us to do that at the time. She had left the company
And who did Liz O'Connell work for?
on location.
And so Liz O'Connell was what's called the agent of On Location that
Correct.
reached out and hired House Music Productions.
Initially for 2022, yes.
2022.
Yes.
This was the first year that House of Music Productions, and I'm gonna generalize this, please let me know if I'm overgeneralizing, had performed any work in the city of Augusta during the week of the Masters.
That is correct.
Okay, and so Liz O'Connell hired you. Is On Location a small company?
They're a pretty significantly large company.
How many audiovisual contractors, vendors do you think On Location has?
Hundreds, maybe thousands.
How many booking agents, such as Liz O'Connell, do they have?
Hundreds, maybe thousands.
And so other people throughout the country are using On Location and they're just spinning it out?
Yeah.
Perfect. And then, so did Liz O'Connell hire you again for 2023?
No, she had,
Did On Location hire you for 2023?
no,
Okay, so then if Liz O'Connell, who was House of Music Productions point of contact, previously didn't hire you, and the company that hired House of Music Productions the year before didn't hire you, who hired you?
it's a company called Century. Nick Schilling is a gentleman.
Is Century owned by On Location?
No.
Do they have any, they're not owned by On Location?
No, they are not.
All right, and so effectively EMI got hired by a totally different client to do the masters for 2023.
Yes,
So they weren't even stealing a House of Music Productions, even in the most adverse view of these facts to us. They weren't, this is a totally different client,
correct,
and that client had no prior action with House of Music Productions.
correct.
All right. And so you initially tried to get this to be a House of Music Productions client, correct?
Correct.
And so there was a lot of talk about assets and stuff, and I don't want to stay on this too long, I just want to clean stuff up. Was there any possible way that you could leverage House of Music Productions assets so that House of Music Productions could perform on these contracts?
I'm not completely understanding that question.
Well, stuff costs money. Did you have House of Music Production bank accounts?
No,
No? So there's no way, was there any other, hidden House of Music Production resources, buried treasure, anything like that, you pawn off here to be able to fund this stuff for House of Music Productions?
No.
And what would have happened to House of Music Productions if you didn't transfer this to EMI?
we could have suffered irreparable damage at that point.
You believe House of Music Productions could have gotten sued?
Yes,
And you said the company that was hiring, were they big companies?
yes,
Did they afford good lawyers, you think?
absolutely.
Think House of Music Productions would be able to, really fight against them?
No.
All right, and so I want to kind of touch, they keep talking about, disinterested members, but A, they're ignoring the fact the operating agreement controls, not the statute. Second, that statute actually has a second part to it, that given the circumstances, it was fair and reasonable to the company. So given the circumstances, do you believe it was fair and reasonable to the company to help them avoid being sued?
Yes,
All right. Now you said, you didn't really ask the other, Mr. Bicknell, Mr. Auda, permission to do this. Why didn't you go talk to them?
at that time, there was some moves that were made by Mr. Auda and Mr. Bicknell that were aggressive in action to remove me from my position and powers within the company.
Can you give an example?
I was removed from the access to the bank accounts. I was provided with a letter of stipulations from Mr. Auda.
Let's talk about it. What was in that letter of stipulations?
That I was no longer allowed to, I was equal to the employee managers. I was no longer allowed to fire anybody. I wasn't allowed to make decisions on my own, so on and so forth in a nutshell.
Then what was his basis for saying that?
I'm not sure where that basis came from, but to my understanding, he was upset with the way that I was doing things.
Okay, and then, so even more than just the accounts, I want to kind of talk about just communications, verbalization of words between you and Mr. Auda. Why was it not even brought up to him doing this?
At that point, the level of aggressive actions from Mr. Auda towards me, I decided that it would be in the best interest not to communicate with him.
Can you give the court an example of, things that were said? I understand people fight, things are probably said in both directions, but give court examples of some things and the hostilities that were said.
I can have you removed and make you a silent partner at any time.
That's exactly what he said.
Yes.
I also want to talk about the phone situation. So as you said in your earlier testimony, the EMI phone number, the House of Music Productions phone number, and the Jeremy Ladd personal phone number are all one and the same.
Correct.
Has Mr. Auda, assented to that? AKA, has he agreed to let that happen?
Yes.
Yes, so for example, how long has that number been the number for all three, or, one only existed since 2019, but can you walk us through the history of that phone number and its relationship to each of the companies?
On a personal level, it's been my personal cell phone number since 1998. Upon partnering up with, and I say partnering, not in a legal sense, but getting together with House of Music Entertainment, is also used as a phone number for House of Music Entertainment. And then later, when we established House of Music Productions in 2019, it was then also now House of Music Productions number as well.
And so this has been, this has been House Music Entertainment prior to the formation of House Music Production. That number was also their company phone number since 2002.
One of the company numbers, yes.
One of the company numbers since 2002. And it has been the House of Music Productions phone number since 2019, the formation of the company.
Correct.
And not until this litigation has Mr. Auda ever taken issue with it.
Correct.
There were also some discussions about discounts provided to you, such as, let's go back to the masters, such as like labor. Did you ever take a discount on labor?
No.
No? You performed labor yourself, right?
Correct.
Who paid for the labor you provided?
For the masters,
The masters,
that would be EMI.
EMI. Did you charge House of Music Production 1 penny for the services you provided?
I did not.
You try to collect money directly from House of Music Productions and associations with the labor that you provided in regards to the masters?
I did not.
Now there are a few things I want to ask you. So there were some allegations of names being changed on invoices where when they were originally put into the system, they were under one name, but then at the final billing, all of a sudden EMI was the name. Can you kind of talk to us about that? Maybe tell us why that was occurring?
In some situations, to be brief on it, a lot of times the finalized billing aspects of the client are not actually done until we complete it. In that situation, also in regards to EMI, I was afraid that if I did put the information there as EMI, then I would be restricted access to the gear in order to service the client.
And on prior other things that you had tried to put EMI on, were there restrictions placed on you?
There has been restrictions, yes.
Can you give some examples of those restrictions?
One, I had EMI put on an event just recently, and that event was canceled in our system by Mr. Auda. Mr. Auda told the employees that work for us that it was canceled. The employees had asked me specifically if it was. I said that it was not. My client called me waiting for delivery of the items. And when I called to talk to the employee that was supposed to deliver it, he informed me that Mr. Auda has taken the keys to the vehicle away from him and will not give him back unless I immediately call him.
And then there were also some questions about, certain people going into the office and not going into the office. Why did you stop going into the office?
The level of aggression that has been taken not only by Mr. Auda against me, but also Mr. Bicknell and Tiki Bicknell as well, has been very overwhelming.
And so, I know it's kind of hard to talk about all this stuff, but can you give some examples of hostility? Was it all business related or was it starting to become personal?
Some was business, some was personal. At one point, Tiki Bicknell had told me.
Your Honor, I'm just going to object to the extent that the question is calling for things other people told him, because that would be calling for hearsay.
Right. So we can't, other than what Mr. Auda may have said, party opponent, Tiki Bicknell's not in this lawsuit, so we can't get into what she said.
Okay,
At least
absolutely.
not in this format.
In a general sense, there was personal and business attacks.
Anything, maybe said against your wife?
Yes,
Yes?
Yes.
Negative things?
yes.
And then, so, as our contention is Mr. Auda resigned in that July of 2022 text message. What did Mr. Auda do after that? Did he keep coming into the office the next day?
No, he did not.
What did he do?
He, I can't tell you exactly what he did, but I know that he was not present at the office.
Okay, but how much time passed between, his text message resigning and the next time you saw him doing business on behalf of House Music Productions?
It wasn't until after the special meeting of the members.
So he just stepped away from the company until you got that meeting notice?
That's correct.
And that meeting notice, when, despite the fact that he made statements today that he told you privately, no one ever know about this, he noticed you very publicly.
That is correct.
You hadn't heard from him, he hadn't been working for the company, he hadn't been coming in at all?
Correct.
All right. I'm gonna wrap up my cross-examination here, and hopefully, move this along and get us out of here. As you see, I'm gonna keep the operating agreement up. So under 5.3, we agree that provides certain powers to the manager, correct?
Correct.
What does 5.3I say?
5.3I, to enter into any and all other agreements on behalf of the company with any other person for any purpose in such forms as the manager may approve.
I'm gonna ask the assistant to kind of say that. And you agree that this is saying that managers have that right?
Yes.
Okay. And then I also want to ask you about one last paragraph provision. With regards to, I know there have been some contentions with the statute controls or the operating agreement controls. Can you please read section 15.18 for me?
Determination of matters not provided for in this operating agreement. The managers shall decide any and all questions arising with respect to the company and this operating agreement, which are not specifically or expressively provided for in this operating agreement.
And would you agree that managers can exercise autonomy?
Yes.
And you agree? That was the express purpose of these two competing companies entering into this synergistic relationship together to allow them to continue to compete.
Yes.
And so there was a lot of testimony about whether or not, House Music Entertainment is still conducting business on their own and whether EMI is. Is there anything in this document or any signed agreement, any non-compete that prevents EMI from continuing to conduct business while House Music Productions has existed?
No.
Is there any agreement that's prevented House Music Entertainment from continuing to conduct business since the creation of House Music Productions?
No.
So EMI and Home free to do within certain bounds pretty much anything they want?
Correct.
Thank you. No further questions.
So we're in a slightly loose procedural posture. Do you have any whatever you were doing with Mr. Ladd?
Yes, Your Honor.
Okay.
Yes.
On cross, you said that you could pretty easily figure out which equipment you contributed or EMI contributed to House Music Productions. How would you do that?
By looking through the list.
Just based on your memory, this is what I contributed, this is what I didn't.
Correct.
No documents from the time that you made this contribution that would show what you did and did not contribute.
As far as equipment or finances,
Equipment.
I mean, I have receipts for the gear that was purchased.
You would have receipts for all of the gear that was purchased.
Correct.
Okay, and some of it, most of it, I believe you testified, you contributed to House Music Productions.
I don't understand your question. I'm sorry.
Yeah, so you have receipts for all of the equipment.
Mhm.
That's not the issue. The issue isn't whether you purchased it or you have been entitled to the equipment. The question I'm asking is, how would you determine which of those things that you purchased and have receipts for did you give to House Music?
I'm gonna object on relevance. The
Yeah.
fact of the matter is your initial contribution was equal regardless of what the piecemeal gear that was given at the time of formation was.
So I don't know that that's the fact of the matter. You say it is, but I'm going to let him explore this. I appreciate that there's that document that says we're each contributing $2,100. And you argued through your question that that means both sides agreed that whatever it was they contributed, it equaled $2,100 in value. I don't think that's what capital contributions are. So I'm going to let Mr. Paskey explore this a little further.
Can you ask the question again, please?
Yeah, so my question is, of the things that EMI purchased and has receipts for,
Mhm.
how do we know which of those things it gave to House of Music Production?
I do not know the answer to that.
So it wouldn't be very easy.
Correct.
With regard to the masters, 2023 masters. Was there ever a time when Mario was supposed to go, Mr. Auda was supposed to go and project manage that? You were instead supposed to go to the Final Four in Texas?
There is a position with a company, with a different client by the name of Kelly James that Mr. Auda had worked for the year before in Augusta during the time of the Masters. And that's what we were going to send him out to do.
Okay. Was there a time when you were going to do the Final Four in Texas?
According to the scheduling, there was a time where I was supposed to be in doing the Final Four in Texas. Yes,
Okay, that's at the same time as the masters.
it was. They ran.
Was there a discussion about switching the two of you because it would be a better fit?
I don't know if it was discussion. I was informed.
Okay.
There was no discussion involved.
So on one hand, you're telling the court that these masters jobs were EMI jobs, but there was at least some period of time where Mr. Auda was going to manage the masters jobs.
I think you might be confusing the Masters with the actual clients. There's a number of different clients that make up the events that happen during the Masters.
I'm glad you brought that up. Let's bring up the actual event, the Endeavor House.
Okay.
The big event that you did.
Okay. Okay.
I'm asking a question. Is that the biggest event that you did at the Masters?
Yes.
Okay. Did House of Music Production do an Endeavor House event in 2022?
Yes.
Okay, so different client, different name, same event.
No, each event is different.
Okay, so there was an Endeavor House in 2022. That was House of Music Productions client. The Endeavor House in 2023, that was EMI client.
Yes.
Okay. Talked about communication and when Mr. Auda, after he sent his email, he wasn't at the office at all, right?
Correct.
You didn't know what he was doing.
Correct.
Okay. Since this lawsuit has been filed, have you been into the office?
No.
Okay. How do you know what's going on with the company?
I touch base with the employees that work in the warehouse and the front desk on a daily basis.
Okay.
I monitor through the inventory control system about upcoming events. And I speak to all the other employees and project managers that are involved on a regular basis to make sure that things are.
You still have access to at least view the bank account, not write checks.
No, I do not.
Does QuickBooks have a feature that shows you what the balance of the bank account is?
It does.
You have access to QuickBooks?
As last time I checked, which was probably 2 months ago. Yes.
The last time you've been on QuickBooks is 2 months ago?
The last time that I checked.
Why have you been off QuickBooks for a couple months?
I haven't even tried to access it.
Why?
Once this lawsuit was started, I was unsure of what boundaries were involved in it and to not do anything that would be considered, malicious or anything. I decided it would be best not to access those.
But that's a decision you made as opposed to you shared with me a little while ago, Mr. Auda would say, you can't do this, you can't do that. This wasn't Mr. Auda saying you cannot check QuickBooks, or even more definitively, your access being taken. So you tried to log in, access denied. That has not happened.
That has not happened.
You've decided, and it may be for a very good reason. My fingerprints aren't going to be on QuickBooks right now.
Correct.
What about the billing software for House of Music Productions? Do you still have access to that?
I do.
You can still check that.
Correct.
You can do all these things without ever being in an office.
Correct.
Are you still in regular communication with Mr. Bicknell and Mr. Auda?
I am not.
Have they emailed you?
Yes.
And do you respond?
No.
Do you communicate with them at all, phone, text message, any other way?
No.
Okay. Do you have access to read the emails that are sent to Mr. Bicknell and Mr. Auda?
No.
Don't have access to all of the company's emails?
I'm assuming I could. Yes. I control the domain for the email.
Okay. It's your testimony that you haven't looked at anybody else's emails since you filed this lawsuit?
No.
That is your testimony?
Yes.
Okay. That's all I have.
All right. I think we're done now with Mr. Paskey's presentation. Mr. Jackson, what do you want to present?
I am going to call Mario out at this stand.
All right, Mr. Ladd, you'll probably be back, but thanks for being in the chair. Mr. Auda.
I'm going to ask you the first question, and that is, I don't remember which of you, it may have been Mr. Ladd, described Mr. Bicknell's role as more of a mentor, but not a day-to-day, let's make sure things happen. What role, if any, does Mr. Bicknell have now?
He is our main salesperson. He does most of the sales. That's what he brought to the table when we bought Tree Productions out.
Okay, sales is in, he's out there trying to gin up more business, or if people call, get the phone to Lee, because he's the guy you want talking with the client, potential client.
A little bit of both. It all depends sometimes who calls. If it's a client that I have dealt with, I don't send them to Lee. I
Right.
deal with it, then I bring it to the table and we discuss the job.
But in terms of bringing in new clients,
So he brings in a lot of new clients and he's also very familiar with all the old clients that he's brought to the table. So he deals with most of them. And then we assign either myself or Jeremy or even one of the other employees to manage the job.
okay. So the true clients, as best you can tell, merged into House of Music Production. And then Mr. Bicknell obviously is the point person for his former client. They're still his clients. It's just under the House of Music Production umbrella.
Yes.
Thank you.
Mr. Auda, I'm just gonna ask you one quick last question about the operating agreement, just to kind of clear up, this kind of distinguishing between property being given to the company and cash being given to the company. Can you please read what 1.4, I'll represent to you that section 1 is all definitions. What section 1.4 says of the operating agreement?
This capital contribution, any contribution to the capital of the company in cash or property by member whenever made.
So property can constitute capital contribution as well.
I think so.
And at the time of formation of the company, you agree that the time of formation of the company, how was the split of ownership percentage between yourself and Mr. Ladd via your respective companies?
50-50.
Perfect. Thank you very much. How much money is currently in the House of Music Production bank accounts?
I don't know the exact number.
Do you believe there's enough to cover payroll?
I believe there's enough to cover payroll for the next 2 months until we add some more money to the account.
So if there's, I'm gonna bring up another exhibit. You actually produced this during your discovery.
While he's bringing that up, you think that there's enough in the bank account or bank accounts to cover 2 months of payroll. That means you must have a rough idea of how much is in the account. What would that rough idea be?
So the
We don't
rough
need,
idea, I can tell you the exact amount of number if I look it up and tell you a number, but I don't know the actual number because we do have checks out there that haven't been cashed that we sent out. So it's a low number. I would say we probably right now in our savings account have $35,000, which 65 of that or 62 of that was an SBA loan that we were using as a line of credit. So we left it in our savings account as a line of credit. It came to us through a PPP SBA loan, which was 3% over 30 years. It was a no-brainer. We couldn't get a line of credit. So this is what we used a line of credit for. And now I think we have about maybe 35. I'd have to look at the numbers. They change every day. 35, 40 grand in the bank. Our payroll is about anywhere from 15 to 25,000 per payroll, depending on how busy we are and how not busy we are.
what does that translate into in terms of headcount? How many people work for House of Music Productions, not including you, Bicknell, or Ladd?
So technically, I don't believe myself, Jeremy, or, well, I guess we do, but we're contracted work. As far as employees go, we have about 6 or 7, I'd have to count them up, 6 or 7 or 8 employees that are full-time with us. And then we have contractors that do a lot of work with us that we use, mostly the same, but we have all kinds of contractors that we use.
You can flex up, but in terms of permanent folks, when you're thinking about, gosh, we have to make payroll, that's referring to less than double digits?
I'm also referring to the contractors when I say payroll, because they are part of what we consider payroll. If they do an A1, which is an audio one engineer, they get paid a certain amount. I'm including that in the payroll speak that we're talking about now, although they're contract work.
They get paid if they are working on a project, or you have them on some kind of retainer where they get paid whether you deploy them or not?
No, only the employees get paid whether we deploy or not, but they are to come in and work their hours at the warehouse.
Yep.
Or at the office, or do their duties.
Okay.
So you say there's low 10,000, so that 10, 20, 30, 40, somewhere below $50,000 in bank account, give or take?
Well, if you add up all the accounts that we have, the payroll account, the savings account, and the checking account, the operating account, I'm gonna make a guess that we have 50, 60,000 in the bank at the moment, but that's not the count for the checks that are written that have not cleared the bank yet. And that's also not to account for a lot of the bills we have that we're purposely not paying so that we can make payroll.
And so you and Mr. Ladd currently work for House, perform work with an employee and a contractor, perform work for House Music Productions, is that correct?
Yes.
Okay, how does pay normally work? Do you pay yourself, or I guess, as I understand it, the money flows through House Music Entertainment and then to you, but who authorizes the payment from House Music Productions to House Music Entertainment, and likewise from House Music Productions to EMI?
So prior to the members meeting, Jeremy paid himself out and he paid myself out. He knew how much I was getting in, but I had no idea what he was getting. That partially could be my fault for not asking him for it, but we used to approve each other's. After the meeting, we made sure that I approved his payroll and he approved my payroll. He's the one that hit the button that paid both of us. So I would approve and sign his payroll. He would approve and sign my payroll. In February, when he said that we stopped paying him, he's the one that came to me, which isn't something that we haven't done before. We've done it plenty of times. When we are looking to reserve some money to make sure we can pay our bills and to make sure we can make payroll, we sometimes don't pay ourselves. That's the back pay that I got paid back in 2021 when I asked for the $15,000 check that he had paid himself off without approval. So I approve his, he approves mine, he pays us both through bill.com.
So as part of, make sure I understand this correctly, you approve his, he approves yours, and then Jeremy, as part of his bookkeeping obligations, presses the actual button that distributes cash?
Yes.
Okay, do you need two people to press the button to distribute the cash?
No, I don't have control of bill.com.
So I am going to share my screen to show you the exhibit. Are you familiar with what this document is?
Not exactly, no.
You produced it during your discovery responses. In fact, it has your date stamp at the bottom.
So this is something I had accounting print out for me, and it looks like probably what we've paid EMI from bill date 2/26/23 through
I believe it goes reverse chronologically down.
all the way from 11/25/19.
Right. So would you agree this shows every payment ever made to EMI?
I would think so. I think it would be in there.
So if, as you just said, Mr. Ladd is still working for EMI, why hasn't he been paid? You also said you're the one who authorized this payment. Why hasn't EMI been paid for the services performed by Mr. Ladd?
Since February?
Yes, you said this represents.
Because he
every
asked me not to pay ourselves because we needed to keep money in the bank. It wasn't until he stopped coming into work that he complained that he wasn't getting paid. Furthermore, he never approved,
Let him finish his
he
answer.
never approved any of my payrolls. And I didn't approve his. He stopped coming in. We had no communication. He would not communicate with us. He told us he was going to work from home because he didn't want to get divorced. Next thing I know, I got served papers, and that date, from then on, he never communicated to me again.
So it's your contention that since February 26th, Mr. Ladd is not authorizing your payment
That is correct.
and you're not receiving payments? since
I
February
think that the
26th?
first time I found out about an authorization was through you and through Kyle Pesk. At the moment, we were barely able to make payroll, much less pay our bills. We were late in paying all our other bills. We were counting on the money from the Masters, Heiko. I mean, there's a half dozen of events that we equal up to be about 200 to 250,000 that should be in our account. Had I had that money, I would pay him everything that he worked for. Not to mention, we don't know what work he's doing. He's not communicating with us, but he's clocking in. We don't know what he's doing. He's clocking in, he's doing the business for the Masters. He's wanting me to pay him for his payroll for setting up the Masters, but he doesn't want to pay us for what I have to pay him for on the Masters. It's probably $5,000 worth of payments that he spent putting together the Masters event. I mean, it takes a lot of hours. House of Music, that's part of his payroll. We're paying him to set up House of Music's events with the Masters. And he's not paying that back to us, and he's just collecting all the money.
Do you have any documents to support that? The reason I ask is Mr. Ladd's testimony during your counsel's presentation of evidence was that he hasn't billed House of Music Productions a penny for his time spent on the Masters. And so now you're saying he has been billing.
Well, you
there
can
wasn't
see,
provision to discovery.
Wait till he's done.
sorry.
We didn't get anything showing this produced discovery. You had a litany of invoices, none of it showed that. Do you have any documents to support the contention that Mr. Ladd was billing House of Music Production in connection with his labor for the Masters events?
Yes,
You?
it clearly shows that he was working for House of Music and he was coming into House of Music, and we were doing business with the Masters in January from that one document. One of the estimates was written up in January of 23.
Not already provided. Can I have you all supplement your discovery responses to include
That
that?
he's referencing an exhibit that's been tendered at this hearing.
So it's in it? Which exhibit are we referring to?
I believe it's the Endeavor House it's one of the Masters invoices or estimates that we put out. He's been working on the Masters since January. He didn't work on the Masters a week before. He worked on it throughout January. It's a pretty big show. He's been working on it from January, February, March.
Share that document real quick.
They're gonna
Yeah, I can scroll through this. I'm just asking to scroll through and I'll scroll through it. I wish you could control it. Can you show me where on this document it says that Mr. Ladd was charging House Music Productions for his time in relation to the Endeavor House?
I could show you that we paid him fully for the hours that he worked at House of Music in January, February, up until the last date that we didn't pay, right? But it's still on his payroll sheet. I can show you that he was working on the Masters in January and February.
And so there's a difference between him working on a project and him billing House of Music Productions for that. And we understand that, he was getting paid up until February 26th. Masters didn't happen until March or April.
Well, this also doesn't show all the pre-work that we had to do and then all the takedown work that our office and our warehouse with our employees did.
And, that wasn't brought up during your council's presentation of evidence, but we will say that, you said that he's working, and then you said he was billing, and you seem to come back on that notion that he was billing House of Music Productions. And so on that extent, I'm a little confused. You said you paid him, but then you said you haven't paid him since February 26th. Masters didn't happen until March or August. Please help me make sense of this.
Let me see if I can help you make sense. EMI we never did business with EMI with House of Music Productions going back and forth where he was charging us. The entire time that we had this master's agreement, it was a House of Music production. It wasn't until 3 weeks after the masters happened, we found out that he billed them through EMI. That was 3 weeks after the show.
So you agree, he billed them through EMI, he's not billing House of Music Productions for its labor.
I agree that he billed the client fully with EMI and then turned around and tried to pay House of Music some of the expenses.
The question was that you said that you had documents showing that he's charging House of Music Productions labor. Your counsel said it was already into evidence, we brought it up, wasn't on that document. We didn't get it in discovery.
Okay, if you pull the document back up, we don't need to go around in circles on this. There is a unit of labor entered. That is the least particularized bill I've ever seen. There's a figure 9,000 something, and it says labor 1, equipment 1. So I presume that means there's some unit of labor that makes up that $9,000 figure. So there's some bill for labor, whether it constitutes Mr. Ladd's labor or not. I think that's where you may get some traction, but
Can you definitively say that that labor on that item was Mr. Ladd's labor?
I can't definitively say what he has done with this job. This job was a House of Music Productions job, and then after the job took place, it became a EMI job. I would still like to see if there's any way we can show where House of Music was doing business with EMI taking House of Music's clients.
But anyways, so you said Mr. Ladd has performed work. You said that, you know, you have 2 months of payroll, $30,000. Why haven't you authorized the payment?
We don't have the money. The money is in his account. Why would I pay him when he's taking our money? And not to mention, we don't pay our employees. We don't have a company. He has done very, very well trying to paralyze our company of having money in the account. And it's working pretty good. We had to dip into the $63,000 SBA loan just to make payroll.
So your contention is there, despite previously saying there's between $30,000 and $49,000 or all expense, dollars in the bank accounts, you do not have the money to pay him.
As of right now, if I pay him, I will not make payroll for the next 2 months. Matter of fact, I have not paid myself either. If I paid myself, we wouldn't be able to do that. If we had the money from the jobs that were taken from us, we would be able to pay everyone and have enough to do and operate business and continue to buy new equipment and continue to move forward. He has paralyzed us to a point where we can't buy new equipment. We can't really go out and do these things because we don't have the money in the account.
You don't have the money to buy new equipment?
Not at the moment. We have the money to buy what we need to for the jobs that are coming up.
So I am going to show you this. Do you recognize this email?
Yes, I do.
Did you send this email?
I sure did.
What date did you send this email?
I don't know. Sure, it says it right here, June 10th, 2023.
That's 2023. So this is, you know, well into this litigation. I believe these injunctions have been filed. This hearing itself might have already been noticed. Now, you just said you didn't have the money to buy new equipment, and now you're emailing somebody, hey, we're considering buying new equipment.
So this email right here, I never gave to Jeremy.
You have it, it's not privileged, so you don't have to give it to him.
well, let's not get into it. You don't get to ask him questions. Your lawyer may be asking him questions.
I don't know where this
Do
could
you
have
agree to
possibly
this
have come.
email?
But yes, I do agree to the email.
How much is one X-frame light for? It says here these are Clay Packy brand. How much is one X-frame light?
$6,000.
One X-frame light is $6,000.
Correct.
So this is roughly $136,000 purchase. I just did that math in my head, I might have messed it up, but somewhere around there,
This is-
$136,000 purchase.
This is not a purchase. This is an inquiry. I had a client come to me asking me to purchase 24 X-frames.
What client?
I have a client that came to me that said they had used X-frames
Mhm. And that's why you're purchasing used ones from the dealership?
No, I called the dealership to find out how much a brand new X-frame costs. They don't give us price sheets. So you have to call for every item from this client to find out how much they cost. I don't have a price list for clay packing. This is how we do it. There's nothing wrong with me inquiring about finding out how much 24 X-frames cost.
So I'm trying to make sense of everything. So you say, we don't have the money to pay people. We don't have the money to make equipment. However, for whatever reason, you have the liquidity to middleman, roughly $130,000 purchase equipment.
No, it was going to be a $25,000 purchase. I wanted to find out the difference between a used light and a brand new light.
You have the liquidity to make a $25,000 purchase.
No, we didn't make the purchase.
You said you were trying to make a $25,000 purchase.
No, we inquired about it. When somebody asks me, hey, what would it cost to get this? Somebody else came to me saying, I've got that very light at a used price. I wanted to inquire to find out how much a brand new price was to compare the differences.
So, okay, your testimony right now is this was an inquiry, and despite what it says, there was no intent to actually purchase the lights.
I was never intending to purchase any of the lights brand new. And if the deal with the used lights would have come through, I would have brokered that deal through House of Music Productions.
So you weren't going to be the buyer or the seller. You were going to connect an interested customer with the seller of used, and you wanted to be educated on how much of a discount is really being had here.
That is correct.
And so we've also had a couple statements about liquidity issues and what's the cause. What is your contention? What is your assertion of why House of Music Productions is currently, despite all the other testimony that we just had, is having solvency issues?
No, there's $200,000 to $250,000 missing from our account.
And I'm assuming it's your contention that it's solely because of Mr. Ladd that you were having insolvency issues?
Well, that, and we're also net 60 or net 90 with one of our clients that we normally have to pay out in front and then wait 60 days after the show. So we got paid for the final 4 on June 10th, I believe it was. To make that payroll was not an easy thing to do before we were collected that extra 110 grand that we collected. And now it's starting to swindle down because yes, 250 grand in our company is a lot of money. And that's what is missing from the shows that Jeremy was tasked to manage and all of a sudden became EMI shows.
And so I want to ask you about management prior to this whole spat. So am I correct to understand that Jeremy managed the clients, you managed the clients, that's kind of how the show's run?
Kind of.
Kind of. Specifically, what clients did you manage? You run off a few, you don't have to give them an exhaustive list.
So the World of Coke is not really a client, but they are. The World of Coke refers their clients to us. I handle most of the World of Coke accounts.
Okay, so let me, okay, I got you. We can move on from that. You handle most of the World of Coke accounts. Okay, that's just one. Can you add another?
Well, there's several of them. I have to sit here and think about which clients I
District.
usually am taxed with.
District, your client?
District's one of my clients. He took over the payments from District about a year ago. He decided he didn't like the way I was collecting from him, so he's collecting money from District.
So the record's clear. He is Mr. Ladd.
Mr. Ladd, which they still owe us $25,000 that
That's
we
what I wanna
collect
ask you
slowly
about.
from.
And so when, District comes like, hey, we have a new event. Actually, sorry. I understand what District is. I know what it is. I'm sure these people do. The court might not know what District is. Can you kind of just give a brief explanation of what District is as business?
District is one of the largest dance clubs in Atlanta, Georgia, that we did the install for. District is somebody that we do the install for, and then they call us to come and do production for. Sometimes production is just hiring one of our lighting technicians to come and operate their lights. Sometimes they hire us to come fix broken equipment. Sometimes they hire us to install more equipment. But what they also do is have referred us to many, many other clients that we've done business with. So district itself isn't a super high profitable client, but what that client brings us in turn is a lot more production and a lot of other installs.
And so you handle districts, everything else, and Jeremy just handles billing collections?
Sometimes he's handled both. We've both kind of tag team it in the last year.
Okay, and then, so is it, nope, that's what's small. Is it normal for when a client doesn't pay their bills for years on end, for you guys to continue to provide services for them?
Sometimes, yes. So as of last year, they paid in full. They had paid in complete full, I think it was June of 22. And they came back to us for an install. Jeremy helped head this project when we put in 30 new lights and a whole video wall. Jeremy actually contracted the video wall sale to district. Now, this is once they finished paying us, they owed us $0. He was in charge of selling them the video wall at that point. He was in charge of helping out and figuring out which lights we were putting in there. At no time did Jeremy say, we do not need to do business with district anymore. And not to mention that district brings us a lot of business. So yes, sometimes the bad way of saying it, you take it so that you get more. But yes, it's been a frustrating customer of ours, or client of ours, that they never pay on time and we have to chase them down to get paid, but they have been making payments.
And so.
And it was his job to go after them to collect those payments.
And so with district specifically, you said they came current June 2022. Did they stay current?
No.
You know how much they currently owe House Music Productions?
About 25,000.
I would agree with that number based on this document. And so this didn't accumulate in one instance. How long has this been accumulating since?
Since we did that install
About a year. About a year ago, is that correct?
about a year ago.
About a year ago. And so at the 6-month mark, you know, at the 6-month mark, if you were, you know, see that they're behind again, let's just split maybe divided by 2, call it 12,000 behind. I'm not saying it's necessarily the exact, you know, path of the invoice stuff, but why did you continue to produce work for them? And you just said they were a frustrating client.
I wasn't the only one doing work for him. Mr. Ladd was doing work for him too. He took the calls. He speaks to Rich Stein, who's the manager over there. He does business with them as well.
You have a personal relationship with Rich Stein?
Not really. I just know him through the owner of the club that I knew before,
Who's the owner of the club?
Donnie Wallach.
You have a personal relationship with Don Waller.
I mean, I knew him from the past. That's how he knew me to call me to come do his install. He used to own a club called Cuckoo Room. And he's also a builder, a contractor who builds clubs and he builds restaurants. He refers us to all those clients.
Have you ever loaned him money?
Yes, we did loan him money.
Have you ever personally loaned him money?
I personally loaned him money because the company couldn't loan him the money. This was when we were doing the initial install in 2017.
This was House of Music Entertainment.
And it was House of Music Entertainment.
Why couldn't House of Music Entertainment loan him money?
Well, because they were behind in making their payments.
Okay, and this is your company, correct? Okay, and so you loaned him money. Do you recall the payment term of the loan you gave him?
Objection, Your Honor. I don't think this is relevant at all. I don't see the relevance, at least.
Okay, tie me in with the relevance. We seem to be straying a little bit from
So
the issues.
We're on direct and we're addressing our, injunction.
Mhm.
And we're showing that as, manager, there's self-interested transactions that he is occurring, including those related to district, for establishing personal relationship between the owner, a history of dealing between the two involving money lending, and just the insolvency of home where the money troubles with home where it can loan money, so you have a personal loan. Might go to the fact of why you still make these decisions to continue to work for district, despite the fact that they're not a paying client.
Okay, you can keep going.
What was payment term on the loan that you made to the owner of the district?
I can't tell you the exact payment terms, but I can tell you why we had to make this loan. So in 2017, we started to do the install. I'm going to get to it.
I don't know what you mean by we. This is pre-existing House of Music Productions.
House of Music Entertainment.
But you said you
along-
personally made the loan, not House of Music Entertainment.
I will continue. In order to start this project, we purchased a sound system that was $110,000. We had to put $30,000 down. They gave us the $30,000 to put down for this equipment. When it came time to make the finished payment on it, I believe at that time, the owner of the club could only come up with $50,000. They had a stop build permit on their place. They could not build any longer. They had a stop build permit for a whole year. Mr. Ladd and I consulted. We said, do we just want to throw $30,000 out the window? It's the client's money. We could throw it out the window, or we can take the $50,000 they gave us and pay the rest off and keep the equipment until they pay us for it. And that is exactly what we did. We didn't necessarily loan them. They owed us money. And I had to take money out of my own pocket to secure the equipment so that the equipment we wouldn't have lost the deposit on the equipment.
So I don't think, I'm not trying to be difficult, I just think that there's a lot of pronouns being used, with we and they and them and us. Where I'm a little confused about the dynamics of this loan. You say they didn't owe us money, yet you're loaning them, maybe using more proper nouns, kind of walk me through that process again.
So we had the equipment in our warehouse for 1 full year.
We being,
House of Music Entertainment at the time in 2017, because it didn't become House of Music Productions until 2019.
You say the equipment, what are you referring to?
the $110,000 sound system.
$110,000 sound.
Belong to House of Music.
At the time, it belonged to House of Music Entertainment, but district put a down payment on it.
You're selling it.
We were selling it. We bought the equipment to sell to district. When it came time to collect the money after we put the deposit down on the equipment, he didn't have the money to give us. So Mr. Ladd and I had a discussion and we said, why don't House of Music Entertainment at the time pay off the equipment and we will keep that equipment and use it until we do the install. And that is exactly what we did. We used that equipment.
When was the install?
The install was completed in 2019.
So why would you talk to Mr. Ladd about what to do with the equipment? It sounds like that was before House of Music production came into being.
Because at that time, Mr. Ladd wasn't doing productions really with EMI. He was using EMI for his DJ company, where he was performing services for DJs. Most all of the production was done through House of Music Entertainment.
So he was a business associate, maybe not a partner in the sense of he
That's
owned
correct.
part of House of Music Entertainment, but he was a business associate and you wanted his view on whether to outright buy the equipment, hold on to it and use it until district could afford to buy it.
That is correct.
It was not a House of Music production decision. All these things we decided, it was ultimately a House of Music Entertainment decision with some input, not coincidentally, I guess, from Mr. Ladd.
Yes.
Okay. So that's seeming a little less relevant now. It's not even a House of Music production thing. So accelerate to tying it into post 2019.
Okay, 3 questions for you real quick. So after January 1st, 2019, did Mr. Ladd continue to provide any services to House of Music Entertainment?
No,
After the loan agreement deal transaction, however you want to classify it, with district was not completed until after, and final payment not received until after January 1st, 2019.
that is correct.
earlier today that you stated that House of Music Entertainment has not had any transactions come to it except from House of Music Productions since the formation. So how does that work?
It works as in, I transferred all the jobs that we had from House of Music Entertainment to House of Music Productions. That job was an in-between job that started before House of Music Productions. And I don't believe we ever collected from House of Music Entertainment. Jeremy gave me a $15,000 check that came straight from district to pay off some back pay that was owed to me. That was probably in 2020 sometime. I don't know, remember exactly when it was.
So as opposed, so you have 2019 transaction, now you also have 2020 transaction that House of Music Entertainment took part in.
No, it was a payment from House of Music Productions to House of Music Entertainment. At no time was I running House of Music Entertainment as a business anymore.
Said it was from district just a second ago.
I don't know where the check came from. It either came from district and went into our account, and then from the account, it went into mine. I was owed back pay, and this is how we were paid the back pay. But there, no time since we started House of Music Productions has House of Music Entertainment conducted any business other than what I was paid from House of Music Productions.
I'm gonna ask you a couple questions. I'm gonna move along. Next, I think we beaten that one. Yeah. You raised some allegations in the brief about the Grady. You said you spoke to Grady and they said they had signed a contract with EMI.
I spoke with Grady because I was afraid that was going to be another one of House of Music Productions job changed into EMI. At this moment, I still don't know if it is or not. And what was in our system, I sent it off to Grady as an invoice to be paid because I thought collecting some of it would be better than collecting none of it. I could not trust Jeremy at the time that he was going to keep it a House of Music Productions event. I still to this date don't know. We haven't been paid.
So I'm gonna ask you questions about that. So you stated in your affidavit that that Grady told you that they had signed a contract with EMI. Now you're saying you don't know, and your discovery responses, and which I'm sharing on the screen right now, you actually produced the contract for both 2022 and 2023. I'm sorry, I'm lost in this thing. For both 2022 and 2023, clearly showing that this agreement was entered into on behalf of. Sorry, bad Zoom.
Your Honor, while he's pulling that up, I would just object to the question to the extent it mischaracterizes what was stated in the affidavit. And, if he wants to read the paragraph from the affidavit, then that would cure my objection. But my objection would be that he misstated what the affidavit said.
Okay, we'll need to, why don't you read what's in the affidavit? What paragraph?
22 through roughly 20, 24, 22 through 24.
Is that something that,
It was attached, I think it is exhibit 1 of their initial defendant's motion for temporary restraining order and interlocutory motion for receiver.
I think I have it. 22 starts with additionally on May 4th through 6th. Okay. Okay. So I've read 22 through 24.
I'm having trouble pulling it up myself, Your
Okay.
Honor, right now.
It's out there. Yeah, we hope you have it. It's your client's, David. I can put it up on the screen.
I got it now.
Okay.
So you said that you reached out to them. And
Them being Grady. Them being Grady. We took a little break here. So them being Grady.
You stated that you reached out to Grady. Grady told you that they signed a contract with EMI. In your brief, you specifically single out this event and say, we have no contract, we don't have anything. Yet in your discovery responses, you produced the exact contract. And it says Jeremy Ladd, House of Music. Where did your belief that EMI had taken over this event, given that you had the contract? The other, Brady spoke to them allegedly, but where did your belief come from having this contract that EMI had taken over this contract? This event?
I don't know if I stated, and maybe I did, maybe I misstated. I can tell you that since March, most of the jobs that Jeremy has been working have all changed to EMI jobs and have not been paid to House of Music Productions, which was a House of Music production client. All of them were House of Music production clients. And I don't think we've collected from one of them. I had to go back and collect one from March that he stopped collecting from. I went back to them. I don't know what dealings he made. I don't know if he sent them something from EMI or not. All I know is that we did not get paid and he's not making an effort to collect in a timely manner.
So there's some allegations with invoicing. Do you dispute at all the fact that you sent Brady one or multiple invoices?
I sent them an invoice shortly after the event, after finding out that the Masters event had changed. That was the first time I realized all of a sudden, all our clients were being stolen by EMI and changed to an EMI client. So in following, I didn't, when I was first looking for Grady and sent them the invoice that we had in our system, I didn't know, or I hadn't found this contract yet that was signed by Jeremy, owner, CEO.
Has Grady ever explicitly told you that, hey, this is actually an EMI event or anything of that nature?
Not that I know of. I've
Why
spoken
in
to
your
many.
Don't let him finish.
I have spoken to many clients over the course of this and spent a lot of time trying to find out what Jeremy has and has not done. With the Aviation Hall of Fame, it was a House of Music Productions. I go to collect the money from them. They said, we handed Jeremy a check a month ago. I said, oh, can you send me that check number? Because it's not in our account. And lo and behold, it was written to EMI. So you tell me why I wouldn't be thinking that all the rest of them are changing to EMI.
So if you reach out to, if Brady has never explicitly told you, hey, this is an EMI event, from what I understand, they've never even alluded to that fact. Why didn't you have a sworn statement saying, I reached out to Brady, they told me it was an EMI event? That's a lot of the reason why we're here today is one of these issues. Because you said we need an injunction, this is what Mr. Ladd is doing against us. Now, there's inconsistencies in your affidavit, there's testimony in court. I'm just trying to make sense of it.
I reached out to 10, 12 different clients, maybe.
I'm not talking about those clients, I'm talking about Brady.
So I don't know. I don't know if I got confused with this particular one. We still don't have the money in our account. I don't know what he's planning to do. He's not communicating to us. He's not letting us know that he's trying to collect the money. So I am trying to be proactive and go to these clients before he's able to change it into an EMI account. And that's what I did with this one. I did not get to the Aviation Hall of Fame quick enough because when I called them and they told me they wrote the check out the House of Music, I had to call them back and say, it's not in our account. He goes, well, it's been cashed. It was cashed on May 3rd, but it's written to EMI.
Has Grady ever told you that they have already issued payment to EMI or some other party for this?
I don't believe so. I don't know if they've issued out payments or not. I don't know.
To your knowledge, does Mr. Ladd work for Grady?
He worked for Grady last year
Is he
under House of Music Productions.
Is he an employee of Grady who deals with their finances?
No.
Does he have, to your knowledge, does he have any ability, short of taking legal action, to compel Grady to make payments?
I don't understand the question.
Without filing a lawsuit against Grady, does Mr. Ladd, does he work in their internal operations? Does he do anything that can compel Grady to make payments?
Yes, he collects payments from our company. So he can call them and say, hey, we need to get paid. I haven't heard an explanation of why we haven't been paid.
Well, I'm going to go back to this exhibit where you have, I'm gonna ballpark a number, at least 100 people that haven't paid. Why hasn't Mr. Ladd compelled all these people to pay? Is it because he doesn't work for their company and he can't control their bank accounts, short of suing them?
He is tasked with going after some of the clients to get paid. I am tasked with going after some of the clients. Accounting's tasked to go after all the clients to get paid.
Why haven't you gone after it then?
What, Grady?
Or any of them?
I did try to go after Grady. He's not communicating to us. We have no idea what he's doing.
I think you're missing the point of our question. What I'm trying to say is, can Jeremy Ladd sign contracts on behalf, can Jeremy Ladd sign checks on behalf of Brady, the vendors, whoever that may be, whether it be
No, I don't think so.
PvP gear or whether it be a vendor at a do the Brady event?
No.
No, all right. No further questions for this witness.
All right. Mr. Paskey, do you have any questions?
None.
Okay. Thank you, sir. I think you're done on the stand for today. So why don't you stay right there, Mr. Jackson? Do you have,
Oh, yeah, I was just showing the paper.
okay, shuffle all you want. Should we get Mr. Ladd?
Yeah, I'm gonna call Mr. Ladd.
All right, come on up, Mr. Ladd.
Yeah, hopefully we should be.
All right, Mr. Ladd, you remain under oath.
Yes, sir.
2 seconds to get set up. I think it's gonna go a lot faster.
Okay.
Okay, this is gonna be real short.
Famous last words.
Hold you to that.
Right? On our side, it'll only take 30 minutes. Anyways, so I would ask you. Did we talk about the masters? Did we talk about the masters on cross? Yeah.
Yes.
Step in, we've already gone over this. I'm sorry, it's been a long day. I want to ask you about the masters then.
Okay.
Who hired you for, how was House Music Production hired in 2022?
They were hired through Liz O'Connell and on location.
And then did Liz O'Connell at On Location work at On Location for 2023?
No.
So this we've covered and
Yeah, cover this.
yep, it wasn't on location anymore. It was, that's how Nick got in the mix with Century.
Correct.
I believe we are good to go, Your Honor, actually.
Okay.
That's questions, because we've addressed everything.
Okay.
Cross.
I have a couple questions and they are within the scope.
No direct.
You asked a question about the masters. I got a couple questions about the masters.
So before you guys talk over each other, this is sufficiently informal that I don't mind that Mr. Paskey is going to ask a few questions. You'll have a chance to follow up after that. But you did ask him a question and he started to answer it. And then I let you know that we actually had heard that answer before. But you called him. I reminded him he was under oath. You got at least one question in under your belt. It was could have been objected to as asked and answered. It wasn't. So Mr. Ladd is available for examination by counsel for Mr. Auda and House of Music Entertainment.
Mr. Ladd, about the Masters event, you mentioned that there were some equipment that you got through House of Music Productions to complete that work in 2023. Of the equipment that House of Music Productions did not have, who did you rent it from?
A company called AVL out of Jacksonville, Florida.
Okay. Did you use an EMI account to rent that equipment?
I did.
How would you explain the fact that House of Music Productions received an invoice for that equipment that you used at the Masters?
They must have incorrectly billed them. I informed them of that after they sent the invoice.
Okay, so your testimony is that you didn't use the House of Music Production rental account to get the stuff that House of Music Production did not have.
Correct.
Okay. Whose insurance did you use to submit to the cross vendors to show that the equipment would be insured.
EMI,
So EMI had coverage on that
correct,
policy, and you submitted that to the vendor.
correct.
One more question. This does go outside the scope, so I'll just warn you.
I'll wait to hear what it is.
In your attorney's direct examination of my client showed an email, exhibit.
I'm gonna check the fact that he's talking about his clients, my direct examination of his client where he waived his cross.
All right, let's just see what the exhibit is.
It was an email from Mario to a third party about purchasing equipment. Do you remember that?
This was the lights,
Yes.
the 24X somethings.
Yes, with the, I think you have a better grasp on the model number than I do, but, it's exhibit 11, so plaintiff's exhibit 11, and I'm gonna try to share it here. But I don't know if I'm still connected.
I'll share it. It'll just be faster.
Okay, I was gonna say I have a paper copy of this, that's helpful. Okay, do you recognize this exhibit 11?
Yes,
Okay, this is an email from Mario, Auda, at houseofmusicentertainment.com to Julie Smith, copy Tyler. How did your attorney get this email?
I'm not sure, sir. I must have submitted it to him,
We're
I'm
gonna
assuming.
maintain our objection until there's a judicial ruling on it.
Yeah, what's the relevance of how he got it?
He testified earlier, he's not looking at my client's email, so it goes to his credibility as a witness. There's no way his attorney got this email unless he accessed the company's email account. You'll see he's not a party to this email. The only way that this is not a forward from somebody else to him, this is the original email. The only way he got this email, which is dated June 10th, is that he was accessing my client's email.
So how did you get this email?
It was provided by a third party.
Okay.
What third party provided it?
I would rather not say.
Your Honor, we're still in the objection. The court hasn't made a ruling on it yet.
Whoa, what have I not ruled on?
Sorry, I guess I just didn't hear overruled or sustained. My apologies. With regards to, this is outside of the scope of direct. He's had his presentation of evidence. This was, when Mr. Auda was up, he had the opportunity to cross. Mr. Ladd certainly was not asked about this document.
No, he may not have known to ask him about it. So I think given the impeachment angle of it, I'll allow it. But now we have a new issue. Mr. Ladd doesn't want to answer the question, who's the third party who provided it. So tell me why you need to make this awkward situation go any further.
Because I don't believe him, and we're gonna have an entitlement to discovery through the rest of this case, and I want him under oath saying who he contends gave it to him if he didn't access my client's email.
Okay. At this point, I'm not going to require him to answer the question. I will remember this point that we've reached, and if you reach a point in discovery where it's not clear, or there's some obfuscation about, who's taking the trash out, then I'm happy to revisit it so that you get an affidavit or something that involves Mr. Ladd taking ownership of it. But we don't need to do that right here. Your point's been made, and we'll go from there.
Thank you, Your Honor.
Okay.
No questions.
I bet. Do you have any follow-up?
I can redirect you probably under 20 seconds.
Okay.
So as Mr. Pass just asked you, there was an incorrect bill in House of Music Productions.
Correct.
Did House of Music Productions ever actually pay that bill?
They did not.
Not perfect. And are you?
Okay,
wanting to
well,
not disclose
before-
the name out of fear of
stop.
retaliation?
What transaction were you just asking about?
The one that Mr. Pask asked about where he rented, or EMI rented beer from the third party in the House of Music Productions.
Got it. Okay. Now-
Do you fear retaliation against the third party who provided you this email that you disclosed their name?
Yes, I do.
No further questions.
Okay. Mr. Ladd, you can step down. Thank you. Mr. Jackson, do you have any other witnesses?
That concludes our evidence. Your Honor.
Okay, great. Why don't we take about a 10-minute break? We'll start at 3:30 with argument from both sides as to what the heck we ought to do to try to salvage House of Music Productions while protecting Mr. Ladd's interests and Mr. Auda's interests. And in theory, Mr. Bicknell's, but he didn't see fit to come here today. So I can't really weigh those quite as carefully as these two gentlemen. So when we get back, I guess, Mr. Paskey, I'll hear from you or Mr. Briskin as to the appropriate relief at this juncture. And then Mr. Jackson, I'll hear from you. I know your motion isn't ripe yet, but that doesn't mean you can't advocate in the course of me structuring some type of temporary equitable relief for things that you think address the concerns you've got. I don't think they're unknown concerns to the defense. And like I said, if you're advocating for something that Mr. Paskey says, well, wait a minute, give us X days to just send you a 5-page something on that, I'll certainly afford them that opportunity. Okay. All right. I'll be back in about 8.5 minutes.
That's why I asked for my emails is really and somebody said, and I said, take something to my personal one, which accidentally sent it to mine the very next day. He calls saying, what the hell is this?
So the only possibility is that this guy Tyler sent it to
He
him.
didn't.
No.
Tyler is now sending all my emails to my personal account.
What they want to argue is that someone internally in House Music Productions gave him that email. Can
Yeah, the only-
anyone else in the company access?
Jeremy's the only other person that
Yeah,
could have done it is
Tyler's
the
on there.
person I sent it to that has no relationship with Jeremy.
And what kind of
And I sent
retaliation?
this purposely, knowing that I wanted Jeremy to see it. I didn't care.
So it has to be, he's insinuating Tyler forwarded it to him. But this, if you'll notice, is not a forward. This is the original email.
It says from Mario Auda.
Mhm.
You got that email from my email.
Well, Kyle, we can always ask for that. So,
Can you not ask? Can you do forensics on the email and see that he's got them forwarded to
I don't think
my email's been forwarded to this?
We can, but that's like a $40,000 endeavor to have somebody do like a forensic search on emails. We don't need to do that. We'll do it.
There's gotta be a way through this. It's reading Caitlin's email. I had her do a powerful presentation.
Hire souls to show who looked at the email. And it's too costly for what we're doing.
That is basically what we're asking.
Yeah. Well, it was very not clear. There was nothing clear about it. I don't even know what happened. Put my freaking exhibits in here. I was looking for that affidavit in here and she smartly left out all the exhibits because it wouldn't have fit in the binder, but I was like, where is it? So that's why. Not to pile on you. The only thing that's been really hurtful today is the affidavit not turning out to be true. Which one? When we said that you called Grady and Grady said that he had signed a contract with EMI.
Well, I don't know, you may have.
Right.
I
No, but what we
may
know,
have gotten that confused with one of the other jobs.
I'm just telling you that that's probably the only thing that was said today that I thought was harmful.
I went through so many jobs that I get them all confused right now. This is one that hasn't been paid.
So obviously,
Last year was paid within 2 weeks of the job.
we talked about this at the time, but this is just a good reminder of when we put stuff in writing, we got to make sure that it's 100% accurate. Because that will hold it against you. If it's not.
And you know, I don't know when that document got signed. When I said that, that document may still not have been signed. He may have gone back and got that document signed. I can look it up, see when it was signed.
It's evidence is closed. There's not going to help us now. Oh, that's cute. My loves.
It's Jennifer's group message for the family.
Oh. I got a new car over the weekend.
Oh, you did, yeah. I'm not sure if you parked at the underground, but I didn't see your car
I
there.
did park at the underground. We got a Mustang Mach-E GT.
Is that the electric one?
Yeah.
Yeah, my neighbor has that. It's awesome.
So fast. Like I put the pedal halfway down on the test drive. Putting my heart through.
Yeah, I've been in that car a few times. It's nice. It's quiet as can be.
Yeah. Well, I don't know if I'll be able to go back to the office and get it charged today. I got like the 120 volt charger is the only one I have at my house. So I plugged it in all night. I got like 10% charge. I mean, I started
You
at
need to get
70.
something installed.
I do. Yeah. Well, I plan on using the one in the garage.
Or
by
go to
the office.
Walmart. The garage?
The garage by the vet
Yeah.
has chargers in there
Oh, yeah, on that first
and they're
floor.
free. No, using
Yeah.
those.
Ask him if he's not gonna sell them.
Are they outside?
I think they're down the hall.
Okay. All right, home stretch for today. Why don't you, Mr. Paskey, let me know what you think the basis is for the relief and the form that relief should take at this point in the litigation.
Yes, thank you, Your Honor. The easiest part of this in my mind is the injunction that we've requested in our motion. And simply put, the injunction is simply at the risk of boiling it down too little. It's asking all of the parties, not just Mr. Ladd, but Mr. Bicknell and Mr. Auda as well, to follow 1411-307 and not engage in self-interested transactions. Now, the court was presented with some provisions of the operating agreement that did give the managers broad power. But 14.11.307, which is the code section barring conflicting interest transactions for LLC managers or members, and a member managed, but here managers. What it deals with is it specifically says it applies unless the articles of the operating agreement expressly provide that it do not. What I don't see in the operating agreement is saying, Georgia's laws against self-interested transactions or 14.11.307 do not apply.
Right there, I have seen operating agreements that say just the nature of this is because of the people who are being brought together in this LLC, they're free to follow their own interests as well, even if those conflict with the entity of which they are a member. And it may be that Mr. Jackson can point me to that type of language in this operating agreement. It doesn't seem to be that explicit. I don't know that I've seen one where it says, and by the way, you can abrogate 14.11.307. That may be there as well. That would be the smartest if you really want to give your client, I don't know that a lot of lawyers were involved in putting together this operating agreement, but if you wanted to give your client protection from the type of relief you're seeking.
And that does exist in the kind of context that you're talking about, where it's just openly acknowledged that the managers are going to be competing. I have seen that language.
It's an open relationship.
Right. So what we're asking here is really not too much. What we're asking for is an order from the court saying, don't contract with the company unless you get the other members' approval. Because what we have here is, I suspect the argument is going to be, these were entirely fair. Right. Well, that's obviously not everybody doesn't agree on that, or we wouldn't be complaining about it. And to show that it's entirely fair is a pretty difficult thing to do, especially when you're openly acknowledging you're taking a 50% discount on equipment rentals. Sure. Does the company provide discounts to customers from time to time, a 25%? Maybe. Depends on the context. The context here is that House of Music Production might be doing this event in full if EMI wasn't able to rent the equipment from them. So giving them a 50% discount on top of it is not entirely fair. So what we're asking for is an order just saying that to the extent that you're going to contract with the company and enter into a self-interested transaction, get the approval of the non-interested members. So that's first and foremost. And then secondly, we've also asked for an order enjoining the parties from soliciting, invoicing, or otherwise contacting customers of the company. Now, this one might be a little bit further of a stretch, but we have a gentleman here who contends that he's the sole manager of the company and he's not acting in the company's best interest anytime a customer or a potential customer calls him and he's moving that over to his private company. So we're asking for an injunction against those two things. We've asked in our motion for the appointment of a receiver, and as clarified at the beginning of this hearing, we really only feel like that receiver is appropriate, or a special master, as the court pointed out, is really only appropriate in the limited context that the court finds that we have two managers and they're deadlocked. They can't break the deadlock. And the purpose of that receiver or special master would be to break the deadlock in instances where there is a legitimate business deadlock, but more importantly, to get control of the bank from my client, to get control of the email accounts. So all the control is in one place, and then the company can effectively operate. Now, I would tender to the court that the evidence today showed that that's not necessary, because what happened is Mr. Auda stopped coming into work. Both principals were contractors of the company. They're paid by their time. He said, I'm not doing it anymore. And in fact, he didn't go into the office after that, but neither has Mr. Ladd. He hasn't gone into the office. He's not saying I resigned. So really what he did was just say, I'm not working for the company anymore. And he's still a manager. And secondly, with regard to the transfer of a membership interest to Mr. Bicknell, could the documents have been cleaner? Absolutely. Like, we could have made this a lot easier by using the actual words from the operating agreement in the transfers. What is clear to me, and I think what everybody agrees on, is that True Production purchase price was discounted in exchange for a 10% ownership interest. Whether that is a voting interest or not is the dispute. But I would expect just where there's ambiguity in a contract, I think what we do is we try to use common sense, right? And if I was being granted an ownership interest in a company, I think the assumption would be it's the same interest that the guy that's given it to me has, right? So Mr. Auda and Mr. Ladd have voting rights, 50-50, and they give 5%. So why would that 10% not be voting? And if it wasn't going to be voting, wouldn't you expect an email or a document to confirm that fact? I certainly would. Now, again, I wish the documents were cleaner. I think now I'm confusing all the names. Mr. Bicknell has done everything the company has asked him to do to get the ownership interest. I think the fact that there was a meeting of the members and Mr. Ladd didn't attend the meeting and voice his objection and get it on the minutes. He had an attorney present with him and they decided not to go into that room and say, I object to his right to vote. And that fact to me is evidence that at least as of that time, even Mr. Ladd agreed that Mr. Bicknell could vote. The vote that they took is proper. Right now, Mr. Ladd and Mr. Auda and Mr. Bicknell are the managers. And to the extent that the plaintiff seeks an injunction, which is really almost a summary judgment type of fine for us on the merits of this case, to the extent that we need an interlocutory injunction, it should be to preserve the status quo that Mr. Auda and Mr. Bicknell are running this company. And to help make that happen in the most effective way possible, we would also ask that the order include a directive to Mr. Ladd to make sure that he turns over access to all the accounts so that they can effectively do that.
When you say access to accounts, tell me what you mean, because what I took from most of the evidence on that topic, it's Mr. Auda who has control over the accounts.
Most of them, Your Honor, I will grant you, but there are several, the phones, the emails.
Okay, not financial accounts,
Not
but business service accounts.
And Bill.com are the three that stand out to me
Okay.
as those that the Mr. Ladd retains control over. But yeah, I mean, that would be necessary if the court finds that I want to preserve the status quo, but I don't really want to appoint a receiver or special master because the company has limited resources. I think it would be important to have an aspect of the order that is, hey, whoever's in charge, the other person's got to cooperate with that, has to give them the control of the company. And obviously if the court finds that, there's a substantial probability that the plaintiff is going to meet his burden that Mr. Auda resigned from his manager position and that Mr. Ladd doesn't have a voting interest, then, we would appreciate the clarity from the court, to be honest. I mean, I don't think the court should find that way. I don't think the evidence supports it. But, and then to the extent that the court has legal concerns or legal questions, obviously I've pointed out that there's clear case law that Mr. Bicknell's default cannot be held against my client. I'm happy to provide a brief to the court on that issue and maybe a couple other minor legal issues, but the legal arguments presented in plaintiff's brief, which we haven't responded to yet, aren't novel. The court's familiar with them and understands them. It's really an application of facts, which I think the court heard the best that we're capable of presenting today. So that would be my position.
So I haven't run into a situation of a third party to the dispute defaulting partially. What you're saying is, well, it happens all the time, but not in this context where that default is plaintiff is trying to use co-defendant's default in a way that gives plaintiff an advantage over the non-defaulting co-defendant. And you're saying that the case law is pretty clear that it could be curtains for Bicknell if he had a counterclaim or anything here. And he seems to just be steering clear of this because it's expensive and it's not particularly friendly. And it sounds like he just wants to keep doing the work that he does. I'm projecting onto them as opposed to them not just wanting to spend time with me. But you're saying that default could be bad news for Bicknell, but it certainly doesn't constitute any admissions by Mr. Auda. I get that. But Bicknell now legally admitting, and I haven't lined up all of the accusations and allegations and what the answer said, but assume for a moment that effectively Mr. Bicknell's answer was such that it stands admitted that he doesn't have voting rights.
It's an awkward position. So what?
How does that not mean he says, I don't have voting rights? And so we've got a plaintiff saying he didn't have voting rights. And the law of this case would be Bicknell saying, I don't have voting rights. That doesn't mean Mr. Auda has admitted that Mr. Bicknell didn't have voting rights. And he's got all the arguments you're making, but that's sort of you singing to yourself if Mr. Bicknell is now on the record, if you will, saying, I don't have voting rights. And again, I'm not saying that's the effect of the default at this point, but it's just assume so that I don't want you to have to write the brief. What is case law? What's your understanding of what case law would say if Bicknell has effectively admitted, I don't have voting rights and never did?
That Bicknell, Your Honor, I can give you a citation here. I'm pulling it up. There's Peak versus Southern Guarantee Insurance, 240 Georgia 498. That's a Supreme Court case. And essentially the idea, and there's two of them I have, and I don't want to tell you it's exactly this one, but the idea is that imagine two people are alleged to have committed a tort together, right? And one of them defaults. The fact that the person that's defaulted has now legally admitted that they committed this tort with you, there's probably a paragraph in that complaint, right, that says together they did this.
Right.
That doesn't mean that the other plaintiff is admitting he did it, nor that he's admitting the other person did it. And the key, the awkward part of this is that even if Lee Bicknell is saying, well, my 10% isn't moving the needle or whatever, his 10% is moving the needle for Mr. Auda here, right? So just because he's defaulted as to that, this is different than him testifying. I never intended for it to be, what he's decided to do is exactly what you said. He's decided not to answer. And that's a problem that he'll have to face if he were to ever take an action inconsistent with that. But to hold that against Mr. Auda because his 10%, the 10% member decided not to respond to a lawsuit is inequitable. And so the black letter law is a judgment not binding on just as a judgment not binding on persons who are neither parties nor privies to it, so a default judgment is not binding on co-defendants who are not in default. So where he's not in default, his co-defendant's default isn't binding on him. Now I understand there's some factual weight to the fact that he's decided to default, and the court is obviously going to consider that. But I would just note that default isn't a matter of law, that's considered fact, that he doesn't have a voting interest.
What do you think the law would be on the following scenario? It's murky, things stay murky. I enter an order that sort of maintains whatever the heck the status quo is. Bicknell sits for a deposition and he says, no, I thought I was getting 10% voting and equity. That's what we talked about. That's what we meant. But he's also defaulted on that.
I'm definitely using that testimony, Your Honor. I'll tell you that.
That wasn't my question, though.
So my position on that this is exactly kind of the way that I don't think the interlocutory, that would be weight on the final judgment, right? The interlocutory is the court's going to do the best that it can with the evidence that's in front of it to help the parties, to be honest. I don't think that later testimony, in fact, I'm predicting that later testimony might come out. I don't think that the court doesn't have that in front of it right now, but he's not going to be able to get out of his default, but my client's surely going to be entitled to use that evidence.
Okay. So the relief you're seeking based on what we've heard today, get everyone to follow 1411-307. No one solicits House of Music production customers other than to say, do more business with House of Music production. And Mr. Ladd needs to either relinquish control of phone, email, bill.com, whatever accounts you think he has control over, or would it be sufficient to say, however you're getting in there, you need to let other people know how to get in there so that there's at least joint access, so that if Mr. Auda or administrative person X needs to pay something through bill.com, that person can do it and doesn't need to say, I'd love to, but only Mr. Ladd can do that.
That would work.
Okay. All right. Anything else at this point?
Try and make sure I didn't leave anything out.
How about this? You can keep thinking. You'll get final word anyway, because you're the primary movement here.
Okay.
So Mr. Jackson, I know that there's a lot that needs to be worked through in the larger context of this litigation. You're the plaintiff. So you sort of set the scope of the waterfront that we'll be looking at, and there may be counterclaims, but right now it's the narrower question of what's the short-term temporary relief that would be provided by my granting wholly or in part what defendant Auda is seeking, along with what your client is seeking. So what would you add or subtract from that list of three that Mr. Paskey described?
Yes, Your Honor. So I'll start by saying, with regards to the effect of Mr. Bicknell's default and Mr. Auda's things, we believe there's probably a standing issue with Mr. Auda saying, well, Lee still has voting rights, even though he didn't contest it, but that's Lee's battle to fight, not Mr. Auda's. While, you know, it may affect Mr. Auda down the road, we do believe, and this is probably something we need to get in the nitty-gritty briefing on, there's probably a standing issue. You know, going off that, to ask all parties to refrain from violating OCGA 1411-307, our side hasn't violated that. And the contract specifically states that they're allowed to do it. I'll point you to section 7.6, which specifically says it's not in the broad context, but it does specifically say for member voting, that code section does not apply. Members are entirely allowed to vote self-interestedly.
So they can vote self-interestedly, but what about sua sponte or whatever it would be, sort of ultra vires? Like, if in theory, Mr. Auda and Mr. Ladd were still co-managers because it wasn't a resignation, it was more of a, I'm going to work from home and not come into the office because it's not a friendly place. It doesn't sound like a friendly place. Everyone wants to not be there because of aggression. I feel bad for, maybe everyone who works there now is relieved because Auda and Ladd are both working from home. But that's, and you qualified it. You said, well, it's in the context of voting and you're free to vote in a way that might not align with 1411-307. But what Mr. Paskey has highlighted would be not voting, but actual actions taken. How do you respond to that? Is there something in the operating agreement that says not only is it okay to vote this way, but you can go ahead and do it. You don't need to get a majority vote to make something like that happen?
Yes, Your Honor. There are two sections. One, I can get a one-page supplemental brief because I had to look in the operating agreement for where it is, but it has to do with manager transactions. So it's going to be somewhere in section 5 of the operating agreement. But so if you take section 5.3, the certain powers of the managers, read that in connection with 15.18, which is anything not specifically addressed up here is left to the sole discretion of the managers, which it does not leave any ambiguity. What if it's history says any and all? Finally, in 5, I don't remember the exact one. I think it's limitation of liability for managers, which may be 5.8. It states that, you know, manager only liable for breach of the operating agreement. The operating agreement basically lets managers do whatever they want. With that being said, every single transaction complained of, there was a good faith basis why it was done. It was done in the best interest of the company. So there has been no breach of that duty in the first place with which to require a injunction and joining, you know, our client from doing anything. Further going off of that, given, you know, the disputes with the removal of company gear, the cancellations of reservations, which have been discussed at length in our briefs and the accompanying affidavits, there's an unclean hands argument that they're not entitled to equitable relief in the first place. Going further off that, they have damages at law. They have monetary damages, where in our case, the injunction we're asking for, as pled for in our motion, there is case law exactly on point. That's Scherer v. Hale. That's 248 GA 793. We cited in our motion for injunction. It is almost specifically on point with this. where the court finds there is equitable relief when a person is removed from their position as officer of the company. That is not a damage at law. There's no adequate remedy at law. That is pure equitable territory. You know, to the extent they're saying phone lines, the phone lines have existed since 2002 when it was House of Music Entertainment. The testimony today showed that. It was uncontroverted. This is not a new issue. It has only been an issue since all this stuff has gotten ruffled up since the purported resignation of Mr. Auda. Further, you know, they're saying there's an ambiguity that can get resolved, but I don't think they realize their resolution makes mathematical nonsense. So if you look at the operating agreement, it says a person's ownership percentage when they're a member is based on their capital contribution divided by the aggregate. So they are saying that they transferred 5% each, including their prior made capital contribution, that would give Mr. Bicknell a 10% ownership interest. And they are also arguing that he also made a $40,000 capital contribution, which did not comply with the procedure for capital contribution, the operating agreement at all. However, if he did that, that would give Mr. Bicknell 101% voting power in the company, 90.6 roughly from the $40,000 capital contribution, and then the 10, making more than 100%. It doesn't make any mathematical sense.
But we're focused on legal sense here. I know you're a pure mathematics graduate, but we're in the realm of law right now.
Sorry, I wasn't expecting you to know that. And so there's these status quo questions where they're saying Bicknell and Auda running the company status quo. If that was the status quo, we didn't have a lawsuit in the first place. The fact that that's not the status quo is why we have the lawsuit. You know, the weight of the evidence before the court shows Mario resigned. I think it also shows Mario regrets that resignation, but the fact of the matter is he still resigned. Now they might try to look to our client. Well, you have been well, the operating requirement requires written resignation. And so besides the, purported removal in the member meeting, there's been no written resignation of Mr. Ladd as manager. And so to preserve the status quo, they had testimony today. It was really questionable whether they complied with all 12.2 of the operating agreement regarding the transfer of membership, if that was even found what was to be transferred. But the status quo until, they can concrete show that Lee had voting power is Mr. Ladd being the sole manager. This really kind of feels like a case where, Mr. Auda said, I quit, I'm taking my ball and going home. Saw all the other kids still having fun, wanted to come back in and claw his way back. I get it, regret stinks, but regret doesn't undo it. Might be just about done. Going off the testimony, there were, arguable misrepresentations in the affidavit, bringing credibility of Mr. Auda, especially in the context where he's saying he's having conversations with Grady, but then he never had it. And he's using that as his basis to kind of fire all these shots at Mr. Ladd. Fact of the matter, it's all whole cloth. There's no basis for any of these wrongdoings. It's all, well, I just had a feeling he was doing that. Can you support it with anything? No, none of these would go to Miss. Let me reword this. So in the relief that we're looking for, there is no risk of self-interested transactions with EMI. There is no risk of involvement with EMI at all in house music production if Mr. Ladd is the sole manager of house and music productions. EMI doesn't have to be involved anymore because Mr. Ladd doesn't have to rely on the bank accounts, credit card accounts, company connections of EMI to perform house and music productions contracts if he's in possession of them and has access to the house and music productions resources. This kind of ties in with the unclean hands argument. The only reason that came up in the first place was because Mr. Auda removed his access to those bank accounts and funds, rendering it entirely impossible to perform on these contracts without the intervention of EMI, of which, as discussed in the brief, one of them, EMI took a substantial financial loss to protect house and music productions. And then finally, with regards to the receiver, we would object to that because we believe Mr. Ladd Mr. Auda does not have a right to possess the company. In our brief, there's case law directly on point on that. And further, there is no, we believe, obviously that's why we have a lawsuit, there is no dispute as to who the sole manager is. It's Mr. Ladd. To the extent the court wants to appoint a receiver, we do believe it would be helpful if a receiver was appointed for the sole and exclusive purpose of valuing the company to, potentially reach a buyout and settlement agreement between the parties.
Okay. My original question was, what form of relief are you seeking in light of what we've heard today? And it may have gone exactly as planned and all the evidence was exactly what you thought would come in, but that's rarely how hearings that last this long go. So in light of the evidence that you've heard today, what do you think my order ought to say? You've told me what it shouldn't say, but that leaves a blank piece of paper. So what is the form of relief you think is justified by the record that was made today?
We believe a denial of their injunction request on, there's no basis, there's been no prior violation of any statute or operating agreement, thus it's not warranted. There's an unclean hand argument, they're not even entitled to equitable relief in the first place.
I heard all that. My question is, if the order was going to do something affirmative, not deny things, but say, here is some relief that's being granted, what is it that should be in there that would address the concerns that your client has?
The denial of opposing parties' injunction request, the grant of our injunction request, we would request a denial of the receiver, but if the court saw that one was fit for the exclusive purpose of creating a valuation of the company while Mr. Ladd operated as sole manager pending the final resolution of this case, so that a settlement or buyout agreement has a better chance of being reached.
Okay, so what is the equitable relief that you are seeking?
We are asking for Mr. Auda, and to the extent that Mr. Bicknell has any of it, transfer all managerial accounts over to Mr. Ladd. We would consent to them having view-only access to the bank accounts, so there was no worry about, Mr. Ladd wasting funds or wasting assets or any of that, but have all those accounts come back in to Mr. Ladd's possession, and a ruling that pending the final outcome of this case, Mr. Ladd is a day-to-day manager and decision maker of the company. And a temporary injunction pending this, that Mr. Bicknell can't vote pending the final outcome of this case.
So number one, transfer managerial accounts, and you'd be able to help me flesh that out if I'm granting that relief to Mr. Ladd. It doesn't sound like that would be phone, email, or bill.com. It sounds like it would be financial accounts primarily.
Yes, Your Honor.
Okay. You're not suggesting that Mr. Auda and maybe Mr. Bicknell couldn't have access, but it should be view-only access, so they can say, hey, the balance is X, but they can't say, and by the way, transfer $10,000 to my Cayman Islands Auda retirement fund account.
Yes, Your Honor, if they saw that, they could readily motion for contempt against us, which would not be a good situation for us, so that's kind of the checks and balances there.
I don't know what the contempt would be, though, given your argument that 1411-307 doesn't apply in this LLC. Two, make plain in the order that the day-to-day manager of House of Music Productions is Mr. Ladd.
Yes, as managed or is referred to in the operating.
Yeah. And then three, should there be another meeting called and should Mr. Bicknell show up, he can watch, but he can't vote.
Correct, Your Honor.
Okay, I think I understand that. All right, Mr. Paskey, I said you'd get the final word because you're the primary movement here. And I forgot to ask this. It's what I meant to ask at the very beginning. You've addressed it some, but now that we've heard more, tell me what irreparable harm befalls your client if you do not get the rather modest equitable relief you're seeking here.
Yes, Your Honor. As I referenced at the beginning of the hearing, the risk isn't just the lost money from these accounts. It's the relationships. And you've heard actually Mr. Ladd testify about, these are my clients versus these are your clients. And so to the extent that,
And Mr. Bicknell's clients.
and Mr. Bicknell's clients, and that these relationships in this business are everything, and that to take, once they've moved over to a competitor, the chances of them coming back is not great, right? Once you've harmed that relationship. So the idea is to have all of the House of Music production customers continue to see House of Music production invoices and contracts, and they continue to see House of Music production as their vendor and not EMI. Because even if we got all that money back from those accounts and then the companies went their separate ways, House of Music Productions isn't guaranteed to get those accounts back.
Right, although I guess it depends what separate ways means. If separate ways means Mr. Ladd buys out Mr. Auda, then it's not an issue for Mr. Auda, because House of Music Productions would be Mr. Ladd's to do with as he sees fit, folds it into EMI, vice versa.
And not to dive into settlements, but we've heard testimony that there was a buyout solicited, and here we are a year later, and there's been no term sheet presented. There's been none of that. So that to rely for Mr. Auda to sit on his hands and rely on that to come, it's probably a dangerous move from him from a business perspective.
Why is the loss of a business relationship not amenable to assignment of a financial value?
Well, we always talk about when we get to a final hearing on these, what's speculative, what damage is speculative. And you heard Mr. Auda testify about how certain clients bring in other clients, right? And so it's difficult to reduce to paper, right? So it would be impossible to prove at every opportunity what the dollar figure of that was, on top of the reputation of the company, right?
So you do a good job at a particular master's party, and that's got to be as good as the next neighbor. Hey, you guys had the best lighting. Who'd you use? Well, we used House of Music Productions last year, but this year it was EMI, and it was great. And then that's the name that gets spread down the fancy street in Augusta, where they have these giant parties during the Masters.
Well, you certainly have that grassroots type of, but you also have we talked about the Endeavor House. That same project is now a different person. People move around in the industry. So your contact at the top of X company moves to a different company, and now you're in with that company. All those relationships matter, and it's very difficult to distill to a dollar figure. So that would be our position as to why. And again, I think I'm glad the court appreciates it. What the equitable relief we're requesting is very modest. It's not going to impose any unreasonable and strict restrictions on Mr. Ladd, but it is to prevent that unknown, that what could have come of those relationships.
Okay.
I would, Your Honor, you asked, you told me I'd have a little bit of time to come up. One more aspect to our order we would request is that equipment and inventory not be removed by any party from the House of Music Productions warehouse.
Without,
for a non-job purpose, right? Like you heard Mr. Ladd testify about how he couldn't tell us easily what is House of Music production equipment and what is EMI equipment. And the concern would be that if the court ruled in our favor, he'd, to use opposing counsel's analogy, he'd take his toys and go home, kind of thing. And without a clear inventory of what is his and what is ours, I think the standing assumption should be that if it's in the House of Music Productions warehouse, it's House of Music Productions asset.
I mean, it is for now. It could be if there is a dissolution, then
Sure.
Mr. Ladd would need to do what he said he could do, which is I could get invoices and purchase orders to show this was EMI stuff, and the other either was jointly acquired or was brought in through House of Music Entertainment. Okay. Well, it's been a great, did you have more?
No, that's absolutely it.
It's been a great day to spend together. You all need to settle with the court reporter. She's going to have a sore jaw. But I appreciate all this. If I have any questions about anything, Ms. Niles will shoot you both an email. It may be a question just for Mr. Jackson, but if I want to get a one-page brief from him, I'll always give the other side a chance to weigh in as well. And I know that time is of the essence because the outlook for the company is not getting clearer while this cloud hangs over it. So I will try to jump on it. Mr. Jackson, anything else procedurally, we're done with substance for today.
Not procedurally, Your Honor, might want to make a few statements about what they said, but
Yeah, but we'd be here all night then.
yeah, so,
'Cause
nothing procedurally right now.
Okay, good. Well, thank you all for your day and we'll be in touch.
Your Honor, one more thing. We got emailed about a conference for a scheduling order and we discussed maybe we did postpone that until after this hearing. But I just did want to put it on the court's radar that we had postponed that and hadn't done that scheduling order conference yet.
Right, no, it did get postponed. Ms. Niles and I talked about that and I envision that whatever order I enter, whether it's denies everyone a pox on all your houses or it grants some relief in whatever way, it will say, and let's get some discovery pretty quickly on these declaratory judgment pieces, because as you've both acknowledged, if there is a final ruling entered that says Bicknell had a vote, that solves some of this. I mean, there'll be an appeal of that perhaps, but until the declaratory judgment is entered in a couple of those spaces, there are competing claims to the throne. And I would think you all would want to resolve that soon. Some answer would obviate the need for some of the relief. I mean, it's what Mr. Paskey said at the outset. Look, if you decide that Bicknell didn't have a vote and Auda resigned, then we know who the manager, I mean, it's what you're advocating for. If I don't decide that, then it still needs to, if I don't decide it in the context of this temporary equitable relief is still swirling around out there. So my thought was that the order would say, and here's a real short window to do discovery, at least on these threshold questions. But if I'm not quite sure how to structure that part, that would be an example of where we'll reach out to both sides saying, hey, there's an order coming and it's going to have some scheduling information in it. What do you think about X or Y? Okay, so we have not forgotten about, there's more. It'd be nice if this ended it all, but there's more to this case than me just getting you in order. Okay,
Thank you, Your Honor.
thanks.
Nice job. Well done.